ಅದು ಕೇಳಿ ಹೇಳಿ ಗೊತ್ತು ಸರ್ 2024 ಅಲ್ವಾ ಆಯ್ತು ಸರ್ ಆಯ್ತು ಯಾವುದು ಇರ್ಲಿ ಬಿಡು ಬರ್ಲಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ಬರುತ್ತೆ
Judicial.
ನಾಡಿದ್ದು ಬರುತ್ತೆ ನಾಳೆ ನಾಡಿದ್ದು 2 days 1 ದಿವಸ ಟೈಮ್ ಬೇಕು ಅವ್ರು ನಿಮಗೆ ನಾಡಿದ್ದು ನಾಳೆ ಇಲ್ಲ ನಾಡಿದ್ದು ನಾಳೆಗಂದ್ರೆ ಅರ್ಜೆಂಟ್ ಇದೆ ನಾಡಿದ್ದಾದ್ರೆ ಕೊಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ 2025 ಮ್ಯಾಟ್ರೆ ಸ್ವಲ್ಪ ಕೇಳಬೇಕು ಮೆನ್ಷನ್ ಮಾಡಿ ಕೇಳಿ ಬರುತ್ತೆ ಅದು ಸತೀಶ್ ಅದು ಫ್ಯಾನ್ ಆಗಿ ಆಫ್ ಆಗ್ಬೋದು ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಆಫ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಿಲ್ಲಿ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಆಫ್ ಕಳಿಸ್ತೀನಿ ಕೊಡಿ ಡೇಟ್ ಬರುತ್ತೆ ಕಳಿಸಿ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅವ್ರು ಬರೀತಾರೆ ಅವ್ರು ಬರ್ದು ಕಳಿಸಿ ಶಾರ್ಟ್ ಅಂದ್ರೆ ಲಾಂಗ್ ಅಂದ್ರೆ ನಮ್ಮ ಕೈಲಿದೆ ಶಾರ್ಟ್ ಅಂದ್ರೆ ಅವ್ರು ಲಾಂಗ್ ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ ನಾಡಿದ್ದು ಮೇಲೆ ಸ್ಕೂಟಿನಿ ಅಂತ ಬರ್ತಿರೋದು ಜಾಸ್ತಿ ಇದೆ ಎಲ್ಲ ಬೋರ್ಡ್ ಬ್ರಾಂಚರ್ಸ್ ಫುಲ್ ಜಾಸ್ತಿ ಇದೆ ಅಂತ ಎಲ್ಲ ಆಗ್ತದೆ ಅಂತ ಸರ್ ಹೇಳಿ ಸರ್
On matter for hearing on IAM or vacating on IAM.
40.
Tomorrow, my lord. The reason is that
Date will be fixed by the court
petitioners,
officer.
my lord, having
There must be place in the cause list. I am putting 100 matters, more than 60 it's not possible. So we'll give you a date.
Without making me party, he has obtained the stay. No?
We'll see, let us.
Short date.
Fresh matter. Kodi. But government you have to inform.
Sir.
Right, Kodi.
My lords.
Government, please wait, madam. I'm not running away. Give.
My lords, the matter was advanced on Friday for it to be listed yesterday, and the bench had directed for it to be specifically listed yesterday. However, due to paucity of time, the matter never reached.
Give a memo.
Advance the matter for it to be posted tomorrow. Read petition number 1808 of.
That if you tell like that, I won't remember. The court officer won't remember. You must give the memo only after.
My lords.
This is response number 4, my lord. To vacate the stay.
Kodi.
Any day next week.
My lords, it's a fresh matter.
Kodi.
My lords, it's a fresh matter.
ನಾಡಿ
My lords, it's a fresh matter wherein the
Write
assistant.
fresh matter on top and give it. It'll come immediately.
My lords,
All
it is-
fresh matters, you please write on top fresh matter and give the memos. Adhe
My lords,
check matter.
matter. We are for the respondent, the petitioner.
I heard you, madam. I heard you.
Please.
It will come.
Due to urgency,
I heard you and told the court officer it will come tomorrow.
tomorrow, please.
Just wait. Just
My lord,
wait.
my lord, I filed early hearing application.
Give
More
it.
than 2 weeks is over, my lord. Till today, not. And writ of mandamus, my lord. Kindly.
Write on top Mandamus and give. I'll take it out of turn. Write on top Mandamus and give. All Mandamus matters you write on top Mandamus and give it. It will come out of turn. Preliminary hearing. Manjuna. Yeah, Mandamus is preliminary hearing. What is the urgency?
Survey tomorrow, my lord.
Notice is issued just 3 days, my lord. On Friday, they issue notice stating surveys to be conducted on Wednesday.
Give it, given a extra copy to the government now itself.
Right.
Yes, my lord.
Well, in this case, LR application have failed, my lord. Its parties have been served.
Give it.
Well, 2 times I have moved, my lord, not yet, my lord. Tomorrow I will.
Not tomorrow, it will come.
Yes.
Give it. Date.
Lord, moving a matter for end of list, my lord. Lord, matter pertains to payment of compensation in an acquisition matter. A fraudster on the basis of an unregistered, forced unregistered GPA
How
executes.
is it coming before this court?
Please, my lord. A fraudster without a proper GPA goes before a non-jurisdictional sub-registrar, executes a sale deed in his favor, goes directly before the AC, there without there being a mutation entry or an order of Tashildar. AC also orders for mutation, my lord.
Give it, 230.
Please, my lord.
You give an extra copy to the
I will,
government.
my lord. I will, sir, now.
Vacating stay.
Could he?
There is a suit has been filed for wider relief. Revenue authorities also notified it. Despite they have obtained an order of status quo before this order.
Could he? Could he?
May be posted tomorrow or any day.
Not tomorrow, date ಕೊಡ್ತಾರೆ.
Adjournments?
We are the plaintiffs, my lord. We are engaging the senior counsel.
That you wait,
Adjournments?
just wait.
My lord, matter pertaining to Patana Panchayat election, Town Panchayat election. my
Give
lord.
it, give it.
Hearing on IA, kindly have it on day after tomorrow, my lord.
Some matters are available. Now, new matters you have to move before that bench.
No, my lord, it is a pending matter. It
No,
is
no, only if it is before me in that
it's
batch. which is
before
coming.
you, this court only, my lordship, because it is not dealing last. Day after. Kindly have it on day after tomorrow, my lordship.
No, no, whenever that date we have given, I'm not taking it out of turn. I've given
Because
a date.
hearing on IA, an administrator was appointed, my lord.
Correct. I've refused to take it out of turn and given a date. You have to wait till that date. I've given a date, you find out which date it is.
Adjournments, list 1, page number 1, 1 to 6, page number 2, 7 to 15, page number 3, serial number 16 to 23, page number 4, 24 to 29, page number 5, 30 to 34, page number 6, 35 to 41, page number 7, 42 to 51, page number 8, 52 to 60, page number 9, 61 and 62, page number 10, 63 to 67, page number 11, 68, page number 14, 69, page number 15, 70 to 73, page number 16, 74 and 75, page number 17, 76 to 79, page number 18, 80 to 82, page number 19, 83 to 85, page number 20, 86 to 87, 83,
Huh?
230.
At 2:30 you make a mention. At 2:30 you make a mention. At note ಮಾಡ್ತೆ. ಅದು ಕೊನೆಯಲ್ಲಾದ್ರೂ reach ಆಗದಿದ್ರೆ ಅದಕ್ಕೆ.
Page number 20, 86 and 87, page number 21, 88, list number 2, non-compliance office objections, first time, serial number 1 and 2,
Week's time granted for necessary compliance. If office objections are complied, list the matter in fresh matters list.
second time, serial number 3,
Same order,
third time, serial number 4 to 6,
same order,
fourth time, serial number 7 to 14,
same order, same order.
My lord, serial number 8, my lord.
Yes,
My lord, I have filed the NOC Wakalat, my lord, Harsha Kumar Gowda. My Wakalat may be,
Fresh matter.
the week's time may be granted.
office to show the name of learned counsel so and so. Stated to have filed wakalat.
On 24/10, my lord.
Same order. Yes.
fifth time,
5 and 6, my lord. Interim order may be
5 and
6. 5 and 6.
5 and 6. Check my interim order in operation is extended till the next day. It had come before the court.
Please.
And then you comply with those office
I will.
objections.
fifth time, serial number 15 to 25,
Weeks time granted finally, same order.
sixth time, 26 to 28,
Same order.
seventh time,
Passover.
list 3, page number 1, serial number 1, page number 3, serial number 2 to 7, page number 4, 8 to 12, 10, serial number 10,
My lord, we are for blind issue. We are appointing senior counsel.
Now inform the other side.
Yes.
At request, list week after next.
Page number 5, 13 to 18. Page
Serial number 18, my lords.
18.
I'm for petitioner, my lords. I have intimated to my learned counsel for respondent, my lords. My lords, a date shall be fixed, my lords.
List week after next.
Page number 6, 19 to 25.
Serial number 22, Your Lordship.
Yes.
2 weeks of time may be granted and senior counsel undergone surgery.
At request, list after 2 weeks.
Page number 7, 26 to 31. Page number 8, 32 to 38. Page number
Number 34, Sir Lordship.
34.
You have engaged the senior counsel, Lordship. Kindly 2 weeks of time may be granted.
Have you informed the other side?
Kindly.
Have you informed the other side?
No, not yet.
Inform and report to the court officer. You get the signature on the memo and give it to the court officer. Otherwise, when it reaches, I'll accommodate.
2 weeks of time. I will inform you.
Inform, get the signature on the memo and give it to the court officer. Otherwise, when it comes, I will adjourn the matter.
Page number 9, 39 to 45.
Serial number 41, my lord. This is cancel settlement, my lord. We inform other side counsel.
Yes, ma'am.
At request, list week
On
after
next.
next.
Interim order.
Interim order and operation extended till the next date.
Page number 10, 46 to 50. Page number 11, 51 to 55.
List of dates, madam.
Fresh matter.
Yes.
I made 2 components. One with respect to your very active. Second component is specifically the petitioner. Both the components, given the copy of
Yes. Now the last date is,
10/10.
huh?
10/10 was the last date of settlement.
No, no,
Demanded 45.
20, 45 days from,
Complete on 28th of November. This Friday. 29th.
now what happens if charge sheet is filed? They won't file, that's a, I don't know. I don't know. I
Again,
don't.
they are sought for extension.
Huh?
So again, they have sought for extension. That application is now set up for hearing today.
No, if your lordship.
No, I'm just asking, let's assume that you file a charge sheet by 29th. Then this becomes,
Accrued melodies is entitled to some amount.
so it will not affect.
It will not.
So in case we were to find that there is some flaw, let's assume, so that irrespective of that, the right still remains. But I'll try to do it as fast as possible.
My lord, I have a small suggestion.
Give it, you're late. Yes, give it.
No, my lord, the respondent has been died. One of the respondent has been died in December
You
24.
give the memo, madam. Mentioning time is over. It will come.
Item number 49.
Huh.
And the respondent, please take.
Inform the other side and report to the court officer. List week after next, after 2 weeks.
Lordship, end of,
Huh?
end of the list, there is matter
What
maybe,
is
the
that?
matter is most urgent, she's a senior citizen. So the revenue entries, the revenue authorities is changing the entry. So this is WP KLR, so this,
We'll have it tomorrow. In case only demolition, eviction, we'll take end of the list. We'll have it tomorrow. Give an advance copy to the government tomorrow.
This one fresh matter, serial number 1.
Sir.
Mahesh CM.
My lord, appearing for the petitioner. My lord, in the year
No,
1991,
correct. Now, as on date, entries are already changed.
changed, my lord.
AGA is directed to accept notice for the
230
respondents 1 and 2, emergent notice to the third respondent.
Please.
The third respondent not to create third party rights.
Please, much plus.
Yes.
Serial number 2, Harsha V.
For the petitioner, my lord. My lord, in this case, my lord.
No, just 1 minute. Now, this is only this is only an order of the assistant commissioner.
Order of the assistant commissioner, my lord.
Huh.
The thing is, my lord, in the assistant commissioner's order, he has mentioned that the names as per the partition should be maintained in the MR.
This you have to go before the DC. How
My
you
lord,
can come direct?
Even they are challenging the partition suit also, my lord.
You should go before the deputy commissioner by way of a second appeal under section 50.
The reason is that, my lord, once the AC order was passed, the next month itself, they have changed the mutation, my lord. Since
Correct. Why have you come directly to the High Court? You have to go by second appeal
Because,
under section 50.
because they're influential and they'll influence these.
That you go there. I'll keep all contentions open. You have to go before the DC under section 50. Under section 50, you have to go before the DC.
List number 2, serial number 25 also same matter.
They are noted. The petitioner has called in question the correctness of order at annexure D passed by the assistant commissioner. Full stop. AGA submits that since the order is passed under 136(2), petitioner could exhaust his right of revision under 136(3) as against the impugned order at annexure D. In light of the same, petitioner is relegated to avail of the statutory available remedy as against annexure D. All contentions are kept open. Office to return certified copies of the orders produced after retaining Xerox copy for reference.
Same family, my lord. Same family, same order. Different miscellaneous number.
Same order. Then AG accepts notice for the respondents. Yes.
Serial number 3, S. Rashekar, Ravi Shankar Shastri.
Wasn't able to get a hold of the registrar, my lord, to verify.
So I appear for
whether to be able to.
yesterday's
Could I
matter.
request for a password 230?
Password. They only wanted
that timeline.
What is the timeline?
But I have inquired, my lord, so now they are taking up the matters for final disposal. There is no.
Afternoon, I'll do it. Let him just put a word. Even if you are not there, I'll dispose.
Yes, please.
Pass it.
Here for the petitioner in this case, my lords. My lords, in this matter, the petitioner has challenged the Podi, my lords, before the DDLR in appeal number 67/21, my lords. The seventh respondent in the above petition has cancelled the Podi, which has been effected in the name of respondent number 3, my lords. Subsequently, the respondent number 3, showing the wrong address, filed a revision petition before the JDLR, my lords, and in petition 8/23 to 24, and got the order on 7/11.
AG is directed to accept notice.
Note 7, 8 and 9.
Respondent 7, 8 and
9.
No, she has renumbered it. 8, 9 and 10. In light of the contentions raised, there would be stay of the order at annexure G.
Yes, ma'am.
Now, by virtue of the order of annexure G, they have what have they done?
Nothing, my lord. They have just cancelled the Podi, which was
Annexure G. Emergent notice.
copies.
To
Third, my
the
lords.
respondents 127. 127.
Copies.
Rectified copies you must give. You must
Yes.
give copies after rectification.
Yes, my lord.
You have numbered, changed the number. In his, you have not changed his number.
Yes, we'll change it and
Next time I will vacate. I won't give interim order if you don't give proper copies to the government advocate.
yes, sorry,
Yes.
my lords. I apologize.
5, Alaswamy.
AGA accepts notice.
All
the
respondents. All respondents.
Sagoli Chitta.
Yes, my lord.
List in preliminary hearing list on.
8,
Yes.
6, Srinivas Akhiyan.
What do you want?
Take out notice. Take out notice.
Senior.
Well, I think take out notice. There are civil suits also pending. Huh?
Senior is another court, my lord. Kind of password.
It won't reach password.
7,
Form number 57 has been filed, my lords. It has been
correct,
closed
correct.
without considering it, my lords. As per annexure. Annexure G has been issued.
No, this is Tahsildar.
Please.
Yes.
State is the. Annexure G, my lords,
Yes,
page
yes.
number 43. Page 43, my lords.
So we'll see. Now the DC must, according to
State is.
108
108 triple C.
Huh?
108 triple C. One not eight triple C 3.
So we'll set
Sorry, my
it.
lord. 108 double C.
Huh? Triple C,
108.
no, triple C 3.
Triple C. Triple C.
3. Now we'll set it aside because under 108 it's the DC who has to pass an order, but this would be treated to be a report
Yes.
made to the DC.
Yes.
If you have anything, you can, I'll keep it open for you to represent to the DC.
Please.
The petitioner has called in question the validity of the order passed by the Tahsildar at Annexure G dated 20th August 2025. The application for regularization filed by the petitioner has been disposed of by the Tahsildar as application is stated to be ineligible. Full stop. Perused Rule 108 triple C of the Karnataka Land Revenue Rules. Said provision reads as hereunder. Next, it must be noticed that in terms of Rule 108 triple C, the Tahsildar on report of the officers with his findings shall forward the ineligible application to the Deputy Commissioner for further action. And it's the Deputy Commissioner who has power to reject ineligible applications. In light of the same, the order at Annexure G could not have the effect of closing consideration an ineligible application. Such decision is only to be taken by the Deputy Commissioner. Accordingly, the order at Annexure G is to be treated to be a report, that is to be forwarded by the Tahsildar to the DC. The petitioner is at liberty to represent before the Deputy Commissioner to clarify his stand if, according to the petitioner, application is not ineligible as noticed by the Tahsildar. Accordingly, the petition is disposed of. The order at Annexure G is to be treated as a report of the Tahsildar, same to be forwarded to the DC. Needless to state, before the DC were to take a decision as contemplated under 108 triple C 3, petitioner may be heard.
8, Srinivasan T.
Petitioner, madam. Petitioner is the purchaser. The petition was filed before the Assistant Commissioner after 29 years.
First sale date is 95,
and
proceedings 13-14.
24.
24. No, proceedings were initiated in
2024.
6.
And earlier, as per Annexure G, earlier the other family members had filed another petition in 2013 before the Assistant Commissioner. That petition came to be dismissed by holding that Dodmuniappa, the grandfather of the petitioner, has failed to prove that is the grantee.
This matter
That was not challenged. That has attained finality.
Matter requires consideration in light of the contention that the grantees had suffered an adverse order in the previous round of litigation.
Previously.
Accordingly, there would be stay of
Annexure A and B.
annexure A and B. AG is directed to accept notice respond 1 to 3. Emergent notice to respondents 4 to 7.
9, step of BM.
Since 35 and up to 2022, there was sub 4 numbers. And my lord, all of a sudden without notice, all this ports of survey number 7 has merged with their survey number 7. The identification itself is very difficult now.
AG is directed to accept notice for respondents 1 to 5.
Now there's an endorsement which is given at page 58.
Correct. So you find out, so you take your stand in writing.
Please.
On what basis you are saying that you can't commit, you can't do Podi?
Sale deeds are there prior to 1950.
Let us see, you take your stand in writing, please. But should you not have challenged this endorsement?
Well,
should you not have challenged this endorsement?
Yes, here this is endorsement issued with reference to the EC order, AC orders and all that you have made us to run to pillar to post. Lastly, we come before your lordship. So without notice, how can there are sale deeds are there and entries are there since 19.
Correct. What we are suggesting that no doubt you have sought for a mandamus, you can amend your prayer to challenge this endorsement. We'll ask them to take this.
Endorsement challenge madidini. Annexure AA is the endorsement.
You take your stand, let us see. Please. GA accepts notice for the respondents. Stand in writing to be taken within 2 weeks. Yes.
N, incorrections.
Addition.
Take out notice. What has happened to the RSA?
My lord, it is my lord, respect of my lord, other properties, lordship. Kindly see, my lord, in the.
Let us see. AG accepts notice for the respondents.
11.
They'll have to make the other private respondents also parties to this.
I am not a party in RSA.
You're not a party.
I am not a party. Lordship, kindly see, lordship, the page number 16, my lord, RTC, for a moment.
No, now that schedule doesn't tally with this.
Please, my lord, kindly see, my lord.
No, we are asking that the schedule in the RSA has nothing to do with.
Nothing to do with, my lord. Kindly see, my lord. For a moment, in page number 16, RTC, lordship. 16, my lord. ಅದರಲ್ಲಿ ಪಿಟಿಷನರ್ ಮಹಾದೇವಮ್ಮ ಕೋಮ್ ಉದ್ಯೋಗ ಮಾರೇಗೌಡ ಲಾರ್ಡ್ಶಿಪ್ 20 ಗುಂಟ ಅದರಲ್ಲಿ ಏನಿಲ್ಲ ಇದು ನೆಕ್ಸ್ಟ್ ಗೌರಮ್ಮ 34 ಗುಂಟಾಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಕೋರ್ಟಲ್ ಸ್ಟೇ ಇರೋದು ನಮ್ದಿಲ್ಲ ಬಟ್ ಏನಂದ್ರೆ ಸಿನ್ಸ್ ಮಲಾಡ್ ದ ಸರ್ವೆ ನಂಬರ್ ಇಸ್ ಸೇಮ್ ಲಾರ್ಡ್ಶಿಪ್ ದೆನ್ ಮಲಾಡ್ ದೇ ಆರ್ ಇಶ್ಯೂಡ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ದಟ್ ನಾವು ಮಾಡಕ್ ಬರಲ್ಲ ಸ್ಟೇ ಇದೆ ಹೈಕೋರ್ಟ್ ಸ್ಟೇ ಇದೆ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಮೈ ಪ್ರಾಪರ್ಟಿ ಮಲಾಡ್ ದೇ ಹ್ಯಾವ್ ಟು ಡನ್ ಮಲಾಡ್ ದುರಸ್ತ್ ಅಂಡ್ ಮಲಾಡ್ ಸರ್ವೆ ನಂಬರ್
EG accepts notice for the respondents. List the matter in the preliminary hearing list after 10 days.
Please, oblige.
11.
This case, my lord, petitioner's father purchased the property.
Correct. 80 at page 160.
Page 160.
Says that you have not produced the sale deed. How Subrayappa purchased the property.
Yes, ma'am.
It says
before the deputy commissioner, the document number annexure D is the, kindly see page number 112. Page number 112 is the revision petition filed before the deputy commissioner.
You have produced it.
Produced it. Kindly see page 112, para 6, my lord. It is submitted that on 11/9/1959, the said Keshavaya and sons Rama Sharma and Narayan Sharma and their minor children sold the property in question in survey number 123, measuring 2 acre 10 guntas.
Yes, take out notice. EGA.
They have executed registered sale agreement in favor of third parties. Kindly see last annexure. Page number 179. Immediately after getting the kata in their favor, they have executed the sale agreement. 179. Registered sale agreement. There is some mafia behind this property. Man. The National Highways has acquired the portion of the property and arbitration proceedings launched against me. I have received the compensation. All the document I have produced. Man. Till today I am in possession. After the lapse of 60 years, 2023, they have approached the Assistant Commissioner based on the 78 al namge re-grant agide anta. Namu notice ಕೊಟ್ಟಿಲ್ಲ. Kindly see the notice also I have produced.
EGA accepts notice for the respondents 1 to 3, emergent notice to 4 to 7. Counsel for the petitioner submits that the finding by the KAT in its order while refusing grant of interim relief sought for has observed that the sale deed in favor of Subrayappa was not produced, which is a perverse finding. Full stop. Attention is drawn to page
number 112. That is annexure WML. This is the
attention is drawn
revision
to
filed before the
attention is drawn to the objections filed by the petitioner before the deputy commissioner and in specific to paragraph
6.
Paragraph 6. No. So where is that sale deed you said you have mentioned?
It is marked as annexure D. The sale deed is produced before this honorable court also. Kindly see annexure A.
Just 1 minute. You that time you pointed out, isn't it?
Yes, madam.
Which is that document you pointed out? You have written say that you have produced the sale deed.
Page number 112, annexure 112, page number, para number 6, annexure W. Miller. Annexure W starts from 109, page number 109.
Attention is drawn to the memorandum of review petition under 136 subclause 3 of the Karnataka Land Revenue Act filed before the deputy commissioner and in specific to para
6.
Para 6, yes, wherein the sale deed stated to have been executed in favor of Subrayappa has been referred to and produced.
Annexure D.
At annexure D. Further, a copy of the sale deed is also produced in the present proceedings at
annexure A. Before the KAT also produced as annexure A.
Just 1 minute.
Page 21.
At annexure A. Accordingly, there would be accordingly, the private respondents are restrained from creating any further third-party rights.
Direct the respondent number 3 to not to give any effect for the mutation. Otherwise, they will alienate the property.
No, you have said not to create any further third-party rights.
Yesterday, day before yesterday, they have conducted the Podi. Separate number, survey number.
So what is the interim relief now?
Interim relief stay of AC and orders. Both AC and DC held in their favor. I have sought for AC DC orders, stay of AC DC orders. That is annexure Z and V.
Accordingly, subject to further consideration, there would be stay of the orders at annexure Z and
V.
And further, the private respondents are restrained from creating any further third-party rights.
Much of it.
Petitioner is at liberty to serve counsel appearing for the respondents in the proceedings before the KAT.
No, there also they have not received notice in a Sarvagilla.
I thought better.
Well, maybe should
an ex parte order he rejected.
Notice ತಗೊಂಡಿದ್ದೆ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಅಡ್ರೆಸ್ ನಾಟ್ ಫೌಂಡ್ ಅಂತ ಅವರೆಲ್ಲ ಇಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಿ ಇರೋದು ಅದು. ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ದೇ ಆರ್ ನಾಟ್ ಇನ್ ದಟ್ ವಿಲೇಜ್. ನಾನು ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೆ, ದೇ ಆರ್ ನಾಟ್ ಇನ್ ದ ಅಡ್ರೆಸ್. ನಾನು ಸೇಲ್ಡ್ ಇಡೋ ಇದರಲ್ಲಿ.
Such a detailed ex parte order.
Yes, ma'am.
One.
This court had passed an order at page 77. Page 77, the writ petition was filed against the KIDB and other persons who were private parties. But the court came to the conclusion that I have a right, kindly turn to page 81. Having heard the counsel for the parties and having perused the petition papers, this court declines indulgence in the matter, broadly agreeing with the submission made on behalf of the respondents, more particularly in the light of observations made to the trial court. Both the preliminary notification dated 29/1/2008, 28/1 of 1966 Act, final notification on 27/5/2010. Petitioner's name did not figure in the kata or in the property records. Even thereafter, at the time of passing the award, taking possession and making payment of compensation to, petitioner's name did not figure in the property records. In fact, she had filed RTS appeal 136 of 2002, 136 within bracket 2 of the Karnataka Land Revenue Act. Only in April 2014, which came to be favored by the Assistant Commissioner on 30/6/2017, on the basis of which first petitioner's name gained entry in the property records. That being the position, acquisition process could not be faltered, even at least. But there was some fraud, etc., and a civil suit was disposed of by the court. But what the KIDB does is, at Annexure A, it files a review petition and gets the order reviewed and seeks the transfer of the name in their name. The compensation is not dispensed with insofar as petitioner is concerned. Their names were appearing in the Assistant Commissioner records. But some third parties, they collect the compensation amount on the basis of the earlier order of the Assistant Commissioner and then take away the compensation.
Now what is the interim relief you are seeking?
Right, interim relief I sought for stay of Annexure A, because if the compensation amount is dispensed at this order, I may lose the right also.
No, instead of stay of Annexure A, we'll restrain them from dispersing compensation.
That's all.
In light of the contentions raised, the respondent number 3 is restrained from dispersing compensation till the next date. AG accepts notice for respondent 1 and 2, PV Chandrasekhar for 3. No, the 3?
No, 1, 2, 4.
4, my lord, and 5.
3, I'll take notice.
AGA for 1, 2 and 4.
4 and 5 also.
4 and 5. Emergent notice 6 to 8 as well as to 3.
Yes, please.
Petitioner is at liberty to serve standing counsel if any for respondent number 3.
Yes.
13. Bhaskar K.
Petitioner, my lord. Petitioner a landless.
Will say cancellation of grant.
Yes, my lord. By invoking suo motu force after lapse of nearly 6 years from the original grant, my lord. My lord, the petitioner is a landless person, my lord, who applied for grant of land under section 94A of the Act. My lord,
that has been upheld by the KAT.
Yes.
Right of contentions raised. Matter requires consideration. There will be an order directing maintenance of status quo regarding possession, while petitioners not to create any third party rights to the interregnum. AGA is directed to accept notice for respondent, all respondents. For the respondents, stand in writing to be taken within 2 weeks.
Not to create third party rights from today, my lord, if he has mortgaged already for obtaining loan, my
Third
lord.
party rights henceforth.
Please.
14. Bharat K.
And the petitioner, my lord. Without ascertaining, my lord, whether the land is government land.
No, correct. But what document you have that you have?
My lord's Annexure D.
Annexure
D. My lord's Rati Shetty is my predecessor. She is my relative. When this land was proposed to be a burial ground, that proposal was dropped, my lord. Lords, kindly look into annexure A, my lords, for a minute.
No, we are saying what is the document of title for you?
No, it's a Kumki land, my lords. My lords, it's a land,
Right
annexure
only-
B.
Correct. Kumki
Annexure
land,
B.
Right only of usage.
Correct. My lords, annexure B is the survey number 4/3. ಅದಕ್ಕೆ ಇದು ಕುಮ್ಕಿ ಲ್ಯಾಂಡ್. ನೋಡ್ಸ್ ಅಲ್ಲಿ ನಾನು ಮನೆ ಕಟ್ಕೋಬಹುದು, ಏನ್ ನಾನು ಅಗ್ರಿಕಲ್ಚರ್ ಪರ್ಪಸ್ ಏನ್ ಬೇಕಾದ್ರೂ ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳೋದು.
No, Kumki rights whether you can put up.
Yes, my lords. That is the annexure D. First 4 lines. The Tahsildar Mangalore has submitted a proposal to reserve the land in survey number 3/1 measuring so and so acres for burial ground in Kunjatalli of Mangalore Taluk. The proposed land forms Kumki Kadim land in survey number 1/1, 2/9, 2/11, 2/19, 4/1, 4/7, 4/5, 4/2, 4/3. That is our land. And 6/11. My lords, the operative portion, my lords, 24. Sorry, my lords, page number 23, last paragraph. Shri Gangadhar Maya represented that he is collecting green leaves from this land for the manure purpose. There are fruits bearing trees existing in this land. Therefore, the width of Kumki land rights to be dropped. Peruse the connected records placed before me. I have inspected the proposed site on 7/5/1997 along with other representative officials. The land is situated by the roadside of Kunjattal Road. The land contains full of rocks and slopy areas. Some unauthorized houses have come up in the proposed land. There are a number of houses around this area. The proposal, the operative portion is the proposal for the withdrawal of Kumki right so and so is hereby dropped. Next, annexure A, 39 complaint ಕೊಡ್ತಾರೆ without there is any proceedings. Straight away notice came to be issued on 6/11/2025. My lords, ಅದರಲ್ಲಿ ಹೀಗಿರುವಾಗ ಸನತ್ ಶೆಟ್ಟಿ ಎಂಬುವರ ಸಂಬಂಧಿಕರೊಬ್ಬರು ಸದರಿ ಸ್ಥಳವನ್ನು ಆಕ್ರಮಿಸಿ ಆ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಇವರು ಹೇಳೋದು, ಈ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ ಕುಂಜತಬೈಲ್ ಗ್ರಾಮದ ಅತ್ರಬೈಲ್ ರಸ್ತೆ ಬಳಿ ಸರ್ವೆ ನಂಬರ್ 3ರಲ್ಲಿ ಸರ್ಕಾರಿ ಜಮೀನು ಒತ್ತುವರಿ ಮಾಡಿರೋದರಿಂದ without ascertaining any procedure, without issuing notice to me.
Relist the matter. Relist the matter. We'll have it tomorrow. Day after tomorrow in the same stage. Give one copy.
One copy. Monday, my lords, let there not be any precipitative action, my lord.
Monday, orally you inform them not to take anything till Monday.
Let there be order, my lord. Iland or idmadadilla.
Let us see. We are here. We'll see if anything. Monday.
112. 15 peanut.
Yes.
The second respondent, my lord, set aside the Durast work on the ground that, my lord, without issuing any notice to the petitioners, my lord, the third respondent carried out the Durast work. Your lordship may kindly see at page 38.
No, now the final order is?
Lord, this order was the second respondent has remanded the matter back to the third respondent to carry out the Durast work after giving notice to the parties. The first respondent has set aside the order on the ground that civil suit is pending.
On the ground?
Civil suit is pending.
No, they were only directed continuance of the earlier records.
Yes, my lord.
Earlier Podi.
Yes, sir.
You take out notice. We'll see.
I will take out notice, my lord. To the respondent number 1 to form government, my lord.
AG accepts notice for response 1 to 4. Emergent notice to
respondent number 5.
16 Narsimurtial.
Hearing for petitioner, my lord, sought for writ of mandamus to consider the representation dated 14/10/2025.
AG accepts notice for the respondents. List the matter in the preliminary hearing list on. Now you may have to record it as a disputed case. Anyhow, you find out. Yes.
Please.
17.
For the KVA.
9.
Not
Thirteen.
show me this copy or not.
ಕೊಟ್ಟಿದ್ದೀನಿ ನಿನ್ನೆನೆ ಸರ್ ಆನ್ಲೈನ್ ಅಲ್ಲೇ ಮಾಡಿದ್ದೀನಿ
ಇಲ್ಲ,
ಸರ್
hard copy ಕೊಟ್ಟಿದ್ದೀನಿ.
ಹಾರ್ಡ್ ಕಾಪಿ ಕೊಡಿ ತಗೊಳ್ಳಿ ಇಟ್ಕೊಳ್ಳಿ
The date may also be kindly be fixed.
Not purchasers expedition divergent findings not the assistant commissioner refuses
Let it
to
be heard
resume
tomorrow, Your Honor.
pass the
Let it be heard tomorrow. So we'll run through the.
they have already they are trying to change the nature of the
Let
property.
it be tomorrow, Your Honor. So we'll not
Correct.
precipitate any further.
Now,
We will-
just one minute.
Please.
Now he is the purchaser.
Please.
Now what is the order of the DC? They have asked directed for restoration. So now it has to be stayed. What is there to hear? We'll hear it after you file objections. We'll hear it finally. The petitioner 95 sale.
Please.
Petitioner, light of the contentions raised, matter requires consideration. In the interregnum, there would be stay of the order of the deputy commissioner at annexure A and proceedings pursuant thereto. The AGA accepts notice for
Contesting respondents are served not caveat 5.
respondents 1 and 2. Learned counsel so and so has entered caveat for respondents 3 to 5. Pleadings by the respondents to be completed within 2 weeks.
Correct.
18. Ramesh Kumar.
Petition not due to positive term not 1965 this first sale deed. 70 the second sale deed, the petitioner's father purchased it. But both the courts have held against the
Proceedings in 2011.
11 minutes.
Light of the contention that the sale deed was executed in 1965 and proceedings for restoration were initiated after undue delay in 2011. There would be stay of
A and B minutes, both.
A and B. AGA accepts notice for respondents 1 to 4. Emergent notice to the 5th respondent.
But I am permitted to, my lord, amend the, I'm sorry, my lord, comply the objections because we had the.
So
No,
many.
the reason is, it's
so
very,
many
my lord,
of-
all clerical mistakes there. My lord, in fact, my lord was pleased to grant time.
Petitioner
I'll do that.
to comply with
Course of the
office objections before collecting copy of.
Please,
interim
I'll do
order.
that right now. I'll do that right now.
19. Jay Kumar.
Mandamus, my lord, last 4 years they have not done, carried out the work despite.
AG accepts notice for the respondents. List the matter in the preliminary hearing list on.
9th.
On
Yes.
an earlier date, man.
9th, let us see.
And
Number 20.
next matter also, man.
Huh?
Same, next matter also.
Same.
Great.
9. 21.
Writ of Mandamus, my lord.
Yes, you find
Considering
out.
the representation made by the
Let
petition.
let them find out. AG accepts notice for the respondents, ex-servicemen.
Yes,
So you get instructions.
Serviceman now.
Huh?
Now he is service.
Okay, find out. List after 2 weeks. Yes.
22. Badri R. Badrinath.
22 appear for the petition. 22 and 23 are identical.
20?
22 and 23 are identical. Now, 1995 sale deed, which has already gone back and forth a couple of times. Of course, Malaz, in all fairness, I must submit that what we have challenged here is the AC's order. The reason why, Malaz, I'm instructed to submit why the DC was not approached is, Malaz, now, given the fact that this honorable court is seized of the matter pertaining to the validity of that amendment, and now that even Nekante, I'm told, Malaz, is now a review petition is being heard, which is why, Malaz, now which is why we approach this honorable court directly. But the fact of the matter is, Malad, since 2004, we have been in possession. We have developed sites. In fact, we have sold also several sites. And now there's an order to take possession and restore. So, Malad, if status quo also is directed.
No, correct. But what we are saying, we'll protect you. You go there only.
To the DC, Malad.
We'll protect you.
The only issue, I see what your lordship is saying. The only issue there is, Malad, now even if I were to raise a contention regarding the fact that there is a 12-year delay, most cases, what the officers.
No, actually, that distinction was made between limitation and
Correct,
reasonable
by a
time.
division bench, correct.
And that has been upheld in the sense SLP was dismissed.
Dismissed.
So technically, the judgment of the coordinate bench is only on limitation, technically. Anyhow, as a matter of procedure, we are staying.
Correct.
So we'll protect you. Why don't you go there? Now,
Very well.
huh? The petitioners have called in question
Let DC approach. Until then.
the correctness of the order of the Assistant Commissioner at Annexure A1. No, but if your second prayer, you want that to be considered, then we have to keep it here. If you want the second,
He wants to consider, I mean, which is why that's why I was submitting. I understand we may have to go to the DC, but that contention can't be raised before the DC. Or that contention may be left open, my lords, with liberty to reapproach later on, depending if the DC orders in our favor, we may not require to urge that contention. That contention will be left open.
Next, petitioners have also sought for a declaration with the provisions of the Karnataka Scheduled Castes and Scheduled Tribes, prohibition of transfer of certain lands, Act 2023, is being unconstitutional in light of the grounds raised. It is noticed that the order at Annexure
A1.
Page
32.
The order of the Assistant Commissioner. The order at Annexure A1 is the order of the Assistant Commissioner. As against the said order, an appeal would lie under Section 5A, of the Act to the Deputy Commissioner. No doubt, the constitutional validity of certain provisions in the Amendment Act,
yes,
have been challenged.
For the caveator man.
However, Learned Senior Counsel appearing for the petitioner submits that question may be kept open as the court had indicated that the petitioner is to be relegated to avail of the statutorily available appellate remedy. Next, taking note of the statutorily available appellate remedy, the petition is disposed of without adjudication, relegating the petitioner to avail of appeal remedy if so advised under Section 5A.
Yes, 5A.
Under Section 5A of the Act. Legal contentions insofar as prayer number
1,
Roman 1 is kept open. The petitioner to take appropriate steps to file an appeal within a period of 4 weeks from today. The interim, in the interregnum, the order of the Assistant Commissioner would be stayed for a period of 6 weeks from today. All contentions are kept open.
Grateful. Same in 23 also.
the presence of the caveator.
And counsel so and so has appeared on behalf of the caveator.
Number 5.
Respondent number 5.
And submits and submits that matter may be the petitioner may be relegated to avail of the statutory remedy.
Great. Grateful.
4. Dear Manjunath.
Adalli no AGI.
24.
My lords can kindly pass it over, my lord.
Serial number 24.
24.
Petitioner. Blood the petitioner being aggrieved by the order passed by the DC Millard dated 31/7/2025. But wherein the DC Millard has decided the dispute over the Millard dispute of the title over the social property. But My lord, the petitioner has derived the property, my lord, on 28/11/2007 by virtue of a registered sale deed determined and shall be page number 25. But in pursuance thereof, the revenue records, my lord, made out in the name of the petitioner, annexure C and C1, my lord, the MR and the RTC has been produced. My lord, all of a sudden, one Patel Timarati has filed the suit for declaration before the unequal court.
What happened to that
My
suit?
lord, that is pending for consideration. They are not, my lord, appearing before the court. So, well, such being the fact, one chicken and charity filed a petition before the, my lord, DC. My lord, quashing up the MR, my lord, made out in the name of myself and my vendors. But DC, my lord, 4 times the matter was reserved for orders, and my lord, after the new DC arrival, so he was not issued any notice, my lord, without hearing, without giving any opportunity. The order has been passed. But based on that, the, my lord, annexure L1 and L2, my lord, the revenue records were made out in the name of the present respondents. But based on that, my lord, they have
Just 31/7 is the order passed.
please, my lord.
When was L1 and L2 effective?
My lord, in pursuance of the DC order, my lord.
When? Which date?
8/8/2025.
Within 1 week.
Please, my lord. My lord, and yesterday I have received the EC copy from my client through WhatsApp, wherein, my lord, in pursuance of the revenue records, they have already entered into an agreement of sale in favor of the third parties. But I may be permitted to pass it. Xerox copy I have. I will furnish the certificate copy and make it appear. And moreover, my lord, I have my vendors had derived the property in the year 1963.
No, correct. Now we can only say not to create any further third party rights.
Please.
What is now the only interim order we can pass?
Please.
Is that they be restrained from creating any further third party
Please.
rights. Huh?
Please. And so far as the issuance of notice to the respondent, 15 to 20 may be dispensed with because they are my vendors.
Notice to respondents, 15 to 20 is dispensed with.
Please, I'll pay.
In light of the memo filed.
I'll pay.
As petitioner submits that the said parties are vendors of the petitioner. AG accepts notice for 1 to 5. Emergent notice to 6 to
14.
6 to 14. In light of the contention of the petitioner, the revenue entries pursuant to a sale deed have been
page number 178
have been set aside by proceedings before the DC. And in light of other contentions raised, there will be stay of the order at annexure.
But annexure L, page number 178.
No, which is the order?
Annexure A, my lord.
Annexure A, as well as
Page number
annexure
20.
A, full stop. For the private respondents, respondent number
6 to 14, my lord.
6 to 14 are restrained from creating any further third party rights, noticing the submission of petitioner that registered agreement of sale has been executed.
Please.
What is this within 1 week? How you can change? Very unfair this is. Years together you don't change revenue records.
2011
within
suit is
1
pending.
week after the order is passed, change. It doesn't inspire confidence.
25, Nagarajati.
Office objections you have.
DC order 2011-12 ಅಂತ ಇದೆ. That office objection may be rectified, my lord, because 356 of 2011-12 ಅಂತ ಇದೆ. It is only 2012. I have mentioned it, but they have not accepted. So council note ಅಂತ court ಮುಂದೆ place ಮಾಡಿದ್ದಾರೆ. So that can be
Objection is
rectified.
kept in abeyance in light of the explanation.
Please, please.
My lords, the
Okay,
matter
for 25.
give it respond number 5 minutes. Copy is not. My lords, the matter may be passed over, my lords.
Copy, Mr. Huh? Annexure. We'll have it tomorrow. You serve a copy. You serve a copy. We'll see tomorrow.
Please.
List the matter in the fresh matters list tomorrow.
26, what is Vasudev? 26, Vasudev Young.
At request, relist.
Thank you.
Yes.
27, DP Mahesh.
Petitioner in this case.
Why is it come in preliminary hearing list?
In this case, the matter is pending in Supreme Court. Kindly turn to page 37 of statement of objection. I am the first purchaser.
Yes, what is your case?
So kindly see, I have challenged the order passed by the Deputy Commissioner, setting aside the order passed by the Assistant Commissioner, my lord. Directing to enter the name of.
I am the first purchaser. My sale deed is kept pending because of Lavani sketch. Now the matter is, I had filed the writ petition. Kindly turn to annexure R3 at page 37 of my statement of objections. This honorable court said Lavani sketch is not necessary.
This is a petition filed by you.
Petition filed by me. My father, Gopal Reddy. My registration was kept pending because Lavani sketch is not issued. Then ultimately the registration appeal was also refused and we filed a writ petition. In the writ petition, this is the order made by the division, the honorable judge. So in the event that the SLP were to be disposed of in my favor, then I am the owner, I will be the owner of the property. Therefore, the matter has to be deferred.
This is insofar as Lavani sketch. This is insofar as the Lavani sketch.
Lavani sketch, Lavani sketch.
2011 is the sale deed executed.
Correct, but what is the present petition?
Present petition, change of revenue entries in the name of the petitioner.
Civil suits are pending.
Civil suits are
Civil
pending.
suits are pending.
In spite of it, the Deputy Commissioner says, change the entries in the name of a person in whose favor sale deed is not yet registered.
Lord, the sale consideration was not paid to us. According to them, we are the vendors.
No, just one. Now, what is the 136-2 order?
Yes, brother. Kindly see, that is annexure A.
Annexure?
A.
Annexure B.
B passed by the Assistant Commissioner.
Who went before the Assistant
The
Commissioner?
petitioner, man.
Petitioner.
Yes, seeking the enter his name as per the registered sale deed.
Sale deed of?
Sale deed of annexure D, page number 32.
Dated?
Dated 17/11/2015.
17/11/2015. There was a sale deed executed in your favor by?
Yes, my lord. By the respondent number 3 and 4.
R3 and 4.
Sorry, for 5 and 6.
5 and 6.
6.
Then you, so what happened to that? The mutation was earlier in whose name?
My name.
No, not in their name, the vendor's name. Vendor's name was there pursuant to the sale deed. My name is entered. My lord.
Entered?
Yes. Against which the respond.
Just 1 minute, let me understand.
Yes, ma'am.
Now, you went before the
Assistant
Commissioner.
Yes.
So you challenged which MR?
I am not challenged. I said Tahsildar has not entered my name in the revenue entries. Therefore, direct him to enter the name as per the registered sale deed. That was allowed.
Initiate RRT proceedings.
Page number 20.
The allowing of the
operative portion may kindly be seen.
So you only went against the inaction?
Yes, inaction on the part of the Tahsildar.
So that
to enter the name as per the registered sale.
Prior to this, in whose name it was there?
The respondent number 4 and 5, my lord. They have acquired this property as per registered sale.
5 and 6.
Yes, ma'am.
Your vendors?
Yes. 5 and 6.
Earlier MR was in the name of your vendors?
Yes, as per the registered partition deed. This property was failed to their share as per annexure F, my lord, page number.
No, where is that MR earlier to this?
That MR is not there, my lord. Kindly see the registered partition deed.
No, okay, let us see. So
Yes.
now then, so this order at Annexure B had directed affecting
Revenue entries in the name of petition.
on the basis of the sale deed.
Sale deed.
Then what happened?
Against which, my lord,
Hmm.
the respondent number 7 and 8 filed a appeal before the Deputy Commissioner, Annexure A.
Annexure?
A, page number 15.
Yes.
There I have stated that pursuant to this, they have filed a suit for injunction, later converted into suit for declaration, challenging my sale deed. That is pending consideration.
No orders are passed.
No, it is still pending.
Interim orders are operating. Interim orders are operating.
Not-
Two suits are pending.
not
That's what the learned Deputy Commissioner observes in his order.
OS numbers
OS number
535 of 2015. Those are filed for
Partition.
for declaration.
Declaration and partition.
Initially injunction, later converted into declaration, challenging my sale deed.
what is the interim order passed?
Interim order, I am
Not
not.
to alienate.
Not really.
Not really.
Now these are still pending.
Yes, still pending.
Still pending, my lord. We, according to him, we are
You
the
are,
vendors.
you are the,
According to him, we are the vendors. We are disputing that.
you are 5 and 6.
5 and 6. According to us, my lord, no sale consideration is paid to us by
That
the
we'll see. That's a matter.
They have not challenged.
That's a,
Unless
ma-
not
no,
the- no,
that's a matter before the civil
civil
court.
code. Yes.
Now, what does the DC order?
Now kindly see the DC order. Now the entries in my name was cancelled and directed to be entered in the name of the respondent, subject to the result of the suit.
Which respondent?
Gopal Reddy Miller. Gopal Reddy and Prema.
Who are the agreement holders?
No, they are the the purchasers whose sale deed was not registered due to Lebanese sketch.
I'm sorry, my lord, he's not making.
Just 1 minute. Now, before the deputy commissioner.
Yes.
Deputy Commissioner is only
Order passed
secretary.
is, the appeal was, the revision was allowed.
Allowed.
Now the
Order
order in
set
the
aside.
RA was set aside.
Yes.
Okay.
Both the parties are at liberty to defend their cases in competent civil court
Civil
for
court.
for
Yes.
their civil rights over the property.
Huh.
Now my the
That
revenue
has to be
entries.
maintained.
Huh?
That has to be maintained, my lord. In fact, subject to result of the civil suit.
Now, as on date, the kata stands in your name,
Please,
R5 and 6.
please,
Huh?
please.
So now it's in your vendor's name.
Yes.
Let us.
No, no, not my vendor's name. The first purchaser whose sale deed is not registered.
No, no, no.
ನಮ್ಮ ಹೆಸರು ಇಲ್ಲ.
ಅವ್ರ ಹೆಸರಿಗೆ ಆಗಿಲ್ಲ.
ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇಲ್ಲ.
It's in the vendor's name,
Vendor's name ಅಲ್ಲ.
your vendor's name.
In fact, my lord, without approaching.
There
the
are
assistant-
3 sale deeds. This gentleman has executed 3 sale deeds. Kindly take my statement of objection, my lord. First sale deed is in my favor. Entire sale consideration is paid. Position is delivered to me. Annexure R1, my lord. He is the second purchaser and there is another third purchaser.
No, now, how are you aggrieved by this? Huh? Now, anyhow, it's in your vendor's name, suits are pending.
Yes.
Yes.
Let us see. You can always implead yourself in the suit.
He is already implemented.
I
It's a
have,
party.
been impleted.
And then you wait now.
No, pursuant to sale deed, my lord, it should have been in my name rather than my vendors
That
because
we'll see, that we'll see. Admittedly, suits are also pending. So we'll see, we'll hear it. What is, why should we take it out of turn? Let us,
yes, my lord. Let it be.
this is the matter. In B group.
After disposal of SLP, my lord, because
After
that will,
disposal.
no, that will nail the issue.
No, let us see, let us see. This is the matter. In B group, in due course. What is the interim order in operation?
Against the order of the deputy commissioner is stayed.
That is stayed. In fact, with the same observation, my lord, writ petition itself could be disposed of. Because subject to the result of ultimately, irrespective of the outcome in SLP, my lord, ultimately what prevails is the civil court judgment.
Now validity of the sale deed is under challenge. my
No,
lord.
no, it is not only challenge.
They have
Only-
challenged my sale
It is
deed.
a mischievous way of
My,
doing things.
my sale deed is challenged.
This is the matter in due course.
Interim order.
Interim order, we are going to extend to the next.
28, Badrinath R, 28.
But I am for respondent number 5.
State government was directed to
I
secure the
responded
original
number 5.
record. In this case, the state government was directed to secure the original record that resulted in the passing of Annexure A, my lords. Annexure A, which is at page 20.
One submission. Respondent number 5 was expired, madam. Yesterday I filed memo reporting a plate. Contesting respondent. Yes.
Respondent?
5, madam.
5.
Yes, 5, madam. He is a contesting respondent, Hanumakka. Yesterday I filed memo, not put up.
So you give the details of the legal representatives, they'll take.
Will take.
Steps.
When will you give?
That's a week time. Madam.
Counsel for the respondent number 5 submits. Respondent number 5 has died. Further, it submitted that the details of legal representatives of R5 would be furnished. List the matter in the same stage on next week.
9th.
Meanwhile, you verify. You allow them to inspect it.
Yes, ma'am. We'll do that.
You allow them to inspect it.
Very good. Great.
29. Serial number 29.
On the petitioner's case, writ of Mandamus consider representation of the petition. Petitioner is unauthorized occupation of the land measuring 2 acres 3 guntas from the past many years. The petitioner filed a form number 53 before the third respondent. Still, it is pending.
Been disposed of with the committee. Committee has rejected it.
Give him a copy.
Yeah. Page 101, entry 72. PT Rajegowda.
Stating it's Inam land.
Yes.
My petitioner is PT Rajegowda, my lord. This is BT Rajegowda.
Serial number 72.
PT
Page
Rajegowda.
101. This is what I'm told, my lord.
My petitioner is PT Rajegowda, Annexure A, my lord. PT, initials.
What's the survey? Survey number.
You find out if he's the same person. Please, bro. To find out if he's the same person.
Please.
AJ.
Could I request for a passover, my lord?
Yes,
Verify.
Passover. So if it is so, then you'll have to challenge that.
Please, ma'am, please.
30. Supreet.
Same, my lord. I'm the petitioner, my lord, from the form number 50 filed by the petitioner, my lord. It still is pending, my lord. No order has been passed, my lord.
That is. His application is still pending.
Application has not been uploaded because within that time window they were not able to upload the petition. Now the portal cannot be accessed by them unless permitted by the department.
So you do that. I'll call it after 2 weeks. This is the matter in the same stage. 2 weeks admin date.
Great.
31. 31. MS Deora.
Respondent. Seeking a writ of Mandamus. Copy has not been served. Only seeking a writ of Mandamus against the Deputy Commissioner. Now I see the file. Now I see the file to the government advocate. They not served the copy with me.
That he has to give.
But in this case, either Tahsildar or Executive Officer Talak Panchayat issue the Akkupatra, not for the PDO.
So who has to be implemented then? Who has to be implemented? No, R3 is there, Executive Officer Taluk Panchayat.
And Tahsildar also implemented a party.
No, correct. Now, you appear for the Executive Officer also.
Yes, I have appeared, my lord.
So you find out.
But they have made a representation to the deputy commissioner.
That's okay, but now if at all there is a Hakupatra, you will have to find out
They are-
from your
They are
register.
stating that the Hakkupatra Nakulu copy.
Correct. So you first find out if in your register you have issued any Hakupatra.
I kindly made one more representation to the executive officer Taluk Panchayat. Then we'll decide.
Let him come, we'll see. We'll have it some other day.
Yes, ma'am.
Meanwhile, you just have a look at it
Yes,
and
yes, Maharaj.
complete your
Yes,
instruction.
yes, Maharaj. And also, please serve the copy.
Petitioners, you take it from the government advocate.
Yes.
Petitioner to serve copies of the petition on counsel for R3 and 4. List after 2 weeks. Instructions to be completed in the interregnum.
32. Tenant's petition, my lord. Claim has been rejected in so far as 2 acres 34 cents is concerned.
So we'll admit it and hear it in due course.
My objections are also ready, your lords. I'll file it in the counter.
Correct. Now it has to be heard, isn't it?
Yes, sir.
After several rounds, some order is passed. So we'll consider it. We'll consider.
State government notice madam.
AGA is directed to accept notice.
1 to 3 may.
1 and 2.
1 and 2.
When counsel so and so has entered appearance by filing caveat insofar as the third respondent.
Third respondent.
Now apprehension is, my lord, they are trying to alienate at least to that extent.
We will not alienate
If they undertake, my lord, no.
We'll undertake to not alienate.
Third counsel for the respondent number 3 submits that they would not alienate the property pending disposal of the present proceedings. Counsel for R3 submits statement of objections will be filed. This is the matter in due course in B group. So somebody said in land reforms matter in Mangalore, now it's no more landlord tenant, it's only real estate.
33, Mohammed?
Yes.
Yes. Petitioner. My lord.
There's another faction. It's another faction that has filed another writ petition, my lord. We're trying to verify what the writ petition is. A letter has been sent to the DC's office, my lord, saying a writ petition has been filed contesting on the same land. But the letter does not say which writ petition. So we're trying to verify that. So lordship may have this next week.
I have 3 decrees from the civil court, my lord. In addition to my grant order, Hakkupatra, RTC. The order of the possible the DC commissioner, DC almost ಹೆಬ್ಬೆಟ್ ಕೊಡೋಕೆ 1.5 ವರ್ಷದಿಂದ ಟೇಬಲ್ ಎಲ್ಲ ಇಟ್ಕೊಂಡು ಕೂಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. He's having the hand in glove with land mafia. How can he come and say that no, ಇವರೇ ಹೇಳಿ ಹಾಕಿಸ್ತಾರೆ ಸ್ವಾಮಿ.
Okay, you find out.
I'll find out.
AG accepts notice for respondent 1 and 2. Relist after 10 days, date code.
10th.
On 10th. Great.
34, Srikant MP, Vinay K.
This require a week's time, my lord.
Lord's first matter, Lord's,
For a week.
there is some urgency, my lord, the other matter can be, Lord's, can be
He
sorted out
can't, won't
anytime.
leave till next week. That's why yesterday he didn't leave. He wouldn't have allowed me to get up and go. So I said, I told Manjunath, even the midst of the bail, Srikant matter, nale preliminary hearings. Now, what is the first matter and
My
what is
lords,
the
first,
second matter?
What happened, my lords, my lords, we are running the institution, my lords, in the premises. My lords, with due permission, my lords, and my lords, all the requirements. My lords, at least from 1988. My lords, the department raises a dispute, my lords, as representation appears to have been filed by one individual, private individual, saying that the land on the RTC says Vidyalaya Kottanta Jaga Anta, that is acquired for the purpose of the institution. They say it doesn't clearly say to this institution. As such, Nimdala land. They raise a dispute. My lords, representations are filed and my lord, there is a suit pending, my lords, filed by the petitioner management. Against the government, there is an injunction granted, my lords, which is being continued.
Against the government.
Against the government. Because at that stage, insofar as the high school is run, originally registered as girls' school. In 2004, we made a representation to convert it or to run a co-ed educational institution. They sat over it, we have been running the institution. Students are appearing for examination throughout from 2004, and we are in 2025. Now they say, we don't renew recognition first, saying that you have running in a disputed land. Number two, you have converted into co-ed without permission. The matter had reached the appellate authority as we filed the appeal. The appellate authority, though observed in our favor, rejected the appeal. Against that, the writ petition is filed and also for other reliefs. Interim order of stay is granted, insofar as withdrawal of recognition is concerned. In that event, what happens is the department issues a notice on us, saying that we have to shift all the 10th standard students to some other institution by issuing TCs, and that they should be allowed to go out of the institution.
No, what is the interim order passed?
Staying, all the impugned orders. That is, your lordship may kindly see the order dated 8/9/2025. Annexure A, G, Y, and Z, they were stayed. Y, is the order of the appellate authority. Where, my appeal is rejected. In spite of observing that the request was made in 2004 itself for conversion into co-ed.
Correct. Now, there is already a stay, no?
There is already a stay. What happens is, the institution should run smoothly. Now, what they have done is, first they issue a notice saying that you have to issue TCs to all the 10th standard students, so that they will go to some other institution, write the examination from that institution.
What is A, G, Y, and Z?
Y, is the order of the appellate authority. Annexure Z, 175, where they say, that there is a dispute, and insofar as the land is concerned, as such, will not grant you post facto permission for co-ed education. That is, annexure Y. Now, insofar as annexure AG is concerned, is passed by the BEO, who says, that we will withdraw recognition, shift all these students to some other institution, you have to close the institution. All these orders are stayed, by this honorable court. Virtually, they should allow us to run the institution smoothly, which is being run. Now they have to overcome this order. They issue notice, we file an application. Friday and Saturday, the BO himself issues the TCs. He changes the entries in the SATs, that is Students Achievement Tracking System.
What has happened to that suit?
They have Saturday, they are shown to have been.
What has happened to the suit?
Suit, is pending. There is an injunction granted.
OS number?
That 206 of 2023,
Copy of the interim order, annexure?
That annexure X, page number 140. 140, it starts at 145.
Para 4.
That is at 145 para 4. Plaintiff has produced as many as 16 documents. It is well settled principle of law that the subject matter of the suit has to be protected and maintained intact during the pendency of the suit. As rightly contended by the plaintiff, if the IA number 2 is not allowed, the defendants may interfere with the possession of the plaintiff or the suit scheduled property. If an order of ad interim to expert injunction is declared on IA number 2, the very purpose of filing the present suit will be frustrated and it is defeated by delay. On perusal of the records, at this stage, the plaintiff has made out prima facie case. It is suit for permanent injunction. The plaintiff has to prove its possession over the suit scheduled property. In such circumstances, with both the parties.
Yes. Suit for?
Injunction.
Not declaration.
Not declaration. My lord, another writ petition, my lord, is pending. My lord, irrespective of that, if I'm.
Just 1 minute.
Please.
Suit for injunction.
Injunction, my lord, is pending, where my lord, temporary injunction is granted.
Now what is the precipitative action they have taken?
No, my lords, they have issued, if your lordships currently have a look at, my lords, my application.
After the interim order is passed, what have they
My
done?
lord, they have shifted, my lord, 10 standard students. They have issued transfer certificates to 10 standard students.
Where
First,
where
your
is
lordship
that?
may currently have my application for direction, my lord.
IA?
That is IA for direction, my lord, which has been filed. My lord, there are 2 applications. They have not renewed, they are not renewing the recognition.
IA number?
That is, my lords, which are listed today, my lord.
7/11/25, my lord. The
IA 2
applications.
of 2005, my lords, and 3 of 2005.
Now have they given any communication?
Your lordship may kindly come, my lords, have a look at my lord's page number 14, my lord.
Page?
Page 14. I'm sorry, 16, my lords. This is the communication, my lords, of the secretary, my lords, of the KSE board.
It is admitted, my lord. When I sought instruction, my lord, on 21st, everybody has been, means the transfer in was already entered in the website and the portal, my lord.
That is what, my lords, what happens is BO himself does it. My lords, no
My
TC
lord,
by us.
shall I, my lord? The petitioners have approached this honorable court several times with an ulterior motive itself, my lord. It's a petition with a lot of falsehood upon them itself. In 2004, they have filed an application without seeking a permission. They have started admission with respect to the boys in the school itself. So violating that, when the notice was issued, they have challenged before this honorable court, and it was directed for us to give the answer, means consider that representation. So after consideration of that representation, about 20 long years, they have, means about 17 to 18 years, they have continued with the admission of the boys, and that we have, invariably we have permitted.
There is no permission.
There is not at all a permission with respect to that. The appellate authority, after considering all these aspects, have clearly stated that an action has to be taken in accordance with law, and also the officers who have been permitting this type of activity of illegal running of a school by the petitioners. That was stayed by this honorable court, but the action is treated to be illegal by entire proceedings of, means entire proceeding itself.
There is no permission to start.
There is no permission at all, and even the land belongs to the government.
That land part, we leave it aside
Yes,
for a
but
moment.
there is no permission.
There is no permission.
There is no permission. And
Is absolutely, my lords.
Point out where the.
Yes, my lord, that is what, my lord, I'll take your lordships to the, my lords, the order of the appellate authority himself.
Yes.
Lord, they have to answer this.
Produce-
Your lordship may kindly see page number 160, my lord.
Where is the permission you show us now?
My lords, the permission is granted to the institution.
That you should produce
Please,
that.
I have Paisanta permission alladu. If lordships kindly.
My lord, I will read the petitions.
Please, court should not be, my lords. My lords, I am answering the court's question. Your lordship may kindly come to, my lords. There are 2 institutions. One is primary school. Lord, the other one is, my lord, the high school, run by, my lords, the management. If your lordships kindly come to, my lords, page number 64. The primary school, my lords, was admitted, my lords, to grantinate, my lords, by that order. And, my lords, page number 70, my lords, is the, my lords, the order admitting the high school to, my lords, the granting recognition to the high school. The entire confusion is this. If lordships kindly see page number 70, my lords, annexure E1. They say, originally it was Srimati Tayamma Channegoda Balakiyara Prodashala. My lords, thereafter, my lords, that is in 2004, we made a representation saying that we want to have a co-ed institution run. My lord, that is it's an admitted fact, my lord, they're sitting over, my lords, that. It's also an admitted fact that, my lord, the institution is admitting, my lord, the students for co-education. The students are appearing, passing the examination, 20 years over. Your Lordship, in this background, kindly come to, my lord, the order of the appellate authority. Type copy, my lords, is at 160.
No, why this now?
Lord, the fact is, my lord, there is no permission, my lords, granted by the department, saying that you should admit only the boys or only the girls. Recognition is that I am given, my lords, recognition for one section. There is no prescription that I have to admit only the girl students. If they show that they have to admit only the girl students in the order of recognition, my lord, yes, I don't have any case. They have to grant me permission.
My lord, in
There
this
is no,
regard,
one second, sir, one second, sir. There is no such stipulation also. If lordships kindly come to, my lord, the order of the authority, my lords, on our appeal. At 170, my lords, Karanagala Saita.
No, now, are your instructions complete?
no, not completed with respect to this, my lord. The admission, the exclusive permission for their school, the petitioner school was for
When will you complete your instruction? I'll have it-
Monday, by Monday, my lord. By
Monday.
Monday.
I'll have it in the same stage on Monday.
Lords, the difficulty is, my lord,
Same stage. We'll see what is to be done.
let them not, my lords, man, they have already issued, my lord. the
Already
transfer-
issued, already enrolled, they have been
They have
permitted
no,
to.
absolute, view has no authority, my lords, to issue transfer certificates. He himself has.
Monday, my lord, I will.
Release the matter in the same stage on Monday.
Much obliged.
Lord, let the students, my lord, continue or,
See, on Monday we'll decide.
Lord, they, students, my lord, at this stage, they cannot be made to run, my
No,
lord.
we'll see what, he's not ready. So we'll hear in, let him complete instruction and then we'll see what is to be done.
Please.
The matter in the same stage on Monday. Whether the education matter can go back, that also you take. up.
No,
My lord,
it is connected, my lord.
No, no,
That-
if I'm-
then you
Recognition, the recognition.
Complete your instruction and you.
My lords, one submission, my lords, if I'm permitted, addition of this honorable court. My lords, my lords, land dispute, my lord, is sought to be, my lords, clubbed along with the
that
running of the institution, my lord, this court has made it clear.
So that we'll see.
Please, my lord. That it, my lord, it has to be, my lords, independently heard, my lord, that's what
That
the
you
view.
can't say.
No, I'm not saying anything, but you take up by
Under,
this
under
court,
the
my lords.
roster, it comes to the senior judge. That's how it is.
My lords, I understand, I fully.
So let
support.
us, let him complete. We'll see what is.
Please, my lord.
Yes.
35.
Transfer. Petitioner, my lord, the petitioner is, my lord, seeking transfer to mutation based on the registered sale deed. Earlier approached the petitioner to this honorable court, issued the writ of mandamus to within the 2 months time, my lord, page number 13. Again, now they are the respondent, the Tahsildar issued an endorsement. ಅದಕ್ಕೆ ಜೆ ಸ್ಲಿಪ್ ಬಂದಿಲ್ಲ ನನಗೆ, ಅದಕ್ಕೆ ಖಾತೆ ಮಾಡಕ್ ಬರುದಿಲ್ಲ ಅಂತ ಪೇಜ್ ನಂಬರ್ 10 annexure A. Endorsement was issued by the Tahsildar. Last ಕೆಳಗಡೆ operative portion ಅದರಂತೆ ಪ್ರಸ್ತಾವಿತ page number 10 my lord, annexure A. This is the endorsement challenge in this writ petition. 10.
Yes.
Annexure A. Reason is in the last paragraph. ಪ್ರಸ್ತಾವಿತ ಹೆಸರುಘಟ್ಟ ಹೋಬಳಿ ಬ್ಯಾಳಕೆರೆ ಗ್ರಾಮ ಸರ್ವೆ 69/24 ಗುಂಟೆ ಜಮೀನು ಪೈಕಿ 1 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕ್ರಯಪತ್ರ ನೋಂದಾವಣೆ ಸಂಖ್ಯೆ ದಿನಾಂಕ 9/10/2006 ಖಾತೆ ಮಾಡುವ ಸಂಬಂಧ ಭೂಮಿ ಶಾಖೆಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಕ್ರಯಪತ್ರದಂತೆ ಖಾತೆ ಮಾಡಲು ಸಂಬಂಧಪಟ್ಟ ಉಪ ನೋಂದಾವಣಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಿಂದ ಜೆ ಸ್ಲಿಪ್ ಸ್ವೀಕೃತವಾಗಿರುವುದಿಲ್ಲ. ಸಂಬಂಧಪಟ್ಟ ಉಪ ನೋಂದಾವಣಾಧಿಕಾರಿಗಳು ಕಚೇರಿಯಿಂದ ಜೆ ಸ್ಲಿಪ್ ಸ್ವೀಕೃತವಾದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು.
So for the purpose of registration of sale deed, they need a
J slip. That is old sale deed, 2006 sale deed. Or J slip bandre na ಮಾಡ್ತೀವಿ ಅಂತ. There is a registered sale deed. We have produced the sale deed along with the representation. 28(1), my lord, the party can produce the documents before Tahsildar for transfer of the kata.
Now, what is the rule? Some circular is there, is it?
Yes, sir. That circular is, my lord, issued on 2010-2021. They prohibited the agriculture lands in less than 5 guntas. My sale deed is a 2006 sale deed.
Correct, but only at the time of registration, you must fulfill whatever is there.
No, there is no circular. 2006 sale deed. That is on this court passed the judgment on coordinate bench. I give that circular is, my lord, 2021.
WP number
WP number 1034466/23 in para number 5, my lord.
Give him a copy.
I give the copy last time. Tagoli sir, innೊಂದು. Para number 5, my lord. Para number 5.
Yes.
The Revenue Department, Government of Karnataka has issued a circular 12/11/2021 stating that subdivision in respect of land, the extent of which less than 5 guntas is prohibited. The competent authorities with a reference to said circular has rejected the application stating that the extent of the land is possessed by the petitioner is less than 5 guntas. The condition number 2 in the said circular indicates that the restriction is not applicable to the extent of the lands which is purchased prior to the issuance of the circular. The petitioner has purchased 2 guntas of the land 28/2/2019, that is prior to the issuance of the circular. Therefore, the impugned order passed by the competent authority refusing to mutate the name of the petitioner is contrary to.
Now, the only clarification is, it says that this is the context of mutation.
Yes.
So, in that they said, if the sale deed is executed prior to the circular, then this bar won't operate.
Yes.
But here your sale deed is not executed only.
But my say in the writ petition 28/2/2019 sale deed, circular is issued on 12/11/2021. This is a prospective effects. That is the circular.
No, correct. But here the registered sale deed was already registered on 28/2/2019.
19.
This case.
Yes, my lord. The prior to that, prior to the circular, this already sale deed has.
Correct.
registered.
So for mutation entry, court said it won't be a bar because that circular.
Yes, my lord.
Is prospective.
Yes, my lord.
In your case,
In my case is also.
sale deed is not registered.
My lord, my sale deed is registered.
Sale
My
deed registered.
Sale deed is registered, my lord. That is the page number. I produced the sale deed also.
So this is only for mutation.
Only for the mutation only. Page number 16, annexure C.
Page?
Page number 16, my lord.
16. Sale deed dated?
Sale deed dated 9/10/2006. Very same as the set of facts and applicable.
9/10/2006.
Yes, my lord.
Now they have refused to mutate.
Mutate the name of the sale as per sale deed. That is same. This the judgment also applicable to my case. Very same the set of facts.
Yes. Now it appears to be covered by this one.
My lord, with regard to this 1 gunta also, there is another circular which is there. Could I just seek instructions and have?
No, now he's only seeking for kata.
I understand, my lord. Could I seek instructions in this, my lord?
So we'll have it on
Day after tomorrow, my lord.
release the matter on Thursday in the same stage.
Please.
Otherwise, it appears to be squarely covered by the coordinate judgment of the coordinate bench.
Please. In fact, that has been recorded on the last date also by this court. I'll seek clarification by it.
If you having any subsequent circulars, they can produce me.
Yes. Yes.
36 is a similar matter to 35. my lord.
36.
Though it pertains to a different taluk. Same issue.
J-slip.
Same issue. J-slip. It's an old deed of 1970s. They now
Here
want
also
to.
mutation you have rejected on the ground that.
No, mutation is not rejected.
Just 1 minute. Why are you jumping like that? No, they have refused to do mutation because J-slip is.
J-slip is not.
Lords, mutation is already done, Lords.
What
Mutation is already done.
Okay, so what is the grievance now?
Lords, kindly see Lordship order dated 27/10/25, Lords.
Now, what is the endorsement notice?
Lord, there is some litigation, Lords. Lords, there is no litigation as such. There is no any such litigation.
Just read that notice.
Endorsement, Lords.
Government notice.
Lords, ಅಜಿತಾವ್ ಶ್ರೀಮತಿ ಗೌರಮ್ಮ ಕೋಮ್ರೇಟ್ ಮುನಿಸ್ವಾಮಿ ಆದ ನೀವು ಈ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಆನೇಕಲ್ ತಾಲೂಕು ಜಿಗಣಿ ಹೋಬಳಿ ಕನ್ನನಾಯಕನ ಅಗಹ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 16/4 11 ಎಕರೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಪೌತಿ ಖಾತೆ ಮಾಡಬೇಕೆಂದು ಕೋರುವುದು ಸರಿಯಷ್ಟೇ. ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಆನೇಕಲ್ ತಾಲೂಕು ಜಿಗಣಿ ಹೋಬಳಿ ಕನ್ನನಾಯಕನ ಅಗಹ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 11 11 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪಾವತಿಯಾದ ಮುನಿಸ್ವಾಮಿ ರವರಿಗೆ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 3150 of 7475 ಅಂತೆ ಶಿವಶಂಕರ್ ಅವರಿಂದ ಕ್ರಯವಾಗಿದ್ದು ಎಂಆರ್ ನಂಬರ್ 3/75/76 ಆಗಿರುತ್ತದೆ ಎಂದು ಆದರೆ ಅಂದಿನಿಂದ ತಹಲ್ವರೆಗೂ ಖಾತೆಯಾಗಿರುವುದಿಲ್ಲ ಹಾಗೂ ಮುನಿಸ್ವಾಮಿರವರು ಹೆಸರಿನಲ್ಲಿ ಕೈಬರಹದ ಪಹಣಿ ಹಾಗೂ ಗಣಕೀಕೃತ ಪಹಣಿಗಳಲ್ಲಿ ಹೆಸರು ನಮೂದಾಗಿರುವುದಿಲ್ಲ ಎಂದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಪ್ರಶ್ನಿತ ಕ್ರಯಪತ್ರ ಸೋನ್ಸುರಲ್ಲಿ ಸಾಲಿನಾಗಿದ್ದು ಹಳೆಯ ಕ್ರಯಪತ್ರದ ಮೇರೆಗೆ ಭೂಮಿ ಶಾಖೆಯಲ್ಲಿ ಖಾತೆ ಮಾಡುವ ಬಗ್ಗೆ ಚೆಕ್ಲಿಸ್ಟ್ ಸೂಚಿಸಲು ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ರವರು ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿಕೊಂಡು ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ರವರ ಆದೇಶವಾದ ನಂತರ ಈ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು ಎಂಬ ಅಂಶವನ್ನು ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಸುತ್ತೇನೆ.
So now the sale deed is of
75. Mutation is also done in the year 1975.
1975
itself, notes.
Annexure?
Let's kindly see annexure, notes, annexure C, page number 19.
MR number?
Plus MR number, notes.
3 of 75/76. 3 of 75/76.
Page number 22, notes. Second column, note, that is type copy I have produced. MR number 3 of 75/76.
So now it was in the name of?
The name of Muniswami, my husband, my lords.
Now he's alive, dead.
He is no more, my lords.
When did he die?
Lords, he expired, my lords, somewhere in, my lords.
Now you are seeking transfer into your name.
It might, she is the wife of Muniswami, my lords. Pavati Khate and computerization of the MR and the RTC, my lords.
Now do you take your stand in writing, please? Yeah.
Lords, last time also they said, my lord, they filed objections, my lord.
Let them file it. AGA, the counsel for the petitioner submits that they are seeking effecting of kata into the name of Gauramma, wife of late Muniswami. It submitted that MR 3 of 75/76 was standing in the name of Muniswami, and after his death, they seek for transfer of kata into their name. Full stop. They submit that the notice of 27/10/2025, which may have the effect of an endorsement, would not be tenable in light of a copy of mutation extract produced at annexure C, certified by the Tahsildar. AGA to take their stand in writing within 2 weeks.
Does any date may be fixed, lords?
2 weeks admin date.
15th.
Yes.
Problem.
37. Lata.
Appear for the petitioner, my lord. In this matter, my lord, I had given a representation to consider my application, which is pending from 92, my lord. 91. 1/7/1991.
Now land has been regularized in your favor.
The kata is granted in my favor, my lord.
We've initiated 108K proceedings after the grant has been given, because it comes within 5 kilometers of the city limits. ಹೌದು ಇದೆ ಮೇಡಮ್, ಇದೆ ಮೇಡಮ್, ಇದೆ ಮೇಡಮ್. ಹೌದು 30, I'm sorry my lord, 37 is my colleague's number. 38. ಇಲ್ಲಿ ನಾವು
Now,
Mutation is in your name.
RTC is in the name of my father, my lord. After he expired, I had filed for Poti kata. That time they tell me that there is no grant order passed.
No, now
My lord,
you are your husband, father.
Father, my lord.
Father was the original grantee.
He had filed for grant of the land, my lord, but instead, since there was a suit pending, that kept my application pending.
Just have a look at the endorsement.
I went through the endorsement, my lord. It doesn't say about any of my application. They're saying that application is representation is in status quo only. Wherein, my lord, my prayer is to consider my pending application of the year 91 for the grant land. Nowhere they specified.
Okay, you're seeking for grant or saguli?
Yes, my lord. So,
No, no.
grant order itself, my lord, without passing a grant order, that straight away muted
my
the land in my name.
My lord, may I submit, my lord? Here was a case where there was an application filed for regularization of land. The same was also placed before the committee. Committee in its proceedings makes a recording that it is in kept in abeyance due to some legal proceeding pending, my lord. There is no record of what proceedings are pending. According to the petitioner, it would be original suit pending before the civil court. It is pending in before the committee, my lord. So there is no grant order at all. Now, thereafter, what the petitioner has done is on the basis of the OS judgment, they have got the kata mutated. Thereafter, they make a request to make out inheritance kata, which comes to be rejected. So now the endorsement says because it is already rejected, you will have to go before the AC insofar as the inheritance kata is considered. The petitioner also has another additional prayer, my lord, to issue Saguali Chiti. But before the committee, it has been kept in abeyance due to some legal proceedings pending, my lord.
So where is that? Where do you say that?
That, my
That
lord, I
legal
had
proceeding has disposed of in the year 94. Thereafter only they changed the kata in my name, my lord,
No, no.
after producing the OS order. It's at
The committee has.
proceedings are not
committees
before
to-
your lordship.
Then you place that proceeding.
Please, my lord, those proceedings I'll place.
You place the.
I'm sorry, my lord. Your lordships will find that at page 20 of the petition. Page 20. List of 20 people, my lord. Below the page 20.
Yes.
Those are the proceedings, my lord. After 20, if, lordships would see that ಹಾಗೂ ಈ ಕೆಳಕಂಡವರ ಬಗ್ಗೆ ಮಂಜು my lord, I'm not able to read this now. ದಲ್ಲಿ ದಾವೆ ಇರುತ್ತದೆ, ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಇರುತ್ತದೆ, ಅವರುಗಳ ಈ ಕೆಳಗಂಡಂತೆ ಇರುತ್ತಾರೆ. Then thereafter, my lord, 6 people are recorded over there, of which petitioner is also one. ಇವರುಗಳ ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕಟಣೆ ಪೆಂಡಿಂಗ್ ಇರೋದ್ರಿಂದ ತಡೆ ಹಿಡಿಯಲಾಗಿದೆ. So there is no grant in favor of the petitioner's father, my lord, even as per the documents produced by them.
So which is that no final decision was taken.
No decision was taken, my lord.
so, my lord, let there
Now,
be a direction to decide
without
on my
obtaining
application, my
Saguali
lord.
Chiti, they get the khata made out. Now, my lord, they have given a representation. We have said, insofar as inheritance khata is concerned, we cannot make it out because there is already a
Okay,
rejection.
so now so far as this proceedings, you hear them and you pass orders.
Please, my lord, whatever proceedings that were referred to in these, let them produce those orders, my lord, and we will process it in accordance with law. With their representation, let them produce those.
That is the proceedings before the committee.
Before the committee, my lord. As of now, let them give a representation, including those proceedings they were referring
Very well,
to.
my lord, I'll.
Yes. The petitioner has sought for of writ of Mandamus. Respondent number 2 to consider representation dated 28/11/24 and grant Sagoli chit with respect to land measuring 32 guntas in survey number 58 of
As per my application, Annexure B, my lord.
Bhaktarahalli village, Kaspa Hogli, Hoskote Taluk, Bangalore Rural District. Full stop. Petitioner submits that they made an application for regularization of unauthorized.
Annexure B is the application, my lord.
And
Page 30.
copy of the application in form 50 was made. It's further submitted that though mutation has been entered, however, they sought for transfer of kata upon the death of their father. The authorities have taken a stand, which is now placed before the court by the government advocate, that the application for regularization has been pending before the Committee for Regularization of Unauthorized Cultivation. Full stop. AGA submits that in terms of the proceedings produced by the petitioner at Annexure C,
See, my lord.
C itself would indicate that no decision was taken as regards the application in light of a case that is pending. It is submitted that if this aspect of pending case is clarified by the petitioner, the committee would be in a position to take an appropriate decision, and subsequently other requests of the petitioner would then be considered. Full stop. In light of such stand by learned AGA, the petition itself could be disposed of, directing. Now, is there a committee there now? No.
Committee will have to be constituted, my lord. Committee will have, there is a committee. Please, my lord, there is a committee.
In light of the petition itself could be disposed of in terms of the following. Now, you include the committee as an additional respondent.
I'll amend.
Petitioner, ಮೇಲೆ ಬಂದ್ವಿ order sheet ಅಲ್ಲಿ. Petitioners makes a request to array the committee for regularization of unauthorized occupation as an additional respondent. Oral request is acceded to. AG accepts notice for the said respondent. Necessary amendment to be carried out. The following. The petitioner to appear before the third respondent, newly added third respondent, within date code 2 weeks on 10th of December. The petitioner to clarify in writing as to the observation made in the committee regarding pendency of case. Upon such clarification being made and made the committee to take an appropriate decision. Next. In the event the committee passes an order in the affirmative as regards the application of the petitioner, the other requests of the petitioner may be considered appropriately as made in the presented petition. Accordingly, petition is disposed of. Committee to take an appropriate decision within a period not later than 3 months.
My lord, insofar as the 10th December is concerned, could your lordships extend it to be placed before the committee?
22nd. Yes.
38.
Much obliged.
38.
My lord, I appear for the petitioner. My lord, the land grant committee, my lord, has granted the land as per Annexure A at page 13. My lord, your lordship will page 13, my lord, Annexure A.
Yes.
My lord, the item number 6, Raghu, my lord, he has been granted the sanction grant by the land committee, my lord, on 1 acre 3 guntas. Then, my lord, the survey has been conducted, identify the land, and the annexure B at page 15. Survey of the land.
Just 1 minute. Yes, government.
Lord, we have now initiated 108K proceedings in this matter and are seeking cancellation because it comes within 5 kilometers of the Ramnagara town.
You furnish a copy to the petitioner.
My lord, it is not it is a Halli Mala, my lord, in survey number 66 it was granted. My lord, now after it is the village survey number has been granted to me. Not now. The land
Anyhow,
grant,
just have a look at this. Have a look at it.
Yes,
They've
my
given some proceedings. You have a look at it. EGA files memo along with the communication of the Tahsildar petitioner to have a say regarding that list week after next.
my lord, the Tahsildar himself has recommended a land for the issuing of it. Anyway, I'll look into that, my lord.
But have a look at it. Yes.
Yes. My lord, may I fix a date, my lord, otherwise I can.
2 weeks admin.
One ದಿವಸ fix ಮಾಡಿದ್ರು.
15.
Please, my lords, much obliged.
Lord, I seek a week's time.
At request.
Lord, here the endorsement was given.
Yes, this endorsement copy is
Endorsement has been
to
given
me.
and submitted on the last date. 19/8/2025, we have said, my lord, that he is not in possession of these lands. We have given that endorsement. I'll just hand over a copy again.
Copy is given to me on the last occasion itself. I had asked my client to be,
No, but you will have to challenge this now.
my lord, one more thing is whether the Akrama Sakrama committee is the competent authority or
Correct,
the
but here,
Yes.
is under 108 triple C.
108
Triple C, clause 3, these orders are passed.
Please.
Wherein in case of ineligible application, under rule 108 triple C 3, they reject it, saying it's ineligible. If it passes scrutiny, they place before the committee. So this you will have to separately challenge.
1 week time.
Monday. This is the matter in the same stage on Monday.
There is an interim order, my lord, not to discuss. Till then,
Interim order
there is an
extended till the next day. Yes.
Number 40.
Petitioner, challenging the order passed by the first respondent, 79A and B, my lord.
Yes.
15 CLD.
The petitioner has other formats. Format 79AB. The petitioner has called in question the correctness of the order passed at Annexure B dated 24/9/2018. In terms of the order at Annexure B, the Assistant Commissioner has recorded a finding that there has been violation of provisions of Land Reforms Act under 79A and B. And directed vesting of land in the government, with further direction that all revenue records be entered in the name of the government. Full stop. It is to be noticed that the Karnataka land reforms repeat para 4. Repeat para 4. Ali annexure E badlu annexure B. Petitioner to be present before the Assistant Commissioner without further notice on 2 weeks. 10/12/2025. Disposed.
Number 41.
WP 28021 of 25.
Number 41. Naveen Jain.
The issue involved in this case is, my lordship, whether the non-alienation of period will start from the date of order or from the date of issuance of sagologity, your lordship. The last date of hearing, your lordship, directed me to find out any judgments of the division benches. I pass on, your lordship. What's the first judgment, my lordship, 1983, SEC online Karnataka 3. Lordship may come to para 29.
No, what are the facts?
What's the facts in this case is, my lordship. Lordship, Annexure C, page 25. The provisional Grant order was made on 27/9/1993, Your Lordship. Page 25, Your Lordship.
Provisional grant was made on
27/9/1993. Annexure C, page 25, Your Lordship.
yes.
Your Lordship, the Sagoli cheat is at page 31, Your Lordship. That was in the year 2018 and 19, but no date is referred. But they refer to the decision of the committee, page 31, Your Lordship. They refer to the decision of the committee, that is 22/5/1993. And my Lordship, the condition at page 32, condition number 7. ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಈ ಲಗಾಯಿತು 25 ವರ್ಷ ಕಾಲ.
Condition
number 7 in page 32. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಈ ಲಗಾಯಿತು 25 ವರ್ಷಗಳ ಕಾಲ ಪರಭಾರೆ ಮಾಡುವಂತಿಲ್ಲ.
Yes.
Sought for relaxation of this condition. And I produced the judgment, Your Lordship, at page 56.
So from 93, 25 years means?
93, 2003. Lordship, but
over.
It is over, my Lordship. That is my contention. 25 years is already
Then why
over.
are you challenging it?
But the
Provisional
non-alienation is from the 2018 and 19, it is 25 years, not from the 92, Your Lordship. That is the condition.
93, it was provisional, my lord. It's been made permanent as per annexure E.
So when were you put in possession?
Lordship, in the 92, Your Lordship.
You were put in possession.
Please, Your Lordship. Kindly see the page 25, the relevant typed copy. Page 26 is the typed copy, Your Lordship. ಚಿಕ್ಕಮಗಳೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಅರಶಿನಗುಪ್ಪೆ ಗ್ರಾಮದ ವಾಸಿ ಸ್ವಯಂಸೋ ಇವರು ಅನುಬಂಧದಲ್ಲಿ ಕಾಣಿಸಿದ ಬಗರ್ ಹುಕುಂ ಸಾಗುವಳಿ ಮಾಡಿರುವುದಾಗಿ ಸದರಿ ಜಮೀನನ್ನು ತಾಲೂಕು ಬಗರ್ ಹುಕುಂ ಸಾಗುವಳಿ ಸಕ್ರಮ ಸಮಿತಿಯ ಸಕ್ರಮಗೊಳಿಸುವ ಆದೇಶ. Annexure C, Your Lordship, page 26, the typed copy.
Yes.
ಸಾಗುವಳಿ ಸಕ್ರಮ ಸಮಿತಿಯ ಸಕ್ರಮಗೊಳಿಸಲು ಆದೇಶಪಟ್ಟಿರುವ ಮೇರೆಗೆ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಸೂಚನೆ ಕ್ರಮಾಂಕ RD 13 LP 91 ಬೆಂಗಳೂರು ದಿನಾಂಕ 9/4/91 ಮೇಲೆಗೆ ಮತ್ತು ಅದರಲ್ಲಿ ನಮೂದಿತ ಷರತ್ತುಗೊಳಪಟ್ಟು ಈ ಕೆಳಗಿನ ಷರತ್ತುಗಳಿಗೆ ಒಳಪಡಿಸಿ ತಾತ್ಕಾಲಿಕವಾಗಿ ಮಂಜೂರು ಮಾಡಲ್ಪಟ್ಟಿದೆ. ಒನ್ ಆಫ್ ದಿ ಕಂಡೀಷನ್, ಫಸ್ಟ್ ಕಂಡೀಷನ್, ಭೂ ಮಂಜೂರಾತಿಯು ತಾತ್ಕಾಲಿಕವಾಗಿದ್ದು ತಹಸೀಲ್ದಾರ್ ಅವರು ಸ್ಥಿರೀಕರಣಗೊಳಪಟ್ಟಿರುತ್ತದೆ. ಕಾಯಂ ಸಾಗುವಳಿ ಚೀಟುವರೆಗೂ ಮಂಜೂರುದಾರರಿಗೆ ಜಮೀನಿನ ಹಕ್ಕು ಇರುವುದಿಲ್ಲ. The possession is handed over in the year 1993, Your Lordship. But, my Lordship, the condition of non-alienation is from the year 2018 and 19, as per annexure E, 25 years.
You're correct, but then they'll have to take their stand. They have to take their stand in writing.
And I have produced the Lordship judgment at annexure J, page 56. And also, Your Lordship directed me to find out any division bench judgments. Lordship, para 29, Your Lordship, in the first judgment, 1983, SCC online phase 3. Para 29, the issue was framed. Lordship, para 29, issue number 4, Your Lordship. Whether the period of non-alienation should be computed from the date of grant or from the date of issuance of grant certificate to the grantee. The finding to the said issue is at paragraph 81, Your Lordship, may can be. Paragraph 81 onwards, Your Lordship. Married, it is only 2 paragraphs. The Land Council for the petitioner have alleged that wherever the rules read the date of grant, in particular in respect of rules that were in force in old Mysore area before 1960, the period of non-alienation should be computed from the date of grant only and not from the date of issue of grant certificate to the grantee. An application made to the grantee before the competent officer, the same is proceeded by him. Thereafter, an order has been made him or appellate or the revisional authority that deals with the same. When a grant is made, a grant certificate, a title deed, or a sagwal chit is issued to the grantee, demarcating the extent and the boundary of the land granted to him. Without such a grant certificate or title deed, the grantee cannot enter on the land and cultivate the same, though there is a grant order in his favor. A grant and a grant certificate cannot be treated as a two different and distinct matter. This divorced from each other. Without the grant certificate, the grant is not really effectuated. From this, it is followed that construction suggested by the Land Council for the petitioners and the rules, and more so, Rule 43B5 of Mysore Land Revenue Rules before their amendment in 1960 is too literal and will not carry out the scheme and objectives.
Now you must take your stand.
Please, Madam.
Let them complete their instruction. Objections, if any, to be filed within 2 weeks from today. Land Council for the petitioner submits that the period of non-alienation must count from the date of the provisional grant on 27/9/1993 and not from the date when the Sagoli chit came to be issued in 2018-19. Government to take their stand in writing within 2 weeks from today. Yes.
Fix any date, Your Lordship.
42,
Let them file, then you move it. Will.
42 Jason.
Petitioner, my lord. I'll require 2 weeks time, my lord, to file my objections. My lord, I have no objections, but my lord, in the interim, my lord, I may be protected from, my lord, the state transferring that 4 acres. There are no lands there, my lord. My lord, they've been transferred to, my lord, the Vakaliga Sangha.
It's
My
not,
lord, there's some other trust.
it's not being transferred.
My lord, there's been no such. 4 acres is not available in that survey.
Let them take a stand in writing. Wilson. State government to take the stand in writing within 2 weeks. This is the
My lord,
matter thereafter.
My lord, some interim protection may be granted.
So they're saying there's no land there. How I can give something?
My lord, insofar as the
Now let us see. Let them take the stand in writing, and then we'll consider what we could do.
My lord, my only concern is, my lord, that this fact of the matter is Vakaligra Sangha and that there was a Golden Education Trust, Golden Valley Education Trust. My lord, that matter has already been determined at the Supreme
So
Court.
let them take the stand in writing. We'll see how to mold relief. What is the developments? We'll see.
Let them at the very least not encumber that land any further, my lord. That's all I'm
Let them
asking
take
for.
the stand writing. We'll see. The consideration of interim prayer is kept open to be considered once the state government takes their stand in writing. Yes.
43, Sripal.
My lord, a date may be fixed, my lord.
Let us see. Yes.
Petition 43,
This, my lord, there's no land left to be allotted. I'll hand over the endorsement at 2:30, my lord. The request for a pass over.
Paso.
44. Serial number 44.
For the petitioner, seek for a pass over in this matter, my lords.
My lord, in this, hand over an endorsement. There are about 4 factions fighting over this land. Petitioner seeks for Podi. Now, my lord, there are 26 acres of land which they claim consolidated, my lord, between these 4 persons. But there is only 13 acres of land available there. So, as and when we go to Podi the land, my lord, someone or the other comes and disrupts it. So, we're unable to, my lord, Podi this land. These factions, my lord, and their
My lord, the issue with respect to title has already been decided, my lords.
Worship was to see the last paragraph.
ನಂಬರ್ ಬಂದಿದೆ ನಮ್ದು ಒಂದು ಇಟ್ಟಿದೆ
ವಾಟ್ಸಪ್ ಬಂದ
ಪಿಟಿಷನ್ ಕಾಪಿ ಅಂಡ್ ವಾಟ್ಸಪ್
They've said they're going to take action after looking into the records.
My lords, that issue
Look
has
at the
already
last
been
paragraph.
decided, my lords.
Look at the last paragraph. You read it. ಸಂಪೂರ್ಣ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಿದೆ. Read.
I'll seek instructions, my lord, may be taken up on another date. Senior counsel will appear in this matter.
No, they've said they'll do it. They'll do it after looking into the records. AGA along with the memo Files. The order of the Tahsildar, proceedings of the Tahsildar. Petitioner submits that they would take the stand regarding the same list after 2
May I
weeks.
make a mention in this matter, my lord?
Huh.
Lord, I've also, my lord, interested in this land, my lord. What has happened, my lord? I've approached before this court and asked for Podi. This court has already directed the officials to do Podi in my matter. The petitioners have written, don't leave the officials to make the Podi in our matters, my lord. Now, my lord, I'm also interested in this matter. I also implead in this matter, my lord, to assist, my lord.
Whatever you want, you do. Let us see.
Yes.
Now they've said they will look into and do.
Yes.
So you take your stand.
Yes.
Request for a date to be fixed.
45.
Let us see. Now you have a look at it.
Similar petition in serial number 47, my lords.
Huh?
Serial number 47.
7 is also similar.
Similar
matter, my lord.
petition.
We'll link this
Yes,
link
ma'am.
47 to be called along with 44.
Request for a date, my lords. Date
2
may be
weeks
fixed.
Armil Day. 6th of January. Yes.
I appear for the petitioners in this matter, my lords. Process is paid, my lord. The notice yet to be served on the complainant, my lord, who is the 5th respondent. On the previous date, my lords were pleased to stay the impugned orders at annexure A, B, and C.
Office to put up report regarding notice to R5. List after 2 weeks. Next.
Interim order may kindly be extended.
Order in operation extended till the next date.
For the petitioners, my lords.
Yes.
The government has served the copy just now, my lords. We'll just look into it and make the submissions next week, my lords.
File a memo, my lord, endorsement issued to the petitioner by the Tehsil. Copy has been served on the petitioner. In consideration of the representation which is there.
You have to challenge this. Isn't it?
Yes, I'll just take the instruction from the senior. I'll just next week, any date, my lords.
Monday.
Yes, my
AGA,
lords.
files copy of endorsement. But what is there? Once endorsement is filed, you have to challenge it, isn't it? Why give another date?
Monday I'll make submission.
This is the matter in fresh matters list on Monday.
Acha.
47, I think, 48. Adhe Narayana.
Petition. Non-consideration of representation made by the petitioner to change the kata and mutation, RTC and mutation. In spite of the DC direction, Tahsildar made.
Yes.
Suit pending. Suit pending in this.
That is all discussed in the earlier orders. I have not sought to made revenue records in the name of petitioner. It is sought to made the revenue records in the name of my father, Munikavirappa, son of Chinnappa. It is
Take this
originally.
matter on Tuesday, on Thursday, my lord. Thursday.
First on the AGA on
Thursday.
49. Chandrasekhar C.
Apply for call podium lord to consider my representation annexure C, please, lord. Only Mandamus, please.
My lord, this is the petitioner has filed an application under the scheme of Swalam self-Podi, my lord. That application now, when the petitioner applies, as per the circular, my lord, I'll file a copy of that on the next date of hearing. They have to give the coordinates of their property themselves. Now, thereafter, the department uploads a copy of the sketch, pursuant to which they'll have to demarcate their property, my lord, because it's a self-Podi. That demarcation has to happen from the side of the petitioner, which is pending in the petitioner's login as of now. We can only proceed further after they demarcate their.
Lord, I'll cooperate, lord, what?
Just find correct.
It's an online one, I'll
Now
explain.
you find out. I'll have it next week.
Please.
You find out what is the procedure to be followed. You undertake that, we'll dispose it.
With the I understand, lord.
So just find out what they are saying, how it must be done, etc. And get instructions. Next date we'll dispose it.
But if I make one submission, but subject to what you lodge, but I'll cooperate and I'll follow the instructions of the authorities, whatever it is, Lord. With that direction, Lord, I maybe dispose of, because in fact, yesterday also we have approached the concerned person. They said so within a time we will do it if the court fixed, Lord.
My lord,
With
they have.
I'll follow the instructions, whatever it is. The
At this stage, they have two options, my lord. Once now we have uploaded something similar to this, my lord. I'm not able to produce it. So they'll have to demarcate their property within this sketch.
So we'll
At
refer,
that-
correct, so we'll refer to that circular and ask them to complete their part of the, to
Follow the
adhere to
instructions.
the directions of the circular. So if you give the circular number, we'll refer to it and we'll dispose it.
See,
He already has met somebody in the office.
please,
So he said, ನೀವು ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬನ್ನಿ ನಾನು ಮಾಡ್ಬಿಡ್ತೀನಿ. So he's saying ನೀವು ಮಾಡ್ಬಿಡಿ ನಾನು ಮಾಡಿಸ್ಕೊಂತೀನಿ.
In fact, Lord, we have for last 6 months ಇದೇ ಓಡಾಡ್ತಾನೆ ಇದೀವಿ
the
ಅದಕ್ಕೋಸ್ಕರ.
petition, their own.
So in terms of this.
In terms of this circular, my lord. But as of, my lords may record that as of now, the application is pending in the citizens login for their action.
Yes. The petitioner sought for issuance of a writ in the nature of mandamus to direct respondent number 3 and 5 to conduct tatkal Podi in respect to the petitioner's land measuring 2 acres 12 guntas situated at Jinnagara village, Jagigena Hobli, Hoskote Hobli, Bangalore Rural District by considering the online application at Annexure C. Learned Council appearing for the state authority submits that the procedure as contained in the government order dated 22/4/2022 bearing page 2 bearing number COM-E 125 SSC 2022 Bangalore dated 22/4/2022 is required to be adhered to. Full stop. It's further submitted that in terms of the said circular, petitioner's application requires to be completed and the petitioner is to complete his part of duty imposed under circular, in light of which application is pending still in the citizens login.
Please, my lord.
Full stop. It's submitted that if the petitioner were to perform the duties cast upon him in terms of the circular referred to above, further steps would be taken. In light of the same, petition is disposed of.
2 weeks.
50.
That
Because Lord, the problem is Lord, again I have to approach this court, Lord, unless the time stipulation is.
Correct. So you have to complete.
Lord, I'll complete it within a day, Lord, at least from the date of my compliance,
The
because.
condition would be imposed on the state, my lord, if they were not to complete it in accordance, then 2 weeks would be a problem for us.
Lord, 3
My
weeks,
lords
Lord,
may say
because
expeditious-
I'm.
My lords may say at least 3 months, my lord, 3 to 4 months.
If the petitioner were to
Last 1 year, Lord, at least 2 months, Lord, I request.
if the petitioner were to complete his part of the obligation in terms of the circular referred to above, the respondent authorities are to endeavor to complete the process within a period of
4
3
weeks.
months from today.
Please,
Let us see.
My request, because
It's clarified.
I understand.
It's clarified that the period referred to above is only indicative and it's open for the government if all documents and processes are complete to complete the process expeditiously.
Great.
For the petitioner, my lord, this may be kindly passed over, my lord. The senior secretary court.
It won't be disposed of.
We can have it on some.
Similar to what was done in serial number 7 today. 108 triple C, order passed by the Tahsildar,
No, my lord.
can be treated as a report and then.
The
forwarded
senior
to
is
the
held up in court.
Just 1 minute. You will get relief. That the Tahsildar report is to be treated as a
DC page 19.
same order, isn't it?
Same order.
When will you bring him?
Just now.
Huh?
Within 1 hour I will bring him. He's in court hall number 25, my lord.
At 2:30.
2:30, my lord, because-
Much of them.
I will not give passover at 2:30.
No, my.
51. Make it.
Appear for the petition. Lordship, I sought for the man. Your Lordship, as per the court decree,
As per court decree.
Court decree, Your Lordship, myself as well as my vendors also, Your Lordship, they initially filed the, because three brothers, three portion which was, I was entered the agreement. Then court decree has passed to execute the sale deed. For
Yes.
that,
You are seeking kata on the basis of the decree.
yeah.
Lord, this matter, this is called Amrut Mahal Kaval. It's about 5,000 acres, my lord, stretching 3 taluks. Now, my lord, the petitioners are from Chandraipatna district, but the land which they are granted is from Arsikere. Seems to be, my lord, a bogus grant. We'll have to, my lord,
Then you take your stand in
we'll
writing.
take our stand in writing.
AGA submits that they would take the stand in writing. Statement of objections to be filed within 2 weeks. This is the matter in the first week of January. Yes.
52.
For the petition, issue writ of and consider the representation, my lord. The dated 18/2023, my lord.
For?
The consider representation, my lord, to effect the RTC in the name of the petitioner. The annexure B, my lord, Sakura treaty issued by the fourth respondent in the year 2003, my lord. Since
Yeah, my lord,
21
again,
years in the Sakura.
bogus grant. I'll give the endorsement at 2:30.
Passover.
53.
Done for the petitioner. Mandamus, my lord, to implement the order of land grant committee, please, my lord. Annexure E, please, my lord. Page number 17. Annexure E, page number. Wherein land grant committee directed ಮಂಜೂರಾತಿಗಾಗಿ ತೀರ್ಮಾನಿಸಿದೆ ಅಂತ ಪ್ಲೀಸ್ ಮಿಲಾಡ್.
It's up, you are regularized, is it?
ಪ್ಲೀಸ್ ಮಿಲಾಡ್.
Now you are seeking for?
Tahsildar to implement issue Sagwali cheat. To seeking Tahsildar Mandamus direction to Tahsildar issue Sagwali cheat, please.
Find out.
That wherein in page number 17, column number 4, please. Serial number 4, page number 7.
My lord, now for the process of issuance of Saguali Chiti, I had preliminary instruction from the Tehsildar. The petitioner, of course, there's an order for regularization to an extent of 4 acres, 20 guntas, my lord. As of now, the petitioner is only in occupation of 2 acres, 20 guntas. There is another person in the same area who's occupying an extent of 2 odd acres. That person has now filed an application for regularization of unauthorized occupation. That application is also pending. Now the petitioner is seeking for issuance of Saguali Chiti for 4 acres.
Now the
Based on the
proceeding, now in the
recommendation,
proceedings, you have given, you have resolved 4 acres in his name.
Please, my lord. They've been in, but they have not been in possession of the entire extent.
Is it correct?
Place my instructions on record, my lord. These are my instructions.
Annexure D, my lord, sketch is prepared.
Let us see. AGA submits that they would take their stand in writing within 2 weeks. This is the matter in first week of January. No, but then unless you challenge that under 108K, you cannot, once the
They
committee.
are also bound by the pending application, my lord. Now
It was
we don't
pending
have
before.
Mine
Pending
was
been
before.
pending. Those dates I have to
And then
ascertain.
you put it in writing.
Please.
The order was in 2004, please, my lord. He made a subsequent application.
Let them put it in writing, we'll see.
Please.
Yes.
Madam, in preliminary, in please, madam. In
Yes, same stage.
please.
54.
The petitioner, your lordship, seeking for writ of mandamus, directing the respondent to effect the code and duress. Lordship, land was granted in the year 1964. There are 3 portions of land.
Yes.
Lordship,
My lord, the petitioner seeks, there are 3 grants, my lords. We've been only able to trace out 1 file. We'll need some time to verify these records, my lord.
Find out.
My lords may have it after 2 weeks, my lord.
No, lordship.
No, let us see. Let them at least finish it. Let them complete instruction. Then you'll know what your position is. AG request for time. This is the matter in the first week of January. Yes.
In preliminary hearing.
55.
Yes.
55, my lord, survey has been conducted on 19th as per your lordship's directions.
Yes.
The report is getting ready, my lord. Could it be taken up next Wednesday? We'll submit the report.
Yes. AGA submits that in terms of the order of 10/11/2025, a spot survey has been conducted. Report would be filed.
In the presence of the petitioner.
Spot survey has been conducted in
That's
the
what
presence of the petitioner. Report would be filed. Relist the matter in the same stage on.
311.
Yes.
56.
Just for the
Girish.
context, not what had happened. there,
Interim
not-
direction earlier granted would be extended till the next stage.
In the survey, what is outcome? Lordship? We have been handed over a copy also. Lordship, ಅಲ್ಲಿ ಯಾವುದು ಈ ಕಾಲ್ದಾರಿ ಅಂತ ಏನಿತ್ತು, that has been broadened. ಪಕ್ಕದಲ್ಲಿ ಇನ್ನೊಂದು 8 ಅಡಿ ರಸ್ತೆನ 20 ಅಡಿ ರಸ್ತೆ ಮಾಡಿ ಬಿಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ ಹಳ್ಳ ಅಂತ ಏನು ಹೇಳ್ತಾ ಇದ್ರು.
Let us see. Let it
The
come on
municipality has already formed a drain to that effect.
Let
In
us
that
see.
regard.
Let us see.
So that's the outcome of that.
Let us see. Yes.
The petitioner grant certificate has been issued, revenue records are mutated, seeking consideration and representation as per annexure L for conduct Durast and Podi, my lordship. Pursuant to the revenue records stood in the name of the petitioners.
Yes.
To
My
the
lords
grant,
may dispose of the petition for us to 3 months in accordance with law, my lord.
The petitioner
granted land in the year 1980, my
have
lord.
sought for direction to respondent number 4 Tahsildar to consider the representation at annexure L, L1, L2 and L3. The petitioners state that land has been granted in survey number 45
Yes, my lord. 45.
of Bhuvanahally.
45, 45 bar 11, 45 bar 14, 45 bar 17. There are 4 petitioners, my lord.
Petitioners submit that they are residents of Bhuvanahally village, Kaspa Hubli, Hassan Taluk, Hassan district. Full stop. It is submitted that the petitioners have been granted land in 45 in survey number 45, which is subsequently renumbered as 45 bar 11, 45 bar 14, 45 bar 17 and 45 bar 17. Good stuff. It's submitted that subsequently
Revenue records are mutated.
Sagoli chit is issued.
Yes, my lord. Revenue records are mutated, Sagoli chit has been
Sagoli chit has been issued and revenue records have been mutated. Full stop. However, it is submitted that Durast and Podi proceedings are still to be conducted to demarcate the exact boundaries to the petitioner's land, which would enable identification. Representations of the petitioners at annexure
L onwards, my lord.
L, L1, L2, L3 would be considered an appropriate decision action taken within a period of 3 months from receipt of certified copy of the order. In light recording such stand, petition is disposed of.
57, Mohan Kumar.
Petitioner. Yes.
Let's sought for Mandamus Millets as per the release date dated let's 9/7/2025 millets, which is at page number 35. My
Yes.
name has to be mutated in the. My husband has been released the.
Yes.
My lord, there is an order that this land belongs to the temple, my lord, and
Let's see.
during that time, it cannot be mutated in any other name.
Let's kindly come to
Let us
annexure A millets, page number 50.
So we'll see what this endorsement is.
Assessments.
It's an order, my
Order.
lord. Going to.
No, this you have to challenge it.
Yes, millets. Yes, millets. Millets. It has been granted annexure A millets. After that, millets as per this
Correct,
endorsement.
but now they've given an endorsement.
Yes, millets.
So you challenge it, I'll keep.
Millets. And one more request, millets. Millets. They have said the matter is pending before them, millets. I may be permitted to contest that, millets also.
Yes. The petitioner had actually after 5:30 every day these matters preliminary hearing can all of you can sit can ask them to come and whatever only those the rest we can do.
Please,
The petitioners have filed the present writ petition seeking for issuance of writ of mandamus, seeking a direction to respondent number 2 to mutate kata in the petitioner's name in light of the representation dated 18/10/25 at annexure M. Full stop. AGF has filed along with the memo an order passed by the Tahsildar dated 9th September 25. Dated 4/9/25.
4/9.
In light of the order having rejected the claim of the petitioner, petition is disposed of, reserving liberty to the petitioner to challenge the order of the Tahsildar in accordance with law. All contentions of the petitioner are kept open. Full stop.
58.
And millets one
No,
more.
now that liberty is there, I don't have to give it. Now, whatever proceedings are pending, you go implead yourself. I've kept open contentions. All contentions are
Because
kept
now
open.
I got to know this order.
In the it's made clear no, in light of the submission of the petitioner that that the order of the Tahsildar, though dated 4/9/25, has been communicated only on this day. The said aspect to be taken note of in the event of any point of limitation to challenge the order arises. Yes.
Much of
58.
My lord, may I seek a short accommodation in this matter, my lord? I get to receive instructions.
Relist
It's only
on.
Mandamus, my lord.
Let us see.
Why up?
Let us see. Let them finish. We'll pass.
First.
Relist on.
First.
Yes.
59. Mohammed.
Paid for petition. Lord, the matter is listed yesterday, listed again today for similar matter has been passed last occasion. So
This is a notice under challenge
Person challenge,
192 A,
similar
my lord.
common notice.
Lordships have disposed of matters in the same, furnished the number.
Yeah.
yeah.
Mulbaghi.
Yeah. 230. ಇದೆಯಾ 230 230 ಇದೆಯಾ ಕೊಡಿ ಇದೆಯಾ No, this is same, is it?
Yes, my lord. The common
Identical.
notice has been issued to.
This is
So
also
the-
pursuant to the inquiry
Identical.
before the
Yes.
Lokayukta, my lord.
So the same notice was impugned in that.
Yes, my lord.
Identical.
Yes, yes, same content,
petitioner.
what, similar, exact ditto copy has been, only the name has been changed.
Petition is also copy paste.
No,
No, that's okay. Petitioner has challenged the notice at annexure A, which is a notice directing the petitioner to evict himself from the property, feeling which proceedings would be taken under section 192 capital A of the Karnataka Land Revenue Act. Counsel for the petitioner submits as regards notice issued by the Tahsildar Mulbagil, where the notice is identical and petitioner is placed in an identical position as the petitioner in WP 31641 of 2025. The petition has been allowed, and on parity, the same relief may be extended in the present case also. AGA submits that the facts are identical and matter may be disposed of on same terms. Order in WP 31641 of 2025 reads as follows. Entire order. Next. Taking note of parity on facts and position of law, which is not disputed, present petition is disposed of on same terms as extracted above in respect of the order passed in WP 31641 of 2025. Next, accordingly, petition is disposed of. Notice at annexure is set aside. Respondent authorities are at liberty to take appropriate action and follow the procedure as is available under the Act as regards alleged encroachment in accordance with law. Needless to state that the question of disturbing the petitioner's possession would not arise till all proceedings as contemplated and referred to above reach logical and legal finality. Needless to state, any determination of encroachment must be after following principles of natural justice. All contentions are kept open. Yes.
And for the petitioners, my lord.
For respondent 5 and 8.
60.
My lord.
Taken up on Thursday, my lord.
Huh?
Thursday.
Relist at on
Thursday.
27.
Yes.
Interim order shall continue, my lord.
Interim order in WP 890 of 2025 in operation is extended till the next date.
Great, man.
27. 61.
Week's time granted to take necessary steps as regards. What is this?
My lords, annexure F, my lords.
R1 to R3.
The parties who are having, they have got the fake.
No. Who's R1 to R3? Notice must go.
Notice has already gone, my lords.
So we have to wait. Let notice be served.
That's notice already was served in the last hearing date.
No, notice is not served. R1 to R3.
Yes, my lords.
Process
21, 21, 24, I have served the notice, my lords. Before that.
Notice is not served. Week's time granted to pay necessary process. Notice to be issued to R1 to R3. Yes.
62.
9th, my lords.
2 weeks are just after 2 weeks. Yes.
62.
What is this compliance? 6/12/22 order. Just one minute. No, this petition is disposed of. Huh? No, it's only on cost. It's only on cost. No, it's already dismissed. Huh? They've only. No, that's on merits. Now here they were directed to pay costs. It's only come on that. Chamber concern. Our cost is arrears of land revenue and the market disbursement. Huh? Chamber concern. Yes.
63.
Petitioner, Lords, in this
Process.
yes, my Lords, I have to take on R6 and other respond. Am I permitted to serve by hands?
Time granted to take
On,
necessary.
on submission in this matter. They have obtained this last 2 days, they have not appeared. They have obtained the interim order. After obtaining the interim order, they have sold the property. It is the last time I produced the sale dates. Regarding that last 2 hearings, none represented.
Lords, in the
No,
last.
we have not extended the interim order.
Yeah, it is not extended. Because let them,
I was
the matter
permitted
it is
to file
affected by,
application, my
even they have panis, in their panis, they are not entered the writ petition number, Your Honor. In our panis, they have entered the writ petitions number because they have farmed the layout and sold the individual sites. And it is the effect to the, my property is concerned. Your Honor.
Respond number 5 and 6, my Lords, filed a revision petition on sole ground that the notice were not served upon them while conducting the survey, Durast and everything in whole survey number 94. Your Lordship may kindly see for a moment page number 31. Hirappa and MV Suresh, my Lords, their signature are reflected in the said notices. They were very much present in the spot and they were very much aware of everything that has taken place. And after 5 years, they file a revision petition and the JDLR, without considering an application under section 5 of the Limitation Act, passes an order on merits. There is no order as to the limitation, my Lords, condonation of delay. Your Lordship may kindly see page 31, my Lords. That is the notice, my Lords. Survey number 94. Adreli, my Lords. MV Suresh, that is the first signature, who is the revision petitioner number 1 before the JDLR. And my Lords, 6th, my Lords, Hirappa. He is the petition number 2. After 5 years, that the notice were not served upon them. Their signature is clearly seen from the notices. That is the only ground upon which they filed a revision petition after 5 years.
Only a redo of the entire polymer. All of them were not involved in the polymer, and only the part of Podi, and there was an draft which has to be excluded, and pro rata has to be reduced. The extent of grant has to be reduced. That work has been not done in the previous polymer. So the entire work has been redone. Now you have already demarcated.
That you place it on record. You have placed it, is it?
Lords, in the last date of hearing, I was in BC, my Lords. I couldn't log in, my Lords.
I have admitted that they have sold the land despite there was a stay.
Stay on the operation of the order passed by the JDLR, my Lords.
Stay was there despite the order of the JDLR. It was not. They have sold the property. All the other entities of the stay was there. We are not stopped. We have already measurement is there. Our process of assigning a new Podi and new measurement to the new survey number was stalled due to this interim order. Now we can assign a new number. But as of the petition is done greater and we have already developed the land and he has sold the site system, which will also modify the entire plan.
Let's legal.
So, it's a hardship on the purchaser and it's a hardship which will be caused in the other adjacent grantees who are owners, because the exchange will always be reducing for everybody. If they have more, they will that it will be reduced.
My lords, the legality of the order passed by the JDL has to be examined, my lords.
I do accept if they are
Because
not
if-
perfect, if they are not perfect.
My lords, if let them say, undertake that on, when in 2014, the,
They have already conducted some survey, that survey report is
after 5 years, my lords, they want to redo everything, my lords. When every notice was served, everybody has signed the notice, and after 5 years, they have to defeat my rights. There should be some reason, my lords. Okay.
Just wait.
Can.
every person of the grant is we have collected. Thereafter, reduction has to be occurred due to the roads and other excess grant is being made. And in respect of the person, what they have done, the petition here is a member who has occupied some of the extent and he has found the neighborhood. Then we can't leave. But before that itself, this order was passed. Knowing fully that this order was there, this survey would be conducted. He has found the sites, he has sold the sites also. The selling of the site itself has made an illegality in the order of the deportation.
Now, this you place it along with your.
Yes.
I have one copy.
Now you give the details of who all you have sold. Let us see how.
Kindly, my
what
lords, it may be taken up for final hearing.
petitioner to
In this,
place on record details of sale transactions with respect to the property in question. AGA submits that the resurvey has been conducted. You'll file this and has placed the resurvey report on record along with the memo. Same is taken. List after 2 weeks.
I may be permitted to file
Right,
application
maybe.
for extension
date
of
may be
interim
given in
order,
this
my lords.
matter, Your Honor. During the pendency of the revision petition,
The
the
stay was
assistant
granted for the
director
order
of
passed
land
by
records has
JDL, my
submitted
lords.
the report, Your Honor.
Let us see, you have sold, now
There
you
is a-
don't have any locus. You file first, give you information regarding the sale transaction.
Kindly.
Relist.
Cost has to be imposed for disobedience also.
My lords, kindly, my lords,
Yes.
order dated 14/12/2020 to be seen, my lords. If there is any order that is restraining me from selling anything, my lords, I will take, my lords, whatever the
You place
learned
on
friend is
record
saying, my
how
lords.
much you have sold, etc. With
Kindly, my lords.
relist on date code.
Date may be given.
15.
Yes.
Great, my lords.
54, Kumar Ram CM.
ಇದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿಲ್ವಾ ಮಾಡಿಲ್ಲ no representation on behalf of the petitioner and the matter is called out. The order dated 14/11/2025 reads as follows. Next, taking note that the counsel for the petitioner is absent and the matter is called out. Clearly, the petitioner is not diligent in prosecuting the proceeding. Hence, petition is dismissed for non-prosecution.
65,
Same order. Order dated 14/11/25. ಲಾಯರ್ಗಳು ಬೈಕೊಂಬಾರ್ದು 7 ಸತಿ 8 ಸತಿ ನಾವೇನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿಲ್ಲ. ನಾನು ಬರ್ದಿದ್ದೀನಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರ್ದಿದ್ರೆ ಐ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್. ಮಹೇಶ್ ಉಪಿನ್ ನೀವು ಬೈಕೊಂಬಾರ್ದು ಅಂದೆ ಲಾಯರ್ಗಳು. ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ನಾನು ಹೋದ್ ಸತಿ ಬರ್ದಿರ್ತೀನಿ, ನೀವು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರ್ದಿದ್ರೆ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸ್ಮಿಸ್ ಇಟ್. From the first, if you don't comply 7-8 times, then I have no option.
66 Sanchan.
Same order. Same order. Order dated Hakpide.
67,
I appear for actually amended cost title I have filed, my lord. I have to carry out the amendment. A week's time may be granted.
Week's time granted. Petitioner is permitted to carry out amendment in the main petition.
66 seems to
67 seems to be infructuous. Huh? Is what I was told. Seems to be
Mandamus in this matter.
Component number 5. Will be passed. Huh? So date
9.
Yes.
9.
68.
68.2, my lord, I appear for the petitioner, my lord.
Number 5 and 6. Respondent number 8 by me.
Now 68 steps must be taken, isn't it?
Yes.
So R27.
10 and 22.
Huh?
Are 10 and 22 ಒಂದು connected matter first appeal ಅಲ್ಲಿ
So just one by one will you. Now in 68 notice to R27 on IA 1 of 24.
Yes.
Week's time granted to take necessary steps as regards R27 on IA 1 of 24 in 68. 68.1.
Not appearing for the petitioner, my lord. Take steps to the respondent number 9 and 16, my lord. I'll do.
Petitioner submits this step would be taken for issuance of notice to R9
And 16.
R16. What about this
I'll comply the office objection during course of the day, my lord.
office objections to be complied on IA number 2 of 24, 3 of 24 and 4 of 24 within 1 week.
Obliged.
That IA is good. Now the notice must go, is it? Council. Notice must go on the said IA.
Said IA also, my lord.
Huh?
IA ದು ಹೋಗ್ಬೇಕು ಮತ್ತೆ ಇದರದ್ದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9 and 16 ಅವರಿಗೂ ಹೋಗ್ಬೇಕು.
The IA 2.
IA 2 it is for the after that I have recognized, my lord, the delay of the application filed.
Huh?
Application for condonation of delay to bring an LRs, my lord.
Notice must go on these IAs.
Yes, my lord.
After you comply.
Yes.
If office objections are complied on the said applications, notice to be issued on IA 2 of 24, 3 of 24 and 4 of 24. Is 68.2?
68.2, my lord, I have taken steps already, my lord, to bring LRs on record. Respondent 10 and 21 had passed away. I have already taken steps, my lord. Notice.
So notice must go.
Awesome. Yes, yes.
But you just comply with the office objections. Once
Yes,
office objections are complied on IA 1 of 25 and 2 of 25, notice to be issued on the said applications.
Much
in 68.2. Yes. 2 weeks time is granted in 68. 2 weeks time is granted for taking steps to deceased R19 and R23 in 68.3. Yes. Next. Weeks time 68.4. Weeks time granted to take necessary steps for issuance of notice to R5, 16, 21, 22, 23, 24, 4, 6, 9, 13 to 15 and 29 cause listed. Yes.
69.
Interim order may kindly be extended.
Interim orders in operation are extended to the next date.
69.
The same order. Dismissal. Dated 14/11/25 reads as here.
70.
Respond number 12 and 13 in this case.
Weeks time granted for issuance of notice to R7. Petitioner to take steps as regards deceased R4, R5, 14 to 19 within 10 days from today. Next.
71.
Much obliged.
In so far as
application
notice to R9A to R9E. refused. ಇಲ್ಲ 4 ಜನ ಇದೆ. R9A to R9E. In light of the postal tracking report indicating notice to R9A to R9E has been refused. Notice is held sufficient. Office to show the name of said respondents is served in the cause list. Office to put up report regarding notice issued to R9F.
ಅದು ರಿಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ R9F
ಕೊಡಿ
ತಗೊಂಡಿದ್ದು.
ಕೊಡಿ.
ಅದು ಟ್ರ್ಯಾಕಿಂಗ್ ಐಡಿ ತಪ್ಪಾಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಆಗ ಇದ್ರಲ್ಲಿ ನಾವು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ವಿ.
Counsel for the petitioner ಇದನ್ನೇ ತಗೋಬಹುದು. Office to check ಅಂತೀವಿ. Counsel for the petitioner along with the memo submits that notice to R9F has also been refused. The tracking report enclosed along with the memo to be verified by the office.
Yes.
Yes.
72.
Specific on date.
72.
Specific on date.
ಇದು 71 date ಕೊಡಿ.
72.
For the petitioner. Office to put up report regarding notice.
Your permission may be given for substitute service, my lord.
R5. How many times you have taken?
The hand summons has been returned, my
No,
lord.
how many times you have taken? After 3
The
times?
first time for substitute service. my
3 times you take, then I'll permit you. For petitioner is permitted to
lord. Hand
take
summons
out.
has been returned last week, my lord.
No, correct. Petitioner is permitted to take out fresh notice to R5 as well. Next.
73.
Maybe interim order may be extended, my lord.
73 modern office extended to the next date.
On the respondent number 5, Lord, there is some urgency in the matter. I have filed an application for vacating stay.
Yes.
The last may kindly see Lord, photograph page number 34 of my application. Work is under progress, my lord. At that stage, my lord, order to maintain status quo obtained. In page 34, my lord, you last may kindly see.
34.
I am. I am for vacating. ಅದಲ್ಲ ಇನ್ನೊಂದು
ಅವ್ರ ಐ ಕಾಪಿ ನೋಡಿ ಮಂಜುಳ ಅವ್ರ ಐ ಕಾಪಿ
WP 23830.
Okay. Connected.
Ink page 34.
So now what are the two writs?
Now the government has to place the statement of objection in respect of survey number 80.
Need another 10 days, my lord.
Huh?
I need 10 days.
But my problem is that Lord, tender is awarded.
Correct, but now at least government must take that stand. Isn't it?
But work is under progress, Lord. Material is dumped there. If third person comes and theft is committed, Lord.
ಅಲ್ಲ ಆಯ್ತು, I'll give. When will you file? When you
Date
want?
be fixed, my lord. I'll file it on
ಅಲ್ಲ ಇದು ಸ್ವಚ್ಛ ಭಾರತ್ ಮಿಷನ್ ಯೋಜನೆ ಕೆಳಗೆ ಮಾಡ್ತಾ ಇರೋದು.
6th, my lord.
AGA submits the stand in writing would be taken positively by 6th. Accordingly, relist the matter on 6th. On that day we'll take it up, same stage.
Interim order may be.
Pending disposal, subject to result of writ petition, we may be
So we have to
permitted to
hear
go on.
now, he's asking you, if the state takes their stand, it will help you or him. Either way, let us.
ಅಲ್ಲ ಅವ್ರದೇ ಕೆಲಸ ನಾವು ಮಾಡ್ತಾ ಇದೀವಿ ಅವ್ರು.
ಏನ್ ಮಾಡೋದು ನೋಡೋಣ. Interim order and operation extended to the next day.
74.
You sit on the government side and get it done. Let them at least take their stand. A memo filed by the petitioner reads as hereunder. In light of the same, petition is dismissed as not pressed. Liberty is reserved to take appropriate action as regards the impugned proceedings. Yes.
75.
Sorry, my lord, dismiss for default. Recalling the order.
I have filed application in the December itself, but in spite of my memos, the registry has not posted, whether it was posted before roster bench or a particular judge.
ನಾವೇ ಮಾಡ್ಬೋದಾ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತೀವಿ. ಇದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅದ ನೋಡು ಚೆಕ್ ಮಾಡು. You have not of non-compliance ಅಲ್ಲ.
Not on, it is posted in B group.
Who appears for the other side?
Other side is government.
No, private parties?
Private parties also. They have served and represented.
It's about 1 year, that's why I'm wondering whether notice must go to them.
Why I am telling, because I have filed in time only.
No, correct.
But what registry says is I have filed even before that, the particular judge only. But
that we'll see. But the other side must be notified. It's more than 1 year. Tomorrow they should not come up and say that it was recalled without notice to us. I'll have it next week. You serve another copy of the IA to the council for the respondents.
Government I have served.
Government, okay. The other parties, other councils. Relist the petitioner to serve IA 1 of 24 to the council for the respondents. Once again, relist on.
Date.
Sorry, my lordship, serial number 31, my lordship. I am held up in other court, my lordship. Matter will be adjourned. Writ of Mandamus, my lordship, serial number 31, my lordship. Urgency is there. Copy has been served, sir, my lordship. Banned. ಅರ್ಜೆನ್ಸಿ ಅಂತ
ಸೈಟ್ ಆಗಿ ಹೋಗಿರುತ್ತೆ.
ಮೆಮೋ ಏನಂತ ಸರ್? ಅರ್ಜೆನ್ಸಿ ಅಂತ ಬರ್ಕೊಡಿ. ನಾಳೆಗೆ
ನಿಮ್ಮ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು? 31 ಅಲ್ವಾ?
ಮೇಡಮ್ ಯಾವ ಚೇಂಬರು?
ಸರ್ ಅರ್ಜೆನ್ಸಿಗೆ ಮೆಮೋ ಕೊಡ.
Court officer. Sir. Court officer. Sir, ಕೇಳಿಸ್ತಿದ್ಯಾ? Court officer.
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್, ಫೋನಲ್ಲಿ ಮಾತಾಡ್ತಾರೆ.
ಹಾ. Court officer. Sir. Court officer? Sir? Sir, court officer?
Pass over.
One submission. Item number 68 is urgent for taking. Interim order is not extended. Item number 68. Interim order, first matter, interim order will be extended.
68.
68.
68, the interim order and operation.
68 and 68.3.
68 and 68 point?
68 on 68.
68.
Mr.
Lordship, on the matter for end of additional survey is scheduled tomorrow. There will serve additional sets to government also. For end of.
Morning you moved, no?
Oh, yes, ma'am.
Huh?
Morning I moved.
Huh.
Pass over matters. Serial number 3, S. Rajshekhar, Ravishankar Shastri.
Yes. Government. Yes, someone.
Serial number 3. List one.
3 months. 3 months. The petition filed. The petition has been filed seeking to set aside order dated 25/3/2025 passed on IA number 8 in Revenue Appeal 447 of 2021 passed by the KAT. By virtue of the said order, the interim order of stay granted on 15/12/2022 came to be vacated.
Yes.
After hearing the matter for some time, noticing that the appeal, that the revenue appeal, what's it? Revenue appeal.
Revenue.
Revenue appeal is pending consideration. Any order passed regarding the correctness of order on IA number 8 would have the effect of making certain observations which may prejudice proceedings before the Karnataka Appellate Tribunal while hearing the main appeal. Accordingly, it would be appropriate to direct the Karnataka Appellate Tribunal to dispose of the main appeal itself within a period of 3 months. All contentions of both sides are kept open. Yes.
Serial number 6, Srinivas KN.
Let the petitioner
So take out notice.
unauthorized occupation.
Take out notice. AGA is directed to accept notice for respondents 1 to 4. Emergent notice to the private respondents.
Let one submission be let because she is in position from last more than 4 decades.
So correct, but there are series of civil suits
Not
pending.
to dispose of stake.
So the series of civil suits, I'll consider that on appearance of them. Let them appear, I'll consider further relief. Because there are civil suits pending.
Yes, pending minute.
Let us see. Yes.
29, serial number 29. Basavaraju KT.
Petition is
Yes.
29, my lord. The rejection by the committee was submitted. Entry number, my lord, 72 is the entry of the petitioner itself.
Petitioners.
We will approach the
74, I'm sorry. Entry 72, he makes an application for survey number 74. It's in page number 101.
Serial number 72.
72. Yes. He makes an application for 74. His application number is 5301.
Yes.
but he's in possession of survey number 40 and not survey number 74. We've rejected it.
The petitioner has sought for issuance of writ writ of mandamus to direct respondents to consider representation regarding passing of orders as regards his application for regularization of unauthorized occupation. Full stop. PGA, along with the memo, files proceedings of the regularization committee and submits that the application of the petitioner has been rejected. Full stop. In light of the same, the petitioner is reserved liberty to take out appropriate proceedings as regards such order in accordance with law. All contentions are kept open.
Please.
Accordingly, petition is disposed of.
43.
43, my lord, will give the endorsement tomorrow.
Petition.
Relist tomorrow.
Please.
The fresh matters list.
50. Rajaram, yes. 50.
Please. The petitioner has been in possession and enjoying the property as unauthorized occupants, my lord. Filed application under section 57. And matter is pending before the concerned authority, my lord. The property reserved for Ambedkar Bhavan at page number 22, my lord, by the annexure B. Page 22, my lord.
Yes, you'll have to find out what.
No, my lord, this is an allotment which is subsequently done. The rejection is done by the Tahsildar. We can keep annexure B in abeyance till, my lord, the deputy commissioner decides on the report at annexure A.
Very similar order already stayed, my lord, by this court.
Annexure B?
Annexure B is an allotment done to someone else. Land has now been allotted to someone else. A is, my lord, the endorsement given by the Tahsildar considering the application under Form 57. That he should have done, my lord, by submitting a report to the deputy commissioner under 108CCC.
Correct.
That is not done. Your lordship so to direct, my lord, this to be treated as a report.
Correct.
And till then, let, my lord, B be kept in abeyance.
But they have not made B as a party only.
They have not made B as a party.
Anyhow, I'll dispose it of, reserving liberty for you to take a decision. Please. The
In fact, my
petitioner.
lord, annexure B has already been stayed. The very similar order has been stayed by this court, my lord. It may be connected along with that, my lord.
No, anyhow, you have not challenged B. We can't pass order at B without hearing that beneficiary.
challenge.
Where have you made them a party? How can we pass an order without hearing them? I'll set aside A. A is to be treated as a report. Let the deputy commissioner take a decision.
DC.
Tahsildar cannot reject.
No, deputy commissioner is the party, my lord.
So that is with regard to allotment to Ambedkar Bhavan.
Correct.
That's not with regard to considering the.
Annexure B is which is passed by deputy commissioner. Deputy commissioner is the party, my lord.
Who's the beneficiary? Now, annexure A, I'll treat it as a report.
Kindly permit
Let
me
the
to.
deputy commissioner take a decision. Under 108 CCC subclause 3, the Tahsildar cannot take a decision. It's for the DC to take a decision whether it's ineligible. This is only to be treated as a report. And let the DC take an appropriate decision. You will be entitled to place your stand regarding the Tahsildar's report before the DC.
Please, but prior to that, my lord, annexure A is contrary to annexure H order of the annexure H, my lord. Can you turn annexure H? ಜಯಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 227ರಿಂದ ಮೈಸೂರು ಟೌನ್ ಹಾಲ್ ವರೆಗೆ 19 ಕಿಲೋಮೀಟರ್, which they are saying.
No, correct.
Yes, annexure A.
No, I'll allow you.
Please.
Insofar as the Tahsildar report.
Please.
Under 108 triple C 3, the DC will have to take a decision if it's ineligible. I'll allow you to place your case before the DC. The petitioner is aggrieved by the endorsement at annexure A. Issued by the Tahsildar. It is noticed that the petitioner's application for regularization submitted in Form 57 was under consideration, and the Tahsildar at annexure A has made certain observations that the land is within the distance of 10 kilometers from the limits of the Mysore Mahanagara Palike, and accordingly has passed an order rejecting the application for regularization. Full stop. Next, it must be noticed that under Rule 108 triple C 3 of the Karnataka Land Revenue Rules, a decision as regards ineligible application can be taken only by the Deputy Commissioner. Full stop. The Tahsildar, upon report of officers concerned, can place a report to the DC for appropriate decision. If that were to be so, the annexure A, which is an order closing the petitioner's application, would be impermissible. It would be appropriate in the circumstances, however, taking note of the contents of annexure A, that annexure A would be treated as a report made to the Deputy Commissioner. Tahsildar to forward the same to the Deputy Commissioner. It's the Deputy Commissioner who has to take a final decision in terms of 108 triple C 3 of the land revenue rules. Petitioner would submit that the report of Tahsildar is contrary to annexure G, annexure H, and raises other submissions as well. The petitioner is also at liberty to place his stand as regards the Tahsildar's report before the DC, after which the DC may take an appropriate decision. In terms of the same, petition is disposed of. All contentions are kept open. Petitioner to place his stand before the DC within a period of 2 weeks from receipt of certified copy of the order, and it is only thereafter DC may take an appropriate decision.
There is no opportunity of being heard before the DC.
Correct, but now anyhow, since we are treating it as a report, needless to state, the procedure of hearing the petitioner, which otherwise under normal circumstances would not be afforded, is being afforded as the order at annexure A is being treated as a report.
Please, my lord. One more submission, my lord. Annexure B may be
no, that anyhow it's a part of the other petition.
Keep in abeyance, my lord, or otherwise, if
you say it's in challenge there, I've left open contention. So
one sentence may be added, my lord. One sentence may be added, my lord.
No, that we'll see that separately now.
In regarding annexure B,
under land grant rules, rule 5(3), that says categories, how much of public, private, etc. Now all these are private, will be only in one category of 10% or 20%. They'll also have to look into public need also. Public need also they have to look. So it will have to be in that gradation. So out of 100 acres, Some land may have to be reserved even for public.
They may not take coercive action against me. One sentence may be added.
We don't know whether he's in possession or not.
No, I'm in possession, my lord.
Also, my lord, 10 kilometers within, close to Mysore, likely to be rejected anyway. So the question of protection doesn't arise.
If it's within 10 kilometers, then how?
That's what the observation of
Illa,
the
illa.
Tahsildar is
Kindly
in the
turn
report.
annexure H, my lord. Page number 41 for a moment, my lord. It is very clear. The
Now,
Lokopayogi Ilake, they
correct.
themselves specifically stated that, my lord,
no, correct. If they have
there
to-
is distance between 19 kilometers.
If they have to take any decision, they will have to give you a notice. That time you come.
ಒಂದು ಸೆಂಟೆನ್ಸ್ ಆಡ್ ಮಾಡಿದ್ರೆ ಆಗ್ಬೋದು. ಒಂದು coercive action ತಗೊಳ್ಳೋದಂಗೆ ಅಷ್ಟೇ. ಇಷ್ಟು ವರ್ಷದಿಂದ ಅಲ್ಲಿದ್ದೀವಿ.
Let us see. In
ಇಷ್ಟು
the-
ವರ್ಷದಿಂದ ಇದ್ದೀವಿ. ಮೂರು ವಾರಕ್ಕೆ ಏನಾಗಲ್ಲ.
Lord, we will not, anyway, my lord, we will not take possession of it till the deputy commissioner decides on the matter.
Needless to
Then
state,
remedy is available for
any
them.
action for eviction, if any, could be initiated only after final decision is taken by the deputy.
Much.
Yes, next.
52, Under Naik. 52, Under Naik.
Endorsement.
52.
Also, may have this tomorrow, my lord. My endorsements
Release
are not.
refreshment is list tomorrow.
Under 76.
For the petitioner in this case, my lord. I'm filing my objections to the IA filed by the third respondent.
Lords, I have received the objections now at the 2:30. My lords, may kindly pass over this matter, my lord.
No, no, pass over, my lord, no pass
Just
over.
1 minute. Just 1 minute. Now, today Passover will not reach. There is a bail matter.
Kindly list on tomorrow, my lords, because there is some urgency.
What is urgency?
We have filed an application
No, no,
seeking
SC
permission to harvest, my lords.
PTCL, what is urgency?
No,
You
no.
have to hear it.
We have crops hakidive. It
You are
has
the
come up
grantee.
at the stage of harvesting.
No, no, you are the grantee or purchaser.
No, I am the grantee.
I am the purchaser, my lords.
Now, what is the order passed now?
My lords,
What is the
the sale deed
interim
has been null and void, my lords. Null and void agide, sale deed by the deputy commissioner. And my lords,
You are the purchaser.
I am the purchaser.
No, I
Prior
want
to
to
that-
make a submission, there is a history, my lord, this is not a case now. 2005 the High
Now
Court ಇಂದ
crops
ನಡೀತಾ ಇದೆ.
ಹಾಕಿದೀವಿ, it has come up
Division
at the
bench
stage
ಆರ್ಡರ್
of
ಇದೆ
harvest.
ಇದರಲ್ಲಿ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಇದೆ ಇದರಲ್ಲಿ, ಅದ ರಿಮ್ಯಾಂಡ್ ಆಗಿದೆ ಅದು AC ಮುಂದೆ. ಅವಾಗ ಅವರು ತಪ್ಪು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅದ್ರ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ ನಾನು. It's only for 32 quintals, but
But
it's
in
claiming
division
about 2
bench-
acres. I want to argue the matter in detail.
But in
I
division.
filed my objections. He is not in the position.
There was another writ petition corrected and double, writ petition of 22310 was 2022. Kindly connect to this writ petition. Because on same common orders passed by the deputy commissioner, I also filed a writ petition.
22310 of
22310 of 2022, my lord. Writ petition. Challenging the same order. There is a
No,
two-
you have been dispossessed, is it, or what?
No, my lords,
No,
we are in the possession.
Then why are you?
family property.
Then why are, what is the?
For
now-
permission to harvest, my lords. It has come up at
now,
harvesting stage.
Unless land is restored to them, where are you? You are in possession. Government has to restore possession. So what is your apprehension now?
My lords,
He is the grantee.
is a grantee.
His petition is still to be allowed.
Man, there is an interim order by this court.
1974,
No, no, I'm asked, I just want.
There is
to-
an interim order by this.
No, have you been dispossessed by the
No, my
state?
lords. There is a status quo.
So 1 second.
Status quo
Then
order.
leave
there.
it at that.
Madam, 1
Relax,
second.
we
They cannot enter into possession without government restoring possession in terms of.
We are in interrupted.
So 1
possession.
second, my lord.
So what is your apprehension?
We have planted crops only to harvest. We are seeking permission.
Why permission you want? You are in possession, you harvest it. Who's preventing
we
you?
have cultivated the land, we have raised the crops, Your Honor. My lords.
So they are
Therefore,
both of them
we will
They are
claiming.
the brothers of me. They,
Not
these,
a girl.
You sort it out amongst yourselves.
Madam, 1 second, my lord. I want to make a submission.
No,
my
on
lord.
merits we'll hear you. Complete.
But there is
service.
interim order, my lord, in this case now.
I am not saying anything. What am I saying?
No, no, they have no right to cut the crops.
No, you are in possession, is it?
Yes.
illa,
Hello.
illa, illa. No, my lords.
1
It
second.
is wrong, wrong.
Good, file good. But how are you in possession? Has government put you in possession after the order?
One second, my lord. I want to make a submission. There was a suo motu initiative, my lord. Suo motu after in 1992, my lord. 1992, that the petition that act to be restored to me. There was a dispute between us. Then In 2000, then it was restored. But the petition was allowed. My petition also. In 1992, my lord. And DC also come from the order. In 2002, the third respondent filed appeal before the DC, my lord. That was allowed. I prepared a petition before this honorable court, my lord. 5532. That petition was allowed in my favor. Then they prepared a writ appeal. And in writ appeal, only a part was remanded just for 32 guntas, not for whole land. The whole land has to restore to me. There was an order. But the AC and DC, what they has passed, not only to 32 lands, they said there is no grant. They have passed an order. It amounts to contempt of court to whole land. And this third respondent was admitted before the single bench and the division bench that there is only 32 guntas. Now he has filed this application for whole 2 acre and 30 lands. That land is not been decided by the AC and DC. So this is the position, and now they want to claim it, and there is a contempt of court, my lord, because the division bench have cleared a writ appeal. I've produced the order.
My lord, the revenue entities are
What has
standing.
been, no, forget it. What has been remanded is how much, what extent?
Only 32
32 guntas.
Then how? Then you must fight only for 32 guntas. How can you claim more than 32 guntas?
But AC allowed the entire.
He has no
sale
right
deed.
allowed.
That's one without jurisdiction. If what has been remanded is only 30, so we'll hear it.
We will submit
My lord,
We'll hear the
documents on the
kindly have this matter tomorrow.
No, no, I'll hear it in due course, no urgency.
I'll file my objections. Objections.
But since status quo was granted, we have filed this application.
So there is interim order is there, my lord.
Status quo is granted.
No, that
We have
means,
we have filed
that
this.
means week's time granted to take necessary steps for R11. Interim order earlier granted is extended till the next date. Both sides to file their synopsis. List after 2 weeks.
My lord, my pleading application was allowed.
List
My
along
pleading
with
application was allowed.
WP.
The amendment was not done.
I'll carry out the amendment.
List
Objections.
List along with WP 22310 of 22.
So
Yes.
objection may be filed in the counter.
It is not amended because I have been implemented.
I'll amend the
Observation of this honorable
I'll
court.
amend.
Petitioner to amend the cause title.
Well, the objections to be filed in the counter again.
Objection to
IA1.
What he has played.
objections to IA 1 of 25 is taken on record. Yes.
So,
It has to be decided. We can't.
yes, my lord. It has to be decided.
77.
This is also objection.
For the petitioner, kindly pass over the matter. Designated in
We
consultation.
don't reach today. Some other day you take it.
Kindly date may be fixed in next week,
Relist.
any date.
15.
Yes.
78.
My lords, I am appearing for the respondent number 5, my lords.
For petitioners, my lords.
I seek a week's accommodation, my lords, please, my lords.
Would this be taken up, my lord, next Wednesday? Next Wednesday will. Thursday, my lord, Thursday.
Relist next Thursday.
Please, my lords.
3.
4.
4. 79. For respondent.
But the resumption has been ordered on 2010 during. Now writ petition came to be filed during 2025. The interim order has been granted. The matter pertains with respect
see,
to
we'll hear it.
all connected matters. A short date may be given since because of the
Matter has not been
And-
admitted.
Huh?
Matter has not been admitted. IA for early hearing is not maintainable. Let it become on B group, my lord. It
There is
need to
urgency,
be heard.
There is urgency. I moved the matter, then I filed an
Need
application.
to be heard in detail, my lord.
It has to be heard, at least short date. There are connected matters too, arising out of KLR itself.
List in B group on.
B group ಅಂದ್ರೆ
ಅಲ್ಲ ಆಯ್ತು ಕಾಯ್ಬೇಕು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ನೋಡೋಣ ಅದೇ
date may fix ಮಾಡೋಣ otherwise ಮಾಡೋಣ.
Yes, 6th.
6 please.
Please.
Interim order in operation extended till the next date.
80.
Relist. Relist week after next.
81.
My lord, I appear for the petitioners, my lord. This matter has to be heard, my lord. There is an ex parte order passed by a challenge change of the kata. It has to be heard, my lord, give your lordship.
You complete service, sir.
My lord, yes, I filed, your lordship, because some of them has already served, I have filed a memo along with it.
No, R5 to 7, you have to still take steps.
I have received,
Petitioner.
your lordship may kindly, I have received an acknowledgement that the endorsement by the post office saying that some of them, I will file a memo to that effect, my lord, I will place before your lordship. Your lordship may have it week after next, my lord.
Yes.
Please, much obliged.
List week after.
82. 82.
For the petitioners, my lords. My lords, in the previous dates of hearing, my lords, the Honorable Court had directed the state government to file their written statements, my lords.
My lord, I am filing the documents in respect of the same, that the entire survey means the village which they are contending to be the filed on 7 is rejected on the ground that it comes within 5 kilometers of the CMC. I have given the maps and also the endorsement, my lord. Sir, ಇದು ಇಟ್ಕೊಳ್ಳಿ last page at page number 20, my lord. Before 19 may be turned, my lord. Page 19 of what I have given the.
No, where is the endorsement?
My lord, at the initial, it has been rejected. Page number 2, my lord. 3 or 3. Page 2 itself. Document number 1. ಅರ್ಜಿದಾರರು ಮಂಜೂರಿ ಕೋರಿರುವ ಜಮೀನು ನಗರಸಭೆ ವ್ಯಾಪ್ತಿ at column number ಗ್ರಾಮ.
Now you challenge this document number 1 in accordance with law.
Please, my lords, I'll take instructions on that.
The,
my lords, one more submission.
You have to challenge it before the appellate authority.
Lords, one more submission. In the connected petition, my lords, I have taken the contention along with the present petition also, that, my lords, in the connected petition where also the connected writ petitioners, they were also for the grant of land under the form number 57.
My lord.
And in that connected petition, my lords, this honorable court has directed not to remove the petitioners without leave of the court. And in that petition also, they have not filed any objections, and their application is also so far is pending.
It is common.
And in my present petition, I have taken the contention that in view of in that petition, where the contention taken that some of the persons are in encroached portion of the Gomala land.
No, that will
it's common survey number, my lord. Both are common survey number to that same village, same survey number. 3 members were filed. 3 applications were decided. Page number 2, my lord. They are all same.
That is the petition and the other petition.
Yes, might be Siddhappa.
Then you challenge.
And
no, my lord. So far as the present endorsement is concerned, only for the present petition at serial number 82. In the connected writ petition, my lords, that is WP 17996 of 16.
I know that petition.
My lord, same survey number, my lord. At page number, same survey number 247. There also you would have issued the endorsement that it comes within 5 kilometers of the radius of the CMC. Same survey number. Parties.
Lords, the contention of the petition is that yes, my lords, it's the same survey number within having a vast of the land which is not even ported.
So and you challenge this. No?
Please, my lords, but one petitioner name is missing in the said endorsement, which if I may permit to brought out.
Separate endorsement may be given. I will pass on to that also. But all of them were issued with the same endorsements. Here, the name of the Rajshekharappa is not found in the page number 2, my lord. I just verified. But same survey number.
Rajshekharappa, KP Krishna, who is the petitioner in present serial number 80, that is WP 16041, is a petitioner number 3.
Siddharaman
he is also pending.
Now the application numbers are given.
Yes, ma'am.
Those applications are rejected.
Yes.
We'll ask them to give separate endorsements insofar as those applications to the petitioners within 1 week from today.
Much obliged.
You challenge this order in accordance with law. the writ petition.
Lords, in so far as connected petition, it may kindly be de-linked along with the main. Because there in the connected petition, though the survey number is the same, but this bit contentions are different from the petitioner's hearing.
No, it is rejected. You have to-
Rejected, but endorsementally presented petitioners and CRC. If they are there, my lords, let them submit and
week we will give
it
a
could be
endorsement.
disposed of along with together.
Within
my
1
lords.
week, we will give the endorsement for in the second petition also. my lord.
I'll have it
If-
on, I'll have it on Monday.
Yes, yes, my
We'll
lord.
bring all the endorsements. We'll give.
Yes.
Submission, my lord. FTA for respond number 3, my lord.
Delist the matter. Let us see. If it's going to be disposed of, then we will not enter into the merits.
Maybe the first matter may be disposed of, my lord. In the similar way, I will also give the endorsement. Second matter.
AG, the WP. One 16041 of 24 is delinked as per the copy and taken up separately. The petitioner had 160. Petitioner is called in question the correctness of the impugned order at annexure F, reserving certain land to for public purpose, which the petitioner submits is the very land for which application for regularization had been filed. During the pendency of the proceedings, AGA has filed a memo and enclosed as document number 1, copy of the order by the Deputy Commissioner dated 11/11/2025, rejecting the claim of the petitioners. In light of the same, petition is disposed of as not calling for any adjudication, while reserving liberty to the petitioner to question order of the Deputy Commissioner rejecting their claim as being ineligible applications. All contentions are kept open. WP 17996, isn't it?
Yes, my lords.
Of 2016 to be treated in preliminary hearing list on Monday.
Please.
Fresh matters list on Monday.
Please, my lords.
Yes, thank you. That also.
Dealing course. 83.
For petitioner in this case. Kindly, interim order may be extended.
Interim order. It was not extended on the last date, is it?
It's extended.
Hello, you filed IA, eh?
Yes, ma'am. Compiling IAN 1925.
Huh? The interim order is there. Why you want extension? Already there is an order. The interim order earlier granted is extended. The interim order earlier granted on 29/11/24 is extended till the next date.
84. Himantapara.
The copy not served, my lord. Actually, surface matter, seal notice was challenged and subject to deposit amount, conditional order was passed. Thereof, sale has not taken place, hence the case was disposed of. There's a due of more than 53 lakhs, my lord.
Now, what is this deposit refund of? Some money amount is there with the registry.
Not furnished any details. And if the amount is there, bank is entitled for, because 53 lakhs is due from that.
No, correct. Now his writ petition goes, it's for him
No, it is a disposed of, petition disposed of.
Correct, it's his amount, it's not your amount.
Yes. So,
Let him take it back, whatever right you have, you can proceed against him.
no, if you could direct him.
Unless you have a, no, correct, unless you have a charge.
No, my lord, like this, conditional order of stay granted subject to deposit of amount.
Let him come in his presence, we'll see.
Yeah, any date may be.
This is the matter in the orders list on next week.
312.
312.
85, Sharath, yes.
Fair for the petitioner, lords.
For the fourth response.
Lord, the petitioner, my lords, is purchaser of 24 guntas of land in survey number 52/9 of Mgpura village under the registered sale deed dated 12/6/2024.
No, no, what does it come up for?
My lord, may I?
What does it come up for today?
Number 2, dispensation of the.
Huh?
Type, there is an application for dispensation of.
2 of 25 is allowed. Petitioners dispense with production of original / certified copy of annexure B, C, D, E, H1 and L.
Typed copies, my lords, not the original. Dispensation of typed copies.
Typed copies. Subject to production of typed copies if called upon by the court. No, it says which IA? IA?
IA 1 of 25 is for dispensation of typed copy of legible copy.
IA 2 of 25.
IA 2 is dispensation of certified copy. Certified copy of annexure A, my lords. That's all.
2 of 25. Certified copy of annexure A is dispensed with, subject to the undertaking that this certified copy would be produced in due course. Yes.
My lords. The matter is simple, my lords.
No, government.
My lord, the endorsement and the challenge at annexure A, my lord, is an endorsement issued by the special tehsildar saying because there is a civil dispute pending between two parties, kata cannot be made out. Now, my lord, pursuant to that and the writ petition filed, the special tehsildar presently has written a communication to the AC, my lord, saying since there is an order passed, now she does not have the power to do so. They have sought for a direction from the AC. My lords may dispose it of taking this into account, directing the authorities to act in accordance with law.
Lords, the suits which are referred to, my lords, are not related to my property at all.
Please,
The
my lord.
endorsement is issued only for the sake of issuing the endorsement, my lords. No problem, my lords, after filing of this writ petition, they have come to know about their lacuna. My lords, merely for the sake of mentioning, my lord, they mention some two random suits and say that your application is kept in abeyance. My lords, when
Now they say that they are going to reconsider it
please
and pass on.
let them reconsider, my lords, because those suits are nothing to do with my property.
So that will not enter into.
Please, my lords.
But they have said that the proceedings also have closed.
Please.
You have a look at the copies and then you make your submission. They're saying the suits are disposed of.
My lord, the proceeding before the special tehsildar was closed on whatever erroneous grounds. Now the present special tehsildar will not have, cannot set it aside. Therefore, a communication is issued to the AC, my lord, regarding this. Now, upon
No, my lords,
clarification
my
from
lords,
the assistant.
what they are quoting is this, my lords, in this 24/11/2025 order, they are saying that they had quoted pendency of two suits. Therefore, once the Tahsildar has issued this endorsement, he cannot once again reconsider
Yes,
it. He is awaiting for the decision of the assistant commissioner.
Assistant commissioner.
But my lords, these two suits which are referred to are nothing to do with my property. I have produced the plain copies. They are some other random properties, random suits.
I'll set aside the endorsement.
Yes.
I'll permit them to hear the parties and take a fresh.
Yes.
The present petition has been filed. Seeking to set aside the order dated 8/1/25 passed by the special Tahsildar Bangalore South Taluk at annexure A, whereby the request of the petitioner for effecting kata on the basis of registered sale deeds has been
Sale deed, only one sale deed.
Sale deed has been rejected on the ground that OS 2231 of 2023 and 235 of 2024 are pending, and objections were raised in that regard. Full stop. EGA submits that the Special Tahsildar has information that the suits are disposed of.
No, my lords.
No, that's what it says.
No, my lords.
My lord, those are the proceedings before the earlier special Tehsildar, my lord, not the suits.
Lords,
Because
it says the suits are pending, therefore the dispute is
at that
ಮುಕ್ತಾಯಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. This annexure A is passed citing the suits are pending.
Please,
Sentence better. Learned counsel for the petitioner submits. Now, were you heard in this proceedings?
Lords, yes.
That the suits referred to have nothing to do with the
Petition schedule property.
request of the petitioner, and that they would demonstrate that the authority can take a decision without waiting for the outcome of the suits.
Yes.
Full stop. It's further submitted that the property which is subject matter of the sale deed is not involved in the pending suits.
Yes.
Full stop. AGA submits that they would hear all concerned and take a fresh decision.
Yes.
They are taking note of stand of the government. Endorsement at annexure A is set aside. The Tahsildar is directed to hear the petitioner and other interested persons and pass appropriate orders insofar as the request of the petitioner is concerned. Accordingly, petition is disposed of. All contentions are kept open.
Lords, date may be fixed to appear before the Tahsildar, lords, since the
Special
contesting.
Tehsildar, ma'am.
The special Tahsildar. The both parties to be present before the special Tahsildar 2 weeks are needed.
10th
Yes.
of December. 86.
Please, wait for me.
86.
I'm the implementing applicant, not in item number 2.
Appearing for the petitions.
But as far as I am concerned, Lord,
Let us see, let him complete instructions, let him file. AGA submits, statement of objections would be filed within 10 days. Relist week after
Finally.
next.
the date, Lord.
2 weeks are will date.
My lords, impleading application copy to be
It's-
served to
No, no,
petitioner.
they've been served.
Serve,
Twice,
serve.
twice it was served.
Once more.
Once more.
Let them take photos of your application.
Please, I shall.
Yes.
7th.
Item number 3, madam, I have served the copy on implementing applicant. I have served the copy and I have taken the endorsement.
Yes, yes, next.
7th of January, 87.
Macha.
Suram SC.
The petitioner is seeking writ of mandamus. The impleading application that they have filed, your lordship, that is not maintainable in the eye of law inasmuch as I am not seeking any relief against them. I am only seeking relief, my lord, against the respondent number 2, requesting them to furnish the copy. Kindly see the prayer, my lord, page 21. When I am not seeking any relief against them, why their necessary parties, my lord, is.
I'm the respondent in LRF case, my lord. I'm the subsequent purchaser, my
Maybe,
lord.
that is a different proceedings. I am only asking to furnish the certain documents, my lord, which are available on the record, which they say that the file is misplaced, this, that, and the ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು.
Yes.
For the purpose of conducting the case.
Find out, they're only asking for copies.
Copies.
Another 2 case, they have filed the same relief, another 2 matters. Kindly connect those writ also, my lord.
No, that we will see, my lord. Let them, whether the impleading applicant presently, my lord, is necessary and proper party to this case is the question.
And apart from issuing direction to the Assistant Commissioner, my
Mother
lord,
is
to
a
furnish the
subsequent
document, my lord.
purchaser, my lord.
Kindly
Mother
see
is
the-
subsequent purchaser.
that is the
RTC
crux of the
comes with
matter.
my name, my lord.
No, correct, but he's saying that there are similar writ petition.
That's correct, Your Lordship. Similar writ petitions for other purposes, Your Lordship.
Same-
Different
They
reliefs we
have
have sought.
claimed the same relief, they are yet a stay.
Yes.
Regarding the same LRF, is there any other?
Yes, yes, Your Lordship.
Please, my lord.
There is a, my lord.
Then
I will
we'll club-
furnish,
we'll club it.
I will
Please,
furnish
my
the
lord.
number, my lord.
List along with WP
Kindly
numbers.
fix
So,
that. Yes,
date
please.
code.
22,430 of 2025, my lord.
And 32983 of 25.
Write and just write the numbers in.
Yes.
Date code.
16,
Yes.
88,
Much obliged.
Impleading applicant in this. Lord, I kindly pray for a week's accommodation to file objection to the impleading application.
Main matter itself we'll see.
Please.
List week after next.
Interim order may be extended.
Modern operation extended till the next date.
list to 2, serial number 29, Basavana MD.
One second, Madhu. ಸ್ವಲ್ಪ complaint ಮಾಡಿದ್ಯಾ? No representation for the petitioner. Week's time finally granted for necessary compliance. It's made clear if petitioner remains absent on the next date, court would be constrained to pass appropriate orders. Yes. ಬಂದಿದ್ದಾರೆ? ಬಂದಿದ್ದಾರೆ ಅಂದ್ರೆ? Three.
List 3, the group matter, serial number 1, SP Leela. List 3.
I am for appellant. Lord, fix the date for hearing next week. Honorable Supreme Court direction matter.
List RFA.
Our special order agreement.
Engineer. List in the week commencing from
5th of January.
5th of
After
January.
vacation act,
5th of January, both sides to file their synopsis.
Yes, sir.
In the interregnum.
We'll file furnish.
Grateful.
Serial number 2, Srinivas V.
List in the week commencing from
5th of January. 3, serial number 3, LS Venkatakrishna.
I'm instructed to appear for the petition. But in fact, last 2-3 occasions, His Lordship Justice Sanjay Gowda has directed the state and its machinery to go and make a joint inspection of my property. My lord, my allegation is, on my land, they allowed the drainage water to pass through in survey number 15, about 21 kuntas of Iblur village adjoining the Belandur tank, made my property unuseful now. And the different objections are filed. BBMP files the objection that we have not put up any construction on this, my property. The chief engineer files an affidavit, we have put up the construction on my land as it is a big Kharab land. Therefore, after hearing for some time, His Lordship directed them to make a joint inspection. How? Because my allegation in the entire petition is the Raj Kalve, which passes originally as per the earlier maps, my lord, it takes directly to the Belandur tank, whatever that drain water, storm water. Now, because of the development surrounding area, because of the construction of, your lordships are aware, near Belandur tank, there are huge constructions of apartments. There was a deviation, made my land unuseful now.
Where is the joint inspection?
No, they have not yet made. That's what the direction. I don't know whether it is in the order sheet or not, my lord. His Lordship Justice Sanjay Gouda is.
No, there was one order on 11/12/2018.
Please.
Directing the Tahsildar to file an affidavit.
Please.
To answer the allegation of deviation of stormwater drain and deviation from original alignment
Yes,
as found in the revenue and survey record.
Please, my lord.
They filed it.
No, affidavit has not been filed by the Tehsildar as on today.
So let them file it then.
That's one minute. There was a oral direction by this honorable court. Let them make a joint inspection of both the petitioner to be present and also, as your lordship read the order, my lord, let them look into the original records where actually it passes. If there is encroachment by any of the person, they have to take action. And it was also state government, I think in the past also in the last 2-3 years, it directed to demolish the buildings wherever Rajkalve has been encroached.
Tahsildar is directed to file affidavit in terms of the direction on 11/12/2018 passed by this court. Noticing that there are certain assertions regarding change in alignment
Of Rajkalve.
Of Rajkalve and its encroachment. The respondents are at liberty to make an inspection and survey if required in the presence to the survey officials in the presence of all concerned.
No, the survey based on the original, as your lordship observed, my lord, as per the original Rajkalve where it passes.
The observations of this court in its order dated 11/12/2018 may be kept in mind. Full stop. AGA submits that Tahsildar may be permitted to file affidavit after the spot inspection and survey. Said request is accommodated. List after 2 weeks.
Let there be direction. Date may be fixed, but these people don't do it. 2018 it is going on. Every year I am facing.
Issue notice to everybody and then do it. Survey may be conducted on 9th of December.
11 a.m.
At 11 a.m. Petitioner to be present without notice. It's made clear that the authorities concerned have to issue notice to other affected parties as well. Others responded.
No, other affected, I'm sorry. No, I may be present, my lord, the petitioner may be present.
Okay,
but the thing is, other persons who are affected by this, my lord, because Rajkalve encroachment.
Correct. So
your lordships are right, my lord. He must issue the notice. You can't avoid them. Please.
Serial number 4, Chandrahasa.
I'm appearing for respondent number 3A to K, my lord.
Yes.
Your lordship may kindly have it after the vacation, my lord. Fine.
I have no objection as far as this, if the mistake has happened, I have pointed out. They agree that that mistake had happened and it ought to have been filed in respect of a different survey number. They filed in respect of this survey number. There is no, the alienation which was made as far as this land is concerned, there is no objection. And ultimately twice the DC has remanded the matter, setting aside the order passed by the Assistant Commissioner. Once again, this is when it is remanded back, I challenged it, saying that it is not necessary, it is a mere mistake by oversight. What happened is, earlier it was 229 and 230.
But she's asking for time, so I'll fix a date. Let us
Yes. Any short date?
Realist,
Not
the
up to
week commencing from
5th of January.
Yes.
5.
Grateful.
Serial number 5.
Serial
5.
5 appear for the petitioner, my lord.
In this case, my lord, actually, my lord, the petitioners and respondent number 4 to 6 are the children of Basappa alias Puttasomappa, son of Parvati Amma. They are siblings.
No, this will take some time. We'll see. We'll have it some other day. I have some parted matter. List
So
the,
next,
relist the matter in the,
next Monday, my lord.
let me see. Relist the matter in the week commencing from.
ಅಲ್ಲಲ್ಲ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ, ಇಲ್ಲಾಂದ್ರೆ ಬರೋದಲ್ಲ. ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಲಿಕ್ಕೆ ತುಂಬಾ ಕಷ್ಟಪಟ್ಟಿದ್ದೇನೆ.
5th of January. Yes.
ತುಂಬಾ ಲೇಟ್ ಆಗುತ್ತೆ.
6th of January. Not before vacation. Yes.
Number 6, Srinivas Reddy.
My lord, I'm appearing for R3 to R5. Kindly pass over the matter.
Relist in the week commencing from
5th of January.
Interim order may kindly extend.
Yes, interim order. Operations extended till the next date.
7, Narayan Swamy PM.
Relist in the week commencing from
5th of January. 8, Murali N.
Fourth respondent, my lord, number 4, my lord, suppressing the earlier order passed by the Assistant Commissioner, my lord, has once again obtained the mutation, my lords, in his favor on the basis of the partition deed, my lord. Earlier,
on submission, my lord, senior is having a inconvenience, my lord. Kindly if may have the matter after a few weeks, my lord.
Next week.
Relist.
Kindly out next week.
5th of January.
First, next week, any date, my lords.
Yes, let us see.
9.
Relist in the week relist in the week commencing from
5th of January. 10.
ಬೆಳಿಗ್ಗೆ ಯಾರೋ ಟೈಮ್ ಕೇಳಿದ್ರು.
ಬೆಳಿಗ್ಗೆ ಟೈಮ್
Somebody asked for time in this matter. Relist in the week commencing from
5th of January. 11.
I'm appearing for the petitioner. Arguing counsel is not well, my lords.
Relist in the week commencing from
5th. 12.
Grateful.
Serial number 12.
Granted land, the mutation was affected and subsequently during 2006, the 5th respondent has created and obtained mutation. Thereafter, I have filed appeal before the State Commissioner. State Commissioner was detailed, made order and allowed the appeal. Thereafter, the Deputy Commissioner has reversed the appeal by allowing the in favor of 5th respondent. The matter is very urgent, but I have taken kindly see the
Annexure G, page number.
Annexure
G, page number 67, para 10.
This is land reform. Land reforms, is it?
yes. So which was granted by the land tribunal itself.
Government, have you taken, government is not required?
The government requirement.
Their stand?
Not at all.
Government, you must take your stand then. If you are going to dispose it off, you must take your stand in writing. Statement of objection.
Next week, my lord.
Let them file, then we'll take it up. Statement of objections by government to be filed positively within 2 weeks. Taking note that this is a matter of the year 2022. Relist in the week commencing from
5th of January. 13.
Interim order maybe.
Interim order in operations extended till the next date.
13. Malappa PM.
Relist.
For the petitioner.
Yes.
My lords, the petitioner has purchased the property under a registered sale deed, my lords, on 24/9/2007, my lords, from Anjanappa Venkataswamy Narasimhaya and others, my lords, Mutation was effected on 1/12/2007, my lord. Since then, the petitioner name is continuously reflecting on RTCs, my lords, from 2007 to 2022. The respondent has preferred an appeal before Assistant Commissioner, my lords, seeking of mutation of entries based on sale deed, my lords. The Assistant Commissioner rightly directed the respondent, stating that the title dispute must be decided by the competent civil courts, my lords. In respect of the same, I have filed a original suit before civil court, my lords, which came to be dismissed, my lords. Aggrieved by the same, I have preferred a regular appeal, my lords, which is pending for consideration, my lords. Meanwhile, my lords, the respondents
You have filed a suit for?
declaration, my lords, declaration of title and cancellation of fraudulent sale deed, my lords.
Executed in favor of the respondent.
Yes, my lords. Respondent number 3, my lords.
Now what's happened to your RFA?
RA, my lords, regular appeal, which is pending, my lords. It has not yet been decided, my lords. Meanwhile, my lords, the respondent number 1, my lords, kindly come to page number 61, my lords. Annexure M, my lords.
No, now as on date, in whose name does the revenue entry stand?
Petitioner name, my lords. From 2007 to 2022, revenue entries.
As on date.
Yes, my lord. As on date, it has been mutated in the name of respondents, my lords. Respondent number 3.
Correct, but then you may have to wait till the outcome of the regular appeal.
Yes, my lord. Still then, the alleged, the impugn order of mutating the RTCs may be
No,
quashed.
if in the regular appeal you obtain any interim order, then you move this matter.
My lords, for a moment, kindly come to page number 61, my lords. In that, my lords,
No, but
Mula.
Correct, but your suit is dismissed now.
Yes, my lords, they've never filed a suit, my lords, before civil court. In the order, it is mentioned that civil court adesha civil court adesha mula badalavane riti kate badalavane. The respondents have never filed any civil suit between the before the trial court, my lords.
Annexure M is passed even before the civil suit is filed.
After, my lords, after the civil suit is filed in the year 2015, my lords.
Then you find out what is the basis for transfer of the mutation. Annexure M, it says civil court adesha badalavane riti kate badalavane swadhinata riti.
As of before 2015 itself, let them deal with any order. If they are not paid with any of the order, it will be entry as of 2015. I have received the Parawise remarks.
There?
Parawise remarks were like that.
That
Can be kept in the abeyance till the disposal of the
My lords, they're claiming under the registered sale deed, my lords, from respondent number 4, my lords. Their sale deed is of the year 2006, my lords. In the year 2006, no revenue entries would stand in the name of the respondent number 4, my lords.
no, earlier to annexure M, mutation was in whose name?
Mutation, Shankrappa bin Venkata Rayappa, my lords.
Earlier to annexure M.
Yes, my lords. It stood in the name of petitioner, my lords. Ramaya.
Where is that?
RTCs, I've produced RTCs, my lords.
Ramaya bin Pilanjanappa. So there is no civil court order. You're saying proceedings were initiated by you later.
Yes, my lords. I have filed a suit in the year 2015, my lords.
What is the date of his sale deed and what is the date of your sale deed?
Please, my lords. My 24/9/2007 is the date of my sale deed, my lords.
Yes.
His sale date is 13/3/2006, my lords.
Earlier to yours.
Yes, my lords. But at the time of the execution of sale deed, my lords, the mutation entries were not standing on in the name of respondent number 4, my lords.
You have where do you get the date of his sale deed?
Page number 35.
Page?
35, page number 35.
13/3/2006.
Yes, my lords.
The petitioner has sought for issuance of writ of certiorari right to set aside the mutation orders passed in MR number H 26/2021-22 dated 22/10/2021, copy of which is produced at Annexure M. In the case of the petitioner, that mutation stood in the name of the petitioner earlier to the order affecting mutation. It is submitted that mutation was effected in the petitioner's name on the basis of sale deed dated 24/9/2007.
Yes, my lords.
It's further submitted that the respondent thereafter claimed change in the mutation entry on the basis of an earlier sale deed dated 13/3/2006. Petitioner submits that the revenue authority does not have jurisdiction to enter into adjudication as to questions of title and could not have taken note of earlier sale deed dated 13/3/2006 and proceeded to effect mutation in the name of the private respondent. Next, it's further submitted by the petitioner that though suit for declaration was filed by the petitioner against the respondent and was dismissed, petitioner has filed RA 140 of 2016, which is still pending consideration. Further submitted, a close perusal of Annexure M would indicate that the origin for change of kata reference is made to an order of civil court. Full stop. It is submitted that except the petitioner, the respondent has not initiated any proceedings before the civil court. And if that were to be so, the reference at Annexure M as regards to order of civil court being the basis for change of mutation does not appear to be correct. No, but your suit was, maybe it's your suit only that is referred.
They have preferred their suit only.
Huh?
Do not come up to 15. But by conducting the, changing this sort of procedure, there was an application that it was compromised and dismissed. So the kata was entered in the name of. I can give this letter also.
Could it? Could it?
After second time.
Without giving notice to the petitioner, they have mutated the entries, my lords.
Full Next. While affecting mutation at annexure M, EGA would submit that during the course of proceedings, a representation was made that there was a settlement in OS 201 of 2015, which was taken note of in passing the order of mutation at annexure M. Full stop. Next. Noticing that OS 201 of 2015 did not in effect end in a compromise, and noticing that RA 140 of 2016 is still pending, it would be appropriate to set aside annexure M while directing mutation entry prior to the order at annexure M to be restored, and such entry would be in prevalence till final orders are passed in the civil dispute in RA 140 of 2016. Accordingly, annexure M is set aside. The earlier mutation standing in the name of the petitioner prior to annexure M to be restored, such entry would await the outcome of the civil dispute pending between the parties.
Much obliged.
Adidly referencing, one Xerox, you leave it in the file. Because that is the basis for we saying that that compromise, that impression was. Yes.
Obliged.
End of list matter. A Nagarajappa.
Appearing for the petition. Lord, the petitioner, the impugned order, your lordships, my lord, get page, my lord, 58, annexure G. But the land, my lord, originally was granted, my lord, in favor of the vendor of the petitioner, my lord, in the year, my lord, 17 to 1982, the grant. My lord, the vendor was sold my lord, the lands in question on 4/5/1998. That your lordship will find at annexure D. No.
17 to 1982 is the?
My lord, 82 is the grant, my lord, that's Sagolichit. I produced my annexure A.
Yes.
The vendor, my lord, sold in favor of the petitioner, my lord, in the year 4/5/1998.
Yes.
The impugned order, your lordships may not find at annexure G. My lord, the Tahsildar and as well as the RFO, my lord, so moto filed a petition before the Assistant Commissioner, page, my lord, 58, annexure G. And my lord, the Assistant Commissioner entertained, my lord, whether it, my lord, comes within the jurisdiction of the forest or not. My lord, the Assistant Commissioner has no without, my lord, the jurisdiction or power and authority. He entertained, my lord, the petition filed by the Tahsildar, and my lord, the operative portion of lordship will get page 62. My lord, there is no hearing, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಗಳ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ಅರಣ್ಯ ಇಲಾಖೆಯವರೊಂದಿಗೆ ಜಂಟಿ ಸರ್ವೆ ಮೂಲ ಆಕಾರ ಬಂದು ವಿಸ್ತರಣಾ ದುರಿಸಾಗಿರುವ ಕರ್ದ ಮತ್ತು ಮೂಲ ಮಂಜಾರಿ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಮೂಲತಃ ಅರಣ್ಯ ಇಲಾಖೆ ಸೇರಿ ಜಮೀನಾಗಿದ್ದರೆ ಕರ್ನಾಟಕ ಭೂ ಮಂಜೂರಾತಿ ಕಾಯ್ದೆ ಕಾಲ 25 ಅಡಿ ತಹಸೀಲ್ದಾರ್ ಮಂಜೂರಾತಿಯನ್ನು ರದ್ದುಪಡಿಸಲು ಅವಕಾಶವಿರುವುದರಿಂದ to cancel, my lord, the grant made in the year 1982 under Rule 25(1) of my lord, the land grant rules after a lapse of, my lord, more than 3 decades.
No, correct. But now it's only in the nature of direction. It's only in the nature of a direction to conduct proceedings.
However, my lord, he has arrived at a conclusion to cancel, my lord. It is not, my lord, to 1982 grant.
No, correct. We'll clarify that this order cannot be taken to have prejudged the issue.
Please,
But
madam.
all contentions would be kept open. And the findings.
Now my information is, my lord, the authorities have issued notice under 64A of the land for, my lord, Forest Act for eviction, your lordship, my lord. Subsequently, after this,
I'll have it tomorrow, you find out.
may pass on, your lordship.
I'll have it tomorrow, you find out. AG accepts notice.
Stay of disposition, my lord. Is your lordship.
Tomorrow we'll have it. AG accepts notice for the respondents. List the matter tomorrow. Now eviction can be done only after an inquiry. So you take instructions, we could clarify.
Whether the assistant commissioner has got, my lord, the power. My lord, if the land is, my lord, a forest land.
This is not an order. We'll clarify that. This is
Only
only
a survey, my lord. We won't come in the way and take any possession till the survey is concluded. A proceeding is properly done in accordance with law, my lord. We won't take
all
possession.
contentions will be kept open.
That
That's it.
can be, my lord, passed, your lordship.
Tomorrow, you just take preliminary instruction.
Yes,
We can dispose it off.
Yes.
Serial number
AG
2.
accepts notice for the respondents.
Serial number 2. A. Nagaraj.
Same order.
Serial number 3. Vivek. Yes.
A1 of 25 is allowed and petitioners dispensed with production of certified copy of annexure G first materially, J second material. Yes.
Serial number 3. Vivek.
The list in fresh matters list tomorrow. Both 1 and 2. Yes.
Agreed by notice at annexure K, my lords. The issued notice for conducting survey on the basis of application preferred by respondent number 7. Annexure K, my lords, page number 55. In the impugned notice, my lords, they have already stated respondent number 7 as owner and possessor of the property, my lords. Prior to survey only, they have referred to the said person as.
No, now they've issued a notice to survey. How are you aggrieved by this?
So there is a civil suit pending between petitioner and respondent number 7.
Where is that?
Annexure B, page 26.
Page
26.
Page number 26 furnish the plaint, my lords. Plaint is at page number 19, my lords, annexure A. There is an interim order favoring the petitioner, my lords, not to alienate the suit scheduled property pending disposal of the suit, my lords. That I have produced at annexure B, my lords. Now, during the pendency of the suit, my lords, he has filed application before respondent authorities for conducting survey matters. After conclusion of evidence, my lords, at appropriate stage, he may take said recourse before in the said suit itself, my lord. Private respondent number 7, my lords, who is defendant number 1 in the said suit.
The suit for injunction.
Suit for declaration and injunction.
Let's see, we'll let it hold. We'll see. Is light of the submission that OS 74 of 20, in light of the submission that OS 74 of 20 is pending between the petitioner and the respondent number 7. There would be stay of the notice at annexure K till the next date. AGA is directed to accept notice for respondents 1 to 6, emergent notice to the 7th respondent.
See for handle.
List 1. Still number 89. Madhesh.
Other matters are not likely to reach. Please take dates from the court office.
No, serial number 14, my lord, in the third list, my lord, which is yet to be called, my lord.
I'm not taking any other matter. I have a bail matter now.
Yes, just a minute, my lord. In the Madras, my lord.
Dates you take. I'm not.
Start date, my lord. Day after tomorrow.
No, no, that you asked the court
I
officer.
have several times moved, my lord. Today is listed, my lord.
No, so
Unfortunately, my matter is not
dates, dates will be given by the court officer.
That list number 349, I have moved memo for consideration of interim prayer is there. 1968 sale did, after 6 sale did, my lord,
All the matters will be distributed on different dates and dates will be given.
interim
Wherever interim orders are there, it will stand extended.
One submission.
One submission, Lord.
Yes.
Seal number 9, like it appears, actually, I was not here. There is an interim order, my lord. It expires today.
Wherever interim orders are there, it will stand
sir,
extended.
interim order.
ಅವರ ಕರೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅರ್ಜೆಂಟ್.
We will extend. In all matters, wherever interim orders are there, it will stand extended.
That may be taken up on at least day after tomorrow.
Let us see. We just find out from the court officer. Yes, Sandesh.
Basically, nettle. 89. ಆಮೇಲೆ ಬರುತ್ತೆ ನೆಟ್ಟಲ್.
ಇದಾ? Act ಕೊಟ್ಬಿಡಿ. Act. PMLA Act. After 5 o'clock, nothing gets into my head. So you better be forewarned. You better be forewarned.
Please, I'm sorry, my lords, if I'm
Mentally,
taking.
no, correct. Mentally, we are already in withdrawal symptoms.
And
after
exhaustion, my lords, whole day. I'm sorry, my lords, I'll try not. My lords, I was on the act, only one last provision in the act that I will show and go to the sequence of events in our case. My lords had seen how the CRPC is made applicable to PMLA, where I pointed out section 46 as well as section 65. Now, my lords, when it comes to bail, similar to what we have in the other enactments of NDPS or special enactments, the twin conditions to be considered, we get that in section 45 of PMLA. Section 45. Nothing contained in the Code of Criminal Procedure. No person accused of an offense shall be released on bail on his own bond unless public prosecutor has been given an opportunity, number one. And two, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense. As I pointed out, my lords. Normally in the special enactments containing serious offenses, we usually find this kind of a section, my lords. But PMLA, in my respectful submission, is one of the only enactments where there's caution at the time of arrest in section 19.
The slight, so before you arrest, you have to be satisfied he is guilty.
One is reasons to believe, my lords, and then also you must be satisfied that he is guilty of the offense before you arrest him. This we don't get, my lords, in other special enactments. Virtually, my lords, the way it is structured, don't unnecessarily arrest unless you are very certain of few aspects.
Because the consequences in 45
will come later.
Onerous.
Oh, yes, my lords, because onerous.
Once you are arrested, getting bail is slightly difficult because of 45.
45.
So before you arrest, this is the.
Be cautious about it. So, my lords, that's how the structuring of the act is. Because ultimately, my lords, you are going against certain proceeds or laundering of proceeds of crime.
So that's more like some economic offense where it can be unearthed through records.
Through records. Mainly so, my lords. Ultimately, you're going against the properties. This is not a case as crime against another human being. These are more Economic crimes, though my lords, they say economic crimes, they can affect the fabric of the country and all that, but in the end of it, it is an economic crime. And for that economic crime, the legislature thought it fit, before you cause arrest of a person, 19 is your safeguard. So with this, my lords, this is how the whole structuring of this act is, my lords. And in sum and substance, my lords, so far as investigation into a schedule offense is concerned, that investigation is done by an agency separate to that of the ED, the schedule offense. If a schedule offense has been committed which has generated proceeds of the crime, and if this proceeds of crime, there's a process or activity thereon, comes PMLA.
Just repeat.
There should be a schedule offense. Offense is completed. Now, simple case is cheating. There's been a case of cheating that has generated proceeds of crime. Say 10 crores is the proceeds of crime that has been generated. The accused has done a process or activity thereafter, that is in the aspect of laundering it for the purpose of purchasing gold, house, anything else. The laundering part of it is what is taken care of under the PMLA. The PMLA is not concerning the schedule offense, which is going to be investigated by your jurisdictional police. And I will be able to demonstrate, my lords, how ED, it oversteps this particular bifurcation and goes to the extent of investigating schedule offenses, which they don't have the power or jurisdiction to do. So, my lords, in our case, in this particular case, my lords, the schedule offenses, illegal allotment of 14 sites, my lords, and 2 paragraphs of vague allegations against Muda. Now, the illegal allotment of 14 sites, 4 named accused. B report is filed against the 4 named accused. But so far as Muda is concerned, the investigating agency has brought to the notice of the court, we will be investigating into the activities of Muda. That is pending consideration on an investigation by the competent investigating officers. But here, my lords, ED now would file a complaint, which I will show as an incomplete complaint, where they say it is an illegal allotment. How could they investigate whether this allotment was legal or not, which is within the power and jurisdiction of the concerned investigating officer who's investigating a schedule offense? So now, my lords, please notice the sequence of events, my lords. I'll just get into the sequence. My lords, I had handed over a synopsis and list of dates, my lords. And one more very important aspect, my lords, which we may have to consider is, now if a schedule offense is still pending investigation, can the ED complete its investigation? It's like putting the cart before the horse. The proceeding under PMLA is dependent on a schedule offense. Now, if investigation is still pending on a schedule offense, how is it that you have completed investigation and you declare that schedule offense is done, there is proceeds of crime, there is laundering of it, and therefore we get jurisdiction? My lords, if a sequence is now noticed, my lords, 4/5/2020, Mr. Kantraju was the Muda commissioner earlier, my lords. Thereafter, 4/5/2020 to 3/5/2022, DB Natesha is the Muda commissioner. Now, DB Natesha is whose 482 petition, my lords, I'm sorry, whose writ petition came to be allowed and quashed, proceedings quashed. allegation against Natasha was, my lords, when he was a commissioner in Muda, about 400 sites there had been allotment, which according to them was illegal. That was the allegation. And allegation against me, the petitioner, my lords, who was the commissioner between 4-5 to 2-7, is that the remaining about 600 allotments happened when I was a commissioner. So there is no difference between what happened during Natasha's time and what happened between Dinesh Kumar's time. And my lords, as I pointed out, all this ultimately the sites which you have done provisional attachments, you have not arrested anyone. I, my lords, as a commissioner, above me is a chairperson. Against a chairperson also you don't do anything. But as a commissioner, when I have cooperated with your inquiry, I'm the only one who's been answering your summons. You think it fit to arrest me. Only person to be arrested in this whole so-called Muda scam is this particular petitioner, no one else. So my lords, Dinesh Kumar number 3, then 21/3/2023, Muda passed a resolution dated 21/3/2023 by upholding earlier government orders to allot sites to the land losers and senior citizens in good faith, since long battles of court cases were pending before the Honorable High Court. 19/4/2023, the Muda resolution was brought to the knowledge of the Honorable High Court, and the same was filed before the Honorable High Court in review petition 135 of 2023. The Honorable High Court, upon considering the resolution passed by Muda, allowed the review petition by directing Muda officials to allot sites within 8 weeks. As per the order of the Honorable High Court, the Commissioner of Muda allotted the sites for senior citizen land losers who are the petitioners in the said petition. Now, my lords, the specific allegation appears to be, my lords, in the guise of allotment, I have made sure it goes to my relatives. Sites have also gone to my relatives, and that's the manner in which I have committed an illegal act. That's the allegation. Then 25/9/2024, the starting point of the schedule offense, my lords. One Snehamahi Krishna filed PCR before the Honorable Special Court for offences punishable under 120B, 166, section so and so, section so of the Karnataka Grabbing Prohibition Act. Now, my lords, could I just pause here because this is the starting point of the schedule offense. My lords, page 55 is a complaint. My lords, so just notice the complaint.
Of the petition.
55, and it should be of the petition. Private complaint, my lords. My lords, the complaint is mainly given against 4 named persons. A1, the Honorable Chief Minister, my lords. A2, Srimati Parvati, the wife of the Honorable Chief Minister. A3, Mallikarjun Swami, who is the brother-in-law of the Chief Minister. And A4, Devraju, who is the original owner of the land. These 4 persons, my lords.
Where do you get that?
I will point it out, my lords, because we can get it in the just at page annexure A, page 53. That is column number 6, my lords. Page 53. Details of known suspects. Four named persons, my lords, would get there, and 5 Mattu Itararu. My lords, coming back to page 55, annexure B. Now, this complaint, private complaint that is given, it has in it 59 paragraphs, my lords. A very detailed complaint containing 59 paragraphs, out of which, my lords, 55 paragraphs is against the 4 named accused. 55 paragraphs devoted to the 4 named accused. Then, my lords, 3 paragraphs against the former Commissioner Natesh DB, because he was there when the allotment of the 14 sites had taken place. And one paragraph, my lords, a general allegation against MUDA officials alleging illegal allotment. If my lords may notice paragraph 19, my lords, page 59.
So now you said a complaint has been filed.
The PCR. That
No, under the.
now what they have filed, they filed a complaint now.
That is the ECIR.
That no complaint, first it starts with an ECIR, my lords. Then they investigate and then they file the complaint under section 44 of the PMLA. Because complaint is virtually a charge sheet, my lords. Equivalence would be a charge sheet because it is post investigation. That has now been filed, my lords. But that has been filed, I will point it out as a ground, my lords. That has been filed not insofar as the whole scam is concerned. They have restricted that complaint only to the petitioner. Whether it is going to be a complete complaint or a partial complaint, my lords, may have to be looked into. Because the Supreme Court would say, my lords, if you are trying to file a charge sheet only for the purpose of denying a person his right of statutory bail, if it is incomplete, it is bad. In our case, my lords, the present complaint, they reserve their liberty to file supplementary complaints, and this whole complaint is devoted only insofar as the petitioner is concerned. And added to it, my lords, and added to it, this complaint filed, they filed it on the 61st day, my lords. 60 days, immediately thereafter they filed it, and the office makes a note that it is incomplete in some aspects of it for them to comply with. After that, they have not even complied with it. So can we consider this to be a complaint filed within the statutory period of 60 days? Otherwise, my lords, he'd have come out on statutory bail. Offense is punishable with 7 years. So that aspect I will point out, my lords, because Supreme Court has deprecated this practice where CBI, my lords, in a given case, they filed a charge sheet against certain accused, my lords. And in the charge sheet, they would show one person to be a charge sheet witness. Then they continue doing supplementary or additional investigation. And in one of the additional investigations done, my lords, they would make this person who was a charge sheet witness as an accused, arrest him. After his arrest, my lords, they would file a supplementary charge sheet just to ensure he is denied statutory bail. When this matter went up to Supreme Court came down heavily, my lords. They deprecated this practice of doing this just to deny a person of statutory bail. And when Supreme Court, that SFP, my lords, allowed it and granted him statutory bail, a review was filed, review was dismissed. So, my lords, if my lords would have paragraph 19 at page 59, this is the main allegation that this private individual had in this PCR. This being the case, my lords would get paragraph. This being the case, once again, when A1 became the Chief Minister of Karnataka in 2013, the attempt to grab the MUDA sites regained momentum, and acting accordingly to illegal plan, accused number 2 Parvati from 2014 onwards started to make representations to MUDA requesting allotment of compulsory sites for alleged using the land in survey number so and so. Copies of the representation made by accused number 2 is annexed to this complaint and marked as document number 20. Could I just pause here, my lords? So far as accused number 2 is concerned, Parvati, when she would receive the summons from ED, my lords, we had challenged it in a 482 petition. We were successful in the challenge. So the ED would take it up to the Supreme Court. SLP is dismissed. Then, my lords, paragraph 20. Further, on 14/7/2021, Shri Natesh DB, the ex-commissioner of MUDA, writes to the government of Karnataka seeking direction and clarification for allotment of compulsory land in view of the resolution passed by MUDA on 15/12/2017 and 30/12/2017. Copy of the communication is document 21. I would pause here, my lords. So far as Natesh is concerned, he filed a writ petition under 226. He was successful in the writ petition. Writ appeal has been filed. In writ appeal, the interim order is investigation can go on. There is no stay of the order passed of quashment, my lords. And my lords, as I pointed out, using Natasha's judgment, my lords, the order was passed in Parvati's judgment and Bhairati Suresh's judgment, my lords. And that Supreme Court has dismissed their SLP. So here the appeal which is pending, my lords, subject to, we will have to produce the order of the Supreme Court saying it has been upheld. Because if that is what has been relied in the ruling, so first, as I pointed out, Natasha's judgment, my lords, their appeal is filed. Then comes Parvati's judgment, which relies on Natasha's judgment. Parvati's judgment goes up to the Supreme Court. Supreme Court dismisses the SLP. Then, my lords, page 60 onwards, the complaint continues insofar as the four named persons are concerned. Then, my lords, the general allegation that is made against the MUDA officials, my lords should get that at page 65, paragraph 52. Similar illegal allotments are being done by MUDA officials and other political and influential persons, thereby causing loss to the tune of more than 5,000 crores to the state exchequer due to so and so. The above mentioned persons have illegally allotted thousands of sites, having received huge kickback. These illegal acts and corruption has gone into the root of MUDA since year 1990. Hence, detailed investigation and inquiry into the case is necessary. This is the allegation that we get, my lords, as against the MUDA officials. My lords, on the basis of this private complaint, on 27/9/2024, I'm sorry, my lords, on 25/9/2024, matter was directed for investigation by powers under 156(3), my lords. 25/9, list of dates only, 7th one.
I just wanted to reach.
Yeah, yeah. List of dates, 7th, 25/9. So on the same day when the complaint was filed, referred under 156(3), and my lords, on 27/9/2024, the registration of FIR in crime number 11 of 2024.
Crime number?
Crime number 11 of 2024. Against 4 named persons and unknown others. Now, my lords, in the span of 4 days, my lords, after the registration of this FIR, 2 important events take place. My lords may notice the next date, 1/10/2024. 1/10/2024. That's serial number 9. 14 sites owned by accused number 2 were surrendered. Serial number 9, my lords, I think it's the bottom 110, were surrendered and accepted by the government. So the bulk of the allegation on 14 sites, my lords, returned back. Then, on the same day, my lords, the ED registers ECIR 25 of 2024. In a span of 4 days, when the predicate offense FIR is registered, ED steps in. And my lords, in the scheme of the act, my lords, as I was trying to point out, some leeway for an investigation to take place on a schedule offense before you even say, yes, there is a schedule offense, yes, there's proceeds of crime, yes, there's a case of process and activity, and it amounts to laundering. Within 4 days, ED steps in, ED registers the CCIR. Then, my lords, 18/10/2024 to 20/10/2024, the Director of Enforcement conducts search and seizure of the office of MUDA. Some digital devices and documents were seized. That's in the office in MUDA, my lords. Then, 25/10, they record the statement of one Prashant Raju, who is the personal assistant of the petitioner. Thereafter, my lords, please notice serial number 12. because just to ascertain at the time of my arrest, what is it that you had against me? 28/10/2024, the respondent director of enforcement conducted search and seizure under section 17 in the house of the petitioner. The search was started and concluded on 29. They found only PAN card, Aadhaar card, loose sheets, handwritten loose sheets, PAN card of Satish, who's another person, Aadhaar card of Satish, vehicle insurance copy. Well, it's normally when we do a search and seizure under 17 is to ensure this proceeds of the crime that we can go and seek attachment of. Now, this was what was done on 28/10/2024, my lords. Then on 28/10/2024, the next one at serial number 13, director conducted search and seizure under 17 in the house of the father-in-law, brother-in-law of the petitioner. 2 panchanamas were drawn. Nothing that was seized there, my lords. So, my lords, under 17, they would get nothing against me. Then they would summon me. The summoning takes place at serial number 14, 9/11/2024. I was summoned. My statements was recorded by them. Then, my lords, after that, 30/11 is so far as Muda's resolution being cancelled by the government. Then, my lords, stay of that cancellation we get at 12/12, that is in so far as those resolutions are concerned. And my lords, may I point out this 12/12/2024, we have pointed out Honorable High Court stayed the government's cancellation order dated 30/11/2024 and 12/12/2024. This, my lords, now the writ petition is dismissed, my lords. It was dismissed on 13th November 2025, recently. It serial number 16, my lords.
Who had filed that?
Yeah, the
Petition
petition
filed by?
there, huh?
No, filed by the?
That members, my lords, members of one society called Chamundeshwari, my lords. They filed it. There was a stay, but on 13th, my lords, the writ is dismissed. Factually, my lords, that may just have to be added there that the writ is dismissed. Then, my lords, 27/1, 18, my lords may come to 27/1/2025, Natasha versus Directorate of Enforcement. The Honorable High Court quashed the summons issued under Section 50 and the search and seizure conducted in his residence as well. Now, this order, my lords may kindly notice. Where do I have that? Petitions.
I think it's in the all other ones.
I'll get it. It's in our citations number 2. Just few paragraphs I'll show in Natasha's, few paragraphs in Srimati Parvati's, my lords, just to get us an understanding of the quashments also in this case. You have that? Separate, no? Yes. For the court. Give to the court. No? Where is this?
In the trial court one.
Natasha, yeah. Can you just pass it to the court? Well, this is 27 January 2025. Well, we put the compilation. In this compilation, my lords, the order of Natasha's, the writ appeal order, my lords, which is pending consideration, the order of Srimati Parvati's, the order insofar as Bhairati Suresh, the SLP's dismissal, and the orders, my lords, where the provisional attachment, about 11 orders which are stayed and pending before this honorable court, they've all been put together in this compilation, my lords. So if my lords would have the first of the judgment, Natesha. My lords, we stressed on the aspect of reasons to believe which is necessary before you do a search and seizure, which my lords would get at 6.3. Give the page numbers. And after that, my lords, the judgments of right from Vijay Madanlal Chowdhury onwards, because that would be the lead case, my lords, which we relied on. The court, upon these arguments, the issues which the court has framed is paragraph 8, my lords. My lords should get that at page 13. It's correct. No, it's matching with the court settlement. What's this? After considering the arguments of the learned counsels for the parties, the following issues emerge for consideration. Whether the authorization issued to conduct the impugned search and seizure at the residence of the petitioner on 2810 and 2910 and the consequent statement recorded under section 17 of PMLA suffers from lack of jurisdiction. My lords, this is answered in the negative because the court holds that there was power and jurisdiction. First point. Second, whether the said impugned search and seizure and the statements recorded is bad in law for lack of the requisite reasons to believe under section 17(1) of PMLA and therefore an abuse of process of law. Answered in favor of the petitioner, my lords. Third, whether impugned summons notice issued under section 50 and various statements recorded thereunder be sustained under the law. Again answered in favor of the petitioner. And the last aspect, whether in the course of its administration and execution of PMLA, the attachment of property under section 5 must mandatorily precede the conduct of search and seizure under 17 of the said act held against the petitioner. My lords, one of the contentions we said was, if you want to do a search and seizure, you must start by having an attachment under section 5 and only then comes search and seizure. But court would hold, no, it need not be so. At times it can be that you can have search and seizure and then the attachment under 5. Page. No, it's Vijay Madanlal. Yeah, I pointed it out. The one that straight away can go. My lords, issue number 2 at page 25, my lords. Reasons to believe, paragraph 22 onwards. My lords, the court would consider Vijay Madanlal's case, Senthil Balaji's case, Pankaj Bansal, Opto Circuit, Arvind Kejriwal's case, and my lords may notice at page 29, 24.5.3. This is where my lords reasons to believe exceeds mere suspicion or doubt and is distinct from knowledge. My lords gets that one portion. Jyoti Prasad versus State of Haryana. And the next judgment also, my lords, A.S. Krishnan, 2004-11 SEC. Again, they deal with that reasons to believe. Chain of probable reasoning based on the circumstances leading to a conclusion or inference about the matter. Then, my lords, page 35, paragraph 25. Page 35, paragraph 25, my lords. Similarly, in the present case, the alleged predicate offence pertains to illegal allotment of sites during the petitioner's tenure as a commissioner of MUDA. However, there is no evidence to demonstrate that any consideration passed in relation to the conveyances or relinquishment of such sites was received by the petitioner. Consequently, the petitioner cannot be attributed any role in possessing, concealing, or using the proceeds of crime to constitute an offence under Section 3 of PMLA Act. My lords, paragraph at page 36, paragraph 29, my lords, again, reasons to believe.
So he's the predecessor of the petition.
Yes, my lords. Allegation against him is about 400 sites he had given. At that point of time, my lords, number of sites they were showing was 1,109 sites. So about 400 during Natesha's period and the remaining during the period of Dinesh Kumar is now how the case is built. Not on the basis of what is in the PCR filed by him, my lords, but subsequently their investigation. My lords, just page 36, paragraph 29, again, my lords, no, when we talk about reasons to believe, my lords, it's not merely on suspicion. Again, the court would find that, my lords. Paragraph 29. My lords may notice page 38, paragraph 34. It is now well settled that reasons to believe must exist on the basis of evidence regarding the existence of certain facts. I'm sorry, I'm at 34, my lords. In the instant case, no such material as was in possession at the time of search has been furnished to this court to probabilize the purported involvement of the petitioner. In absence of the same, any conclusion arrived at necessitating the search does not satisfy the threshold of reasons to believe as envisaged under the PMLA and is therefore no more than a mere suspicion of involvement in the offence under the Act. Thus, this court is of the opinion that the impugned search and seizure conducted at the residence of the petitioner was unwarranted based on unfounded suspicion and is therefore an abuse of process of law. Then, my lords, the third point again, which was answered in favor of the petitioner on section 50 being summoned, because he was repeatedly being summoned, my lords, that was pointed out. And what the court would finally hold there at paragraph 54, page 49, my lords. Paragraph 54, page 49. They'd say they ought not to have kept summoning him in this manner. My lords, issue number 4 was against the petitioner, my lords. The section 5 vis-a-vis section 17. And my lords, on the enforcement directorate, my lords, on how they would function, paragraph 58 at page 51. It is opposite at this stage to observe that the Enforcement Directorate is a premier investigating agency established for the purpose of preventing the serious offense of money laundering and confiscation of the proceeds of crime, and that it is expected to discharge its duty with fairness. The right to liberty and privacy under 21 of the Constitution vests a right against the conduct of arbitrary searches, and therefore the search conducted on the premises of the petitioner under the garb of investigation, where there is no prima facie evidence to establish the offence under section 3, is but an abuse of process of law. The Enforcement Directorate cannot give the elements of procedural fairness contained in the PMLA a go-by in the course of its administration. It's pertinent that the right of liberty and privacy of individuals cannot be trampled upon, and that any curtailment of civil liberties is subject to the due process of law. Accordingly, I order the following. Petition allowed. Impugned searches are hereby declared invalid and illegal. Statement recorded to be is ordered to be retracted. Impugned summons quashed. And 5, my lords, one liberty that was given That, my lords, on appeal, we ourselves submitted, my lords, we don't intend taking any action because, my lords, under section 62 of PMLA, if it is going to be a vexatious search, then the officer conducting the search can be prosecuted, my lords. He can be proceeded against. So this liberty was given, but when the appeal was filed, my lords, when it was brought to our notice, is there a need for this? It was submitted that we don't intend doing anything insofar as this liberty is concerned. My lords, after this is the order. Show me this appeal. My lords, the appeal order against this, my lords should get it at page 54. Although, my lords, the court did not stay the order of the learned single judge, what the court would do is, my lords, page 80, paragraph 6. Could I read this, my lords? All investigation under PML Act are needed to be permitted to be carried on in accordance with law, notwithstanding the directions in the operative order of the learned single judge impugned in the appeal. The applicant investigating agency is therefore entitled to proceed to carry on investigation in respect of other persons or accused in accordance with law. With the observation, clarification, providence and directions as above, the present application stand disposed. This was on 2/4/2025, my lords. This order, my lords, you see, notice it at page 54. Meanwhile, my lords, the other two matters pertaining to Srimati Parvati and pertaining to Bhairati Suresh, who had received summons from the ED, the challenge was under a 482 petitions, my lords. The order passed in that, my lords, would get at page 81, 7th March 2025. My lords may notice paragraph 5, my lords, page 85. So it's for the petitioner who take this court through the documents appended to the petition and seek to demonstrate that the action of the respondent enforcement directorate is laced with malefides as ECIR comes to be registered within 4 days of registration of crime in crime number 11 of 2024. Even before determining in crime number 11 of 2024, where the petitioner along with others are alleged of guilt of offences, the guilty of offences, he would mean the filing of charge sheet in the predicate offence soon after registration of the crime in which the petitioner was named as accused number 2. The petitioner, who is the recipient of 14 sites in the hands of Muda, surrendered these sites, and surrendering is accepted. Deed of cancellation of allotment is executed. On the same day springs the impugned ECIR. Then, my lords, please notice page 89, paragraph 9, the issue that falls for consideration. I have given my anxious consideration to the submissions made by the respective learned councils and have perused the materials on record, in furtherance whereof issue that falls for consideration, whether the petitioner should be permitted to be investigated into on the impugned ECIR. Then paragraph 10, the court notices, my lords, 27(9) was the FIR, 110 was the ECIR. Then the cancellation is pointed out. Thereafter, my lords,
Page 96.
what is it? Page 96, my lords, 110, what took place is again reiterated in 4 days' time, ECIR being registered. And then the court at
Page 108.
page 108, my lords.
Internal page 28.
The extraction of the order of the one that go into extraction of the order of the coordinate page. I'm sorry, my lords. If my lords would have page 127, 127, the court then, my lords, would go into the coordinate bench's order in Natasha's case. 127, right at the bottom, the coordinate bench, my lords would get that portion, in Dr. Natasha versus Directorate of Enforcement has held as follows. Then the entire extraction that we get from paragraph 8 of Natasha's case, my lords. Next page onwards. That goes till page 138, my lords. And 138, my lords would get it, 138, second paragraph. The coordinate bench holds that for an offence under section 3 of the Act, there should be possession, concealment, enjoyment, and usage of the proceeds of crime, be it property or funds. Issue number 3 quoted supra is answered by the coordinate bench in favor of the petitioner. The coordinate bench holds that when there is no prima facie case established showing that an offence has been committed under the Act and no incriminating materials have been elicited at the time of search and seizure, issuance of summons would lack legal authority, and it was observed that the petitioner could not be compelled to appear and give statement, as that would infringe upon the personal right and liberty of that petitioner. Then page 139, paragraph 17, my lords. As observed herein above, section 3 has certain ingredients to be present. It should be concealment, possession, acquisition, and usage of property which is allegedly proceeds of crime. What is proceeds of crime in the case at hand is cites granted in lieu of compensation. The compensation is granted under respective enactments. Whether the petitioner or other accused are guilty of these offences is being investigated into by the Lokaयुक्त police pursuant to registration of a crime in crime number 11 of 2024. The facts as on the date of registration of ECIR is that the petitioner is not in possession, enjoyment, and usage of sites that were allotted to her, as they have been surrendered and cancellation of allotment has happened. Therefore, there is no laundering in the case at hand. In the case at hand, the alleged proceeds of crime are referable to allotment of sites. The coordinate bench in the case of Natasha Supra holds in 2 of its paragraphs that allotment of sites cannot become proceeds of crime. The coordinate bench has held as follows. Then, my lords, page 141. In the light of the findings rendered by the coordinate bench, as also different high courts interpreting what would be proceeds of crime, who would be guilty of proceeds of crime, the case at hand neither projects the petitioner being in possession, enjoyment, and usage of proceeds of crime. And finally, my lords, page 144 is the order. Criminal petition is allowed. Enforcement case information report in 25 of 2024 stands quashed. All consequential actions, including summons pursuant to ECIR, are also obliterated. 144. Now, this was taken up by the ED. I'm sorry, my lords. Before that, page 145, the other connected matter similar order which was passed. My lords would notice at page 145, B.S. Suresha.
The court holds that the sites cannot constitute proceeds of
Yes,
crime.
my lords. Allotment of sites cannot be constituted as proceeds of crime. And the court notices, my lords, that's under investigation. My lords, as I pointed out, that is for the Lokaयुक्त police to unearth whether that allotment of sites is illegal or not. ED doesn't come into the picture there. ED will come into the picture, my lords, after it is established by the Lokaयुक्त police, yes, indeed, those were illegal allotments. That illegal allotments, the proceeds of crime were generated. Then ED will have to look, this proceeds of crime, did they do an activity or process? If they've done an activity and process, that is the starting point of jurisdiction. So, my lords, on the very same day, the other order which is passed, my lords, gets at page 145. runs on similar lines and quashment that takes place of the ECIR insofar as the concerned petitioner is there. my lords. Now, both these orders were taken up to the Supreme Court. My lords, page 171. Page 171. The order of the Supreme Court, my lords, delay condoned. In the peculiar facts and circumstances, we do not find any error with the reasoning given by the learned single judge of the High Court in these cases. The special leave petitions are accordingly dismissed. Pending applications are disposed of. Now, this is what we get as a written order, my lords. There were a few observations made orally by the court at that point of time, my lords, on the functioning of the ED. That was widely published, my lords, of what transpired orally. And then would thank the ASG to say that, good, you have prevented us from passing something more drastic than what we are passing in the orders. So with that, my lords, finality insofar as those petitions. Now, what is remaining is the appeal here, my lords. Probably when it comes up, we may have to fall back on how the Supreme Court has dismissed the SLP. Now, my lords, in the same compilation, which that's next to the insofar as 11 stays, isn't that only? No? My lords, after that, the stay orders that have been granted by this honorable court, insofar as the provisional attachments are concerned, my lords would get that from page, this is page number 172 onwards, my lords. In some of these orders, my lords, we find orders of stay, and in some no coercive steps. In fact, my lords also had some occasions to deal with these provisional attachments. So this is the status insofar as remaining is concerned, my lords. Unfortunately, my lords, when all this was happening, petitioners still kept cooperating with the ED. They issued summons, I was appearing. Now, please look at the sequence of events, my lords. Probably if the petitioner also had come before this court, he might have been in a position to satisfy the court that this is not a case where ED could have had these proceedings on. But he did not. So whenever he was summoned, he went before the ED. Now, in the sequence of events, just notice after that what has happened, my lords. I'll quickly just point that out. How he participated. My lords, it serial number 19, 12 to 2025. My lords, gets 12 to 2025. The Lokayak police filed B report in crime number 11. And my lords, when they filed that B report, it is not in entirety, my lords. It was in so far as the 4 named persons therein are concerned, where they reserved their liberty to investigate further insofar as the Muda scam is concerned. So, my lords, and seeking permission to submit supplementary report under 173(8) of the CRPC. And even to this date, my lords, that investigation is going on. Then, my lords, 20 to 2025, those are those orders of stays and not to take coercive steps that are passed by this honorable court. And I can straight away skip the next sequence, my lords, which are all quashments, which I've all pointed out, my lords, the appeals, quashment, SLP. I'll skip out that whole sequence. Please then notice, my lords, 16/9/2025, 32. Avut summons bandilla. we have wrongly mentioned a summons. ಮಾಡಿದ್ದಾರಾ ಯಾವ್ದ್ರಲ್ಲಿ? So my lords, this 16/9/2025, after about 9-10 months, my lords, after I had been summoned, and after in my search and seizure they would find nothing. 16/9, my lords, after about 8-9 months, they issue summons under section 50, record statements of the petitioner, and he is arrested on that day. And the only person to be arrested. Though, my lords, physically they did not give us a copy of 50, but in the remand application, they make a mention that 50 summons was given and they conducted a search and seizure. Search and seizure, they did not get anything incriminating which could be called proceeds of the crime again. For such of the persons who you found that provisional attachments is necessary and you have done, you don't choose to proceed against them in any arrest. My superiors, you don't choose to do anything. The persons who are actually named in the main complaint, my lords, you don't choose to do anything. I am singled out. Why? I cooperated with you. Every time you issued a summons in 2024, I came there. You conducted 3 searches in 2024. Then suddenly on 16/9, you feel again you're summoning me and you cause my arrest. Okay. My lords, on that day, on 16/9, according to the search and seizure, my lords, they have got loose sheets, page numbers 1 to 75, and then they say a Nokia black colored mobile phone belonging to the petitioner. My lords, I was given to police custody or to the custody of the ED for about 9 days, and thereafter I was sent to JC. We preferred this bail application. In the bail application, my lords, 2 main contentions that we took. One contention we took is the mandate of DK Basu had not been followed at the time of arrest, making the arrest illegal. More specifically, my lords, in DK Basu, there are 11 guidelines given. We pointed out guideline number 7, which is an inspection memo, had not been submitted at the time of arrest. So our contention is arrest itself becomes illegal. On the merits, my lords, the 4 contentions taken was there a necessity for an arrest? Number 1. Is the arrest justified in view of section 19 of PMLA? The third aspect, is the arrest done legally? Because of DK Basu, my lords, third aspect, is the arrest done legally? Is further incarceration of the petitioner necessary considering the facts of the case? One additional point which my lords for consideration now, which I'm going to be submitting, is investigation complaint file. Is a complaint an incomplete complaint for the purpose of denying statutory bail? Is the complaint an incomplete complaint for the purpose of denying statutory bail? My lords, the first point, was there a necessity of arrest? First point, my lords.
So while seeking bail,
yes,
the procedure of arrest is also a ground.
Yes, my lords. Then it makes it illegal. My lords, whether it is going to be DK Basu's 11-point guideline, my lords. The lead cases, my lords, as I understand, is DK Basu, Arnesh Kumar. That will be the second lead case, my lords. After that comes the grounds of arrest. Now, in ground of arrest, my lords, we have Pankaj Bansal, Prabir Purkayastra, Vihan Kumar, and the latest ruling, my lords, which is in Mihir Rajesh Shah. So in all these cases, they say, one is if the guidelines in DK Basu is not complied with, I will point out which 11 guidelines are, then the arrest becomes illegal. He can't be kept inside even for a minute after that, if it is an illegal arrest. Similarly, my lords, so far as grounds of arrest, if it has not been given to either him and his relatives, in one of the cases, Vihan, my lords, concurring judgment said even to the relatives, then it makes the arrest illegal. And if arrest is illegal, he immediately has to be left. Well, it's the first point which was there a necessity of arrest? First point, my lords. My lords, first search and seizure the first search and seizure takes place on 28/10/2024. My lords, his arrest was 16/9/25. The first search and seizure 28/10/2024. My lords, annexure B1, page 464, just as a reference, my lords, so that no incriminating material seized. The B1, no? B1 or V1? I'm sorry, it is V1, not B1, my lords. V1, page 464. No incriminating materials seized. Same day, my lords, 28/10/2024, when search and seizure is done at the premises of my father-in-law and brother-in-law, no incriminating material seized. 28/10/2024. Nine 11/2024, I am summoned under section 50 and my statement is recorded. 9/11/2024, petitioner's statement recorded, annexure C, page 75 and 76. In 9/2025, the search and seizure that is again conducted, where, as I pointed out, no incriminating circumstances against me, no incriminating materials. After 10 months,
This is once again.
Please. Again, yes, my lords. 16/9/2025. Show me again that what was seized. 16/9/2025, page 483. Again, a search and seizure at my house, where at 487, all that they get is loose sheets, page numbers 1 to 75, and one Nokia black color mobile phone. Well, is this material sufficient for the purpose of causing arrest by exercising powers under 90? So the necessity to arrest, when I'm cooperating, my statements recorded, you have done whatever search and seizures that you have wanted to do, and you don't find anything against me as on 16/9/2025, was there a necessity for you to cause an arrest? And you were fully participant of all the quashments that have taken place, stays that have happened here, and you have attached in so far as 250 provisional attachments of others. Was there a necessity, my lords, for this arrest to take place? Why was he only singled out? So the second aspect is, my lords, is the arrest justified in view of section 19 of the act? My lords, I will not trouble my lords, my lords. Two important aspects there. They should have had reasons to believe, and they should have been convinced I'm guilty of the offense. My lords, reasons to believe, already in my predecessor, this honorable court held there was no reasons to believe. And to have a prima facie view that I'm guilty of an offense, my lords, all that they've got till 16/9 is what I have pointed out. My statement, 4 search and seizures, 2 at my place, 1 at my father-in-law, 1 at my brother-in-law's place.
No incriminatory material.
No incriminating materials in the search and seizures that were done. And most important, my lords, I may say there is no provisional attachment under 5 of any of my properties. So, my lords, the twin requirement under section 19 to cause my arrest would be lacking, my lords. The twin requirement. The next point is, my lords, is my arrest valid? This is where DK Basu that I'm relying on, my lords. Not yes. To go back, you give to the.
Yes, we have that. This is DK Basu.
All yes. Have I marked it?
Yes, everything is marked.
Now let's kindly notice, my lords, the index itself. Non-compliance of guidelines issued by the Honorable Apex Court regarding arrest and custody. We made a note, my lords, I'll just point that out. 2. Table on compliance of guidelines issued by the Honorable Apex Court in DK Basu's case regarding arrest and custody. Now the judgments, my lords, is DK Basu, Arnesh, Purshottama is not of great application. Then B may be noticed, my lords. DK Basu guidelines applicable to ED. There are 2 cases that point out that they're applicable, both from Calcutta. Then the rigors of section 45, twin condition, not a bar to grant of bail. My lords, 2 decisions of one of Supreme Court and one of our court, my lords. Then arrest based on mere non-cooperation in investigation or evasive reply not permissible. Judgments between 8 to 13. Now, my lords may have the first page, non-compliance. Just a small note, my lords, there. First page. When an arrest is made, irrespective of on a warrant or without a warrant, there are certain guidelines to be followed to effect the arrest. The requirements to be fulfilled while making an arrest are as follows. A checklist is to be provided in compliance of section 41B of the CRPC, which is equivalent to section 36 of BNSS and in compliance with guidelines issued in DK Basu and Arnesh Kumar. Second, arrest intimation to be provided in compliance of section 50 capital A of CRPC equivalent to section 48 of BNSS and clause 5 of DK Basu. 3. Arrest memo in compliance of section 50A of CRPC equivalent to 48 of BNSS and clause 2 of DK Basu. 4. An inspection memo to be prepared and signed by both arrestee and police officer affecting the arrest in compliance with 50A, which is equivalent to 48 of BNSS and clause 7 of DK Basu. This is what is not given. And my lords, this is what in my respectful submission has not been given in our case. 4, what my lords gets at 4. 5. Checklist under section 41B2, memorandum of arrest equivalent to section 36B to be prepared in compliance of Arnesh Kumar versus State. Non-compliance of any of the requirement while making an arrest would necessarily make the arrest illegal. In the present case at hand, it is pertinent to note that the Respondent Enforcement Directorate has flouted in compliance with the guidelines issued by the Honorable Apex Court in the case of DK Basu while arresting the petitioner. The 11 mandatory requirements enumerated in the judgment with regard to arrest or detention has not been followed. What is paragraph 35 of DK Basu we have extracted, my lords. That's where we get the 11 guidelines. Which one is ours? My lords may notice.
We'll continue
Please,
tomorrow.
please.
Arguments remain inconclusive. Release tomorrow.
Submission also same. Result.
Lokesh.
Oblige.
Sorry, Lord, I'm holding you, Lords. Lords, I'll keep the matter in short, my Lord. Lord, the petition schedule property is subjected to the land acquisition proceedings since 2007 for peripheral ring road project by PMLA. Lord, the 8th respondent, who is a private respondent, in the month of September 2024 goes before a non-jurisdictional sub-registrar. The property comes under Rajaji Nagara registration district, my Lord, and Madnagnalli sub-district. He goes to Gandhi Nagara district registrar's jurisdiction, where in Ganganagar, produces an unregistered GPA and obtains a sale deed. He only executes the sale deed in his own favor. And my Lord, Tahsildar does not act on it because there is a conspicuous entry in the RTC that land is acquired. My Lord, per se, Karnataka Land Restriction on Transfer Act, which says that any land transfer by way of gift or mortgage or sale should be done with the prior permission. And Section 8 of the said Act says that any such instrument should not be registered. So Tahsildar does not act on it. He directly goes before the AC, and AC, just for asking, gives an order without even issuing notice to Tahsildar, without making me a party. And my Lord, my first contention is that, my Lord, Tahsildar only gets a jurisdiction to sit on appeal only when there is an order under 129(4). That comes when the dispute is raised before Tahsildar and Tahsildar passes an order. Second is there is a certified mutation entry. Certified mutation entry for on that point of time, my Lord, was nothing but the original owner's mutation. There was no mutation after that. So without those two, the AC will not get the jurisdiction, is my contention, first contention, my Lord, and the subsequent contentions are with respect to the sale and registration of the sale deed. My Lord, may kindly take page number 33, my Lord, of my petition. In column number 11 of the RTC, Lord, this is the Jayama Komunyapa, 1 acre 25 gunta. It is my property, Lord. This is the petitioner. In column number 11, it is said that number so and so ante BDA peripheral ring road ಯೋಜನೆಗೆ 1 ಎಕರೆ 30 ಗುಂಟೆ ಭೂಸ್ವಾಧೀನ ಪಡೆಯಲಾಗಿದೆ. The entire property in survey number 11/1A is about 2 acre 5 guntas. My property is to 1 acre 25 gunta.
No, now
Please.
there was a notification on 9/6/2007.
Yes, my lord. And it is still, PRR is not yet come to an end, my lord. They have not even started, they have started from, there was a news, my lord, from last year that they are going to start the project.
After the 4/1 notification, there's a bar.
Please, my lord. Under this, it is 17/1.
Huh?
17/1 under the BDA.
After 17/1, there's a bar.
Please, my lord. 19/1 is issued. My lord, I have produced the 19/1 also for my lord's consideration, which is at annexure E, page 36. My property can be found at page 41, entry 10.
19 is the final notification.
Please, my lords, that the declaration that the land is required, and what follows is the compensation. They have to determine the compensation and take further action.
After 19, this sale deed is executed.
Please, my lord, that is in last year 2024. They have which he himself has got the sale deed.
19 is in which year?
2007.
Now, what is the AC done?
Lord, kindly take the AC order, Lord. The impugned order is at annexure A, page number 26. 2 pages order, Lord. Lord, AC, if there was an order to appeal, he gets a jurisdiction, Lord. There is nothing as such. He directly approaches the AC, and Tashildar is made a party. No notice to Tashildar at least is issued. May I read, my lord? From page number 2 is what is appropriate, my lord. Other than the Prakaranada Kadadal Labhyada, he says that sale deed.
Just one minute.
Please.
You are not made a party.
No, my lord, this is all done only to take away my compensation.
The petitioner submits that the assistant commissioner, without making the petitioner as a party, though mutation as on the date of the order of the AC stood in the name of the petitioner,
Please.
has passed an order in violation of principles of natural justice. Full stop. It's further submitted that the section 17 and 19 and section 19 notification by the BDA having been in force, the property could not have been dealt with by private properties, and accordingly the assistant commissioner ought not to have entertained request for making revenue entry when the details of the acquisition notifications were found in column 11 of the RTC. In light of the contentions raised, there would be stay of the order at annexure A.
And B. The mutation is at B. Mutation is at B.
And the mutation entry at annexure B. AGS directed to...
My lord, BDA need not disperse compensation. All this is done to take away my compensation, that's all.
In the interregnum, as a consequential order, respondent BDA is restrained from dispersing compensation. AGA accepts notice for 1 to 3, K. Krishna for 4 and 4. AGA for 5, 6, 7. Emergent notice to 8.
My lord, compensation to 8, it may be signaled. Restraining the BDA from dispersing the compensation to respondent number 8, it is not there.
Disperse compensation to R8.
Objections, sir.
Who, sir?
ಮಾಡ್ತೀನಿ
ಆಮೇಲೆ ಮಾಡ್ತೀನಿ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀನಿ.
ಮರಿಬೇಡಿ.
ಹಾ ಮಾಡಿ. ಅಲ್ಲಿ ನೀವು ವಾಪಸ್ ಎಲ್ಲಿ ಕಳಿಸ್ತೀರಾ ಇದನ್ನು?
ಸ್ಕೂಟನಿ ಕಳಿಸ್ಬಿಡ್ತೀವಿ, ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ ನಾಳೆ.
ಆಯ್ತು.
ಸ್ಕೂಟನಿ ಪೆಂಡಿಂಗ್ ಹೋಗುತ್ತೆ, ನಾಳೆ ಮಾಡಿ.
ಆಯ್ತು.
ಸರ್
ಹೇಳಿ ಸರ್.
ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 51 ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರ ಪ್ರೆಸ್ ಮಾಡ್ಬೇಕು. 51 ಏನಾಯ್ತು ಮೈನ್ ಮೇಲೆ ತಗೊಂತೀವಿ ಅಂತ
5181
ಸರ್ ಶಾರ್ಟೆಡ್
ಎಲ್ಲ ಬರ್ದಾಕ್ಬಿಟ್ಟಿದೆ. ಬರ್ದು
ಯಾಕಂದ್ರೆ ಸ್ಟೇ ಬೇರೆ ಇಲ್ಲ.
ಯಾಕಂದ್ರೆ ಎಲ್ಲರಿಗೂ ಅದೇ ಮಾಡಿದೆ.
ಇಲ್ಲ ಸ್ಟೇ ಬೇರೆ ಇಲ್ಲ.
ಒಂದು ಮೆಮೊ ಕೊಟ್ಬಿಡಿ.
ಮೆಮೊ ಬೆಳಗ್ಗೆ ಕೊಡ್ಲ? ಸ್ಟೇ ಇಲ್ಲ ಅದರಲ್ಲಿ ಅದಕ್ಕೆ.
ಅದೇ ಒಂದು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನಮ್ಗೆ
ಅಲ್ಲ ಇವಾಗ ಕೊಟ್ರ?
ಎಲ್ಲಾರ್ದು ಅಷ್ಟೇ ಇಲ್ಲ, ಡೇಟ್ ಎಲ್ಲಾರ್ಗೂ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇವಾಗ ಕೊಟ್ಟಿದ್ದ?
ನೋಡಿ ಎಲ್ಲ ಆರ್ಡರ್ ಇದೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಅಲ್ಲ